I'll just announce it now. Okay, colleagues, the time now is 8:30. I think we should get seated and be ready to start. Today we're going to start with Ms. Cheryl Narunski. Is she here? And she will be followed by Mr. Kyle Drescher. Is he here? Yes? Yes, very well. And then he will be, and thereafter will be the Council for Medical Schemes. Are they here? Yes? Very well. And then thereafter we will hear from the Allied Health Professions Council of South Africa. Are they here? Yeah? I mean, could someone make sure that they will be here at some point? Yes. And thereafter we will hear from Professor, I don't know how to pronounce this, Appelstadt? Is that how? Is he here, the professor? No? And then we'll hear the National Hospital Network. Are they here? Yes? Very well. Very well, Ms. Narunski, is that how you pronounce your name? Yes. Previously, you have made you've given us a document, yes, which would form the basis of your oral presentation.
That's right.
And then yesterday evening, I received a further document which is supposed to come from you, which is dated the 9th of March. Is this the same document as the one that you have previously?
We made some amendments to the document.
I see, okay, I see. So what, and the one with the latest amendment, when did you file that?
That was the day before yesterday, so that would have been probably what you received yesterday.
Would that have been on Monday?
Yes.
Okay, I've lost track of the days.
Me too, as you notice.
Yes, that's very well. So I suppose what we then need to do is to replace what we have on file with the latest one that you have.
Yes, please.
Yes.
In addition to that, if
Yeah.
I may just mention, this is my daughter, Jessica McCarthy, who will be testifying with me.
Yes.
As you've seen, we divided our document into chapters. Jessica's chapter is chapter 8.
That's right, yes.
She's made a small amendment to that, and we've handed that in today so that the panel can switch their chapter 8 with the new one. It's just got 2 extra sentences in it.
Okay. Okay. All right. I think for the purposes of managing this is what we will then do. We will enter for the record your submission for oral presentation, which is dated the 9th of March 2016 as Annexure CN1.
Thank you.
And then we will then enter the additional input of Chapter 8 by Jessica McCarthy as JM1.
Thank you.
Very well. Well, good morning.
Good morning.
How are you this morning?
A little nervous, but good, thank you.
Relax then.
I'll try as I go.
And drink more water. Yes. Okay. Perhaps just to set your mind at rest, let me just explain why. What's the purpose of this inquiry. I mean, as you are aware, we are looking into competition in the private healthcare sector. And one of the issues that we will have to look at is how accessible are health services within the health sector. Do consumers have access to information that's crucial for them to make an informed decision as to the type of treatment that they require? And what we thought we would do during this initial phase of the public hearing is just to get to understand how various stakeholders within the sector interact with one another. That is, how do consumers interact with service providers such as your doctor, your specialist, interaction between the consumer and the medical schemes, the administrators, the government, etc. Now, you can assume we have carefully read your presentation, which really focuses on your interaction with the medical scheme, in particular Discovery. That's what we would like to hear you on. In addition to that, I see that at the end, you've also made recommendations. Those are the kind of issues that we would like to hear on. And the same goes for Ms. MacArthur. Do you understand that? Does it make sense to you? Yes? Does it make you much more relaxed now?
Yes, thank you.
Good. Okay. When you're ready to start, you will tell us. Now, from the submission that you've made, I assume that you will address us on chapters 1 through 7, and that the last chapter will be dealt with by Ms. MacArthur. Is that right?
That's
yes?
right.
Okay,
yes.
very well. Do you want to start then?
Thank you very much. Besides being nervous, we're also very grateful for this opportunity. So, for other people listening, just to know that there are the 8 chapters. And the background to start with. On the 1st of July 2012, my daughter Jessica McCarthy was the victim of a motor vehicle accident and sustained a traumatic brain injury. Her official diagnosis was diffuse brain injury with severe axonal damage. Jessica was 23 years old at the time and was a member of her own medical aid scheme, namely Discovery Health. Her debilitating injury meant that she was in no position to deal with Discovery Health, and that task fell to me as her mother. Just to say, the person sitting next to me is not the same as the young woman who had limited ability to walk, severe dizziness, speech difficulties, an inability to stay awake for longer than an hour due to brain injury fatigue, and an inability to write or read, etc., etc. The daughter who sits with me today is the product of excellent rehabilitation services provided by a dedicated group of private practitioners. The subject of this presentation is our ongoing battle with Discovery Medical Aid to get them to honour their responsibilities for the costs of Jessica's treatment. We encountered 2 main areas of difficulty. The first was a problem with getting hospital authorization, and the second, to get Discovery to meet their responsibilities in terms of prescribed minimum benefit legislation to pay for Jessica's rehabilitation. The first issue was eventually resolved, but I believe the story bears telling here. In relation to the PMB conditions, our battle with Discovery is now 4 years long, nearly, and still ongoing to this day. In many ways, this is a long and tedious story for you to have to listen to. I'll have to ask you to bear with us and also ask you to see that living the story has been both extremely traumatic and endlessly arduous for both Jessica and myself. So, on to chapter 2 and the beginning of a rough timeline of our experience. We live in Cape Town. The accident happened near to Port Elizabeth, and Jessica was hospitalized first in ICU, and then in a general ward at Green Acres Hospital, and then transferred to Aurora Rehabilitation Centre, both in PE. After a month in PE, the doctors deemed her fit to travel, and we were told that we'd been transferred to a rehabilitation facility in Cape Town. And this is when our first issue with Discovery Health arose. When we arrived to book her into the hospital in Cape Town, we were told that authorization had not been provided by Discovery Health. She was supposed to enter the Cape Town rehab unit on the 30th of July. I phoned them daily, up to 5 times a day, calls from me, as well as calls from both rehabilitation units and a medical aid broker who was trying to assist us. Discovery Health used petty excuses to delay giving the authorization. They never said an outright no, which would have given us recourse to some legal action, as they were obliged to pay for the treatment. Instead, they kept making excuses like, we don't have the letter of motivation. This was sent to them 4 times. Or promising, our medical review team will definitely meet tomorrow, without any answers forthcoming on the next day. And then the final insult. She's been out of hospital for 5 days now, so we don't believe that she needs to be there. All these calls back and forth were made while trying to care for my daughter, who at that stage couldn't even go to the toilet unaided. After 13 days of this, and in desperation, I started a Facebook group, which I called How I Was Messed Around by Discovery Health, and I posted the story. Within 2 hours of the social media posting, I received an email from the office of the CEO of Discovery, Dr. Jonathan Bromberg. The authorization was issued with a written apology on the same day, and I have attached the correspondence that came between myself and them at that time as attachment 1. On to chapter 3. The next battle began when Jess was discharged from inpatient rehabilitation and Discovery refused to meet their obligations to pay for her ongoing outpatient rehabilitation. This story could be told in 3 seconds. Discovery employed every possible bit of trickery or gross incompetence to avoid their responsibility to us in terms of the prescribed minimum benefit legislation. They claim it was not trickery. I have to share at least some of the laborious details with you so that you can judge for yourselves. Some background. The P&B legislation provides for outpatient rehabilitation for Jessica until such time as she's reached a ceiling on her recovery. Head injury, as most of you might know, a listed P&B condition. For those of you not familiar with the P&B issue, I have attached to the report 2 documents. Reading from attachment 2, which is the Board of Healthcare Funders' legal report and prescribed minimum benefits. It begins with the report reading, subject to the provisions of this regulation, any benefit option that is offered by a medical scheme must pay in full without co-payment or the use of deductibles the diagnosis, treatment, and care costs of the prescribed minimum benefit conditions. The attached Council for Medical Scheme script, more specific to head injury, is a description of medical aid obligations. I refer you to the paragraph at the end of that attachment, which says, the medical management and care of people with head injuries often includes rehabilitation. Rehabilitative services include but are not limited to physiotherapy, occupational and speech therapy, and psychological and social support. Once it becomes clear that the patient will not regain further body functionality, the medical scheme is not obliged to pay for further rehabilitation services. The scheme can ask to see the initial assessment findings and weekly progress reports to determine whether you're making progress in regaining your functionality to be self-sufficient. Just as a side note here, I want to mention that if I had not been an allied medical professional myself and had not had excellent input from the practitioners involved, I would never even have known that PMB legislation exists, much less be able to understand it. I therefore heartily endorse the call made by Angela Drescher in her submission to greater availability of this knowledge for patients and practitioners. With Jessica's treatment, Discovery Health insisted that each and every practitioner dealing with her submit a separate PMB application form. More than 15 of these forms were checked and submitted with the relevant invoices during August and September of 2012. Once again, in daily phone calls to Discovery, we were constantly told that the forms had not been loaded onto the system. And this was with my having this so-called special access to the CEO office after the social media. So I was forced to write to the CEO for help, and I received a 90-minute phone call from Abby Adams, who I believe was his assistant, where I had to check every form with her. In that phone call, she claimed not to have received some of them, but I was insistent. I gave her dates and times for each email, and she eventually admitted possession of all those emails. Abby Adams then assured me that she would fight the strongest possible case on our behalf in order to get Discovery's medical panel to approve our requests. She also promised to furnish me with an internal document which they call their basket of care for brain injury. This document hasn't arrived to this day, despite constant reminders from me. I have attached to our submission detailed documentation of Discovery's first offer to us in terms of the treatment they were willing to pay for, and my assessment of the problems with this offer point by point. Were I to take you through all those details here, this presentation would take days. In short, Discovery Health's medical panel chose to override reports submitted by no less than 23 medical and allied medical practitioners who had actually examined Jessica and supported Jessica's need for twice-weekly occupational therapy, twice-weekly physiotherapy, once-weekly speech therapy, once-weekly psychotherapy, and assessments with a neuropsychologist, a neurologist, an audiologist, and an assessment at a specialist dizziness clinic. Discovery's medical panel deemed it fit to assess a patient they'd never met and granted a total of 1 consultation with a doctor, 2 with a neuropsychologist, 1 session with a psychotherapist, and 4 sessions of occupational therapy, which they deemed sufficient for her entire rehabilitation process. And the full attachments describe those things. Even on appeal, with further reports submitted by all the treatment team, they refused to budge. When I requested the names of Discovery Health's medical panel, this was refused. I was told it was confidential information, and neither myself nor my daughter was allowed any access to these experts. This brings me to my second recommendation to this commission. The Facebook group, which I started in a moment of sheer desperation and have never actually actively promoted, now has more than 1,000 members. Other people who found their way out of desperation. Angela Drescher reported on some of their cases to this commission. Too many of us share this experience of the medical panel. An anonymous group of people whom Discovery Health inform us are experts in the field take it upon themselves to prescribe treatments for patients they have never consulted with, usually overriding the treatments prescribed by the practitioners who've actually examined the patients. It is my belief, both as a patient and as an allied medical practitioner myself, that the Health Professions Council of South Africa should be directed to undertake an investigation into these medical panels and to rule on the ethics of this conduct. Without access to the names of this panel or their practice numbers, we were unable to lay a complaint with Health Professions Council. So B, I believe that it's wrong for these professionals to be hidden in this way, and recommend that their names and practice numbers be made publicly available. Back to our timeline. Discovery Health's Abby Adams, despite repeated requests from us, failed to load even the measly benefits that they had originally offered onto the Discovery system, so we were unable to get them to pay those claims. Which brings me to Chapter 4. In which we lodged a complaint with the Council for Medical Schemes. And I would perhaps just like to say at this point that although the main focus, as I've written this, is on Discovery Health, I would also just like the Commission to pay some attention to the difficulties we've had in getting the Council for Medical Schemes to enforce their own rulings. In September 2013, after a year of attempts to appeal Discovery's decisions via their internal processes, we lodged a formal complaint with the Council for Medical Schemes. I want to publicly thank Jessica's treatment team, who spent hours of their own time writing reports and motivations in an effort to help us through these times. I would also like to state that not one of these private practitioners ever charged us treatment rates that were higher than those laid down by the medical aid. And I've added this here, as I often see references in the press reports of medical aids to practitioner greed in relation to PMBs as being a problem. We definitely did not experience any greed on the part of our practitioners. I also need to publicly express my disgust at the way in which Discovery Health's legal team responded to our complaint. There is an attachment on their response to our complaint with the full details, but in which you'll see that they resorted to stalking Jessica's Facebook page and randomly quoting from Facebook posts of hers as the only so-called medical proof that she was now fully functional and did not require the rehabilitation that her extensive medical team had said she needed. I do not have the time in this presentation to elaborate on the lies and misrepresentations that were contained in Discovery's rebuttal and in those quotes. The details are in their rebuttal and our response, which I have attached to this document. After 11 months, the Council for Medical Schemes issued a ruling in our favour in June 2014, essentially stating that Discovery Health should have been paying for all of her rehabilitation in accordance with PMB legislation, with the sole exception of the treatment by the plastic and reconstructive surgeon. I have attached their ruling as document 8. In addition to the 11th-month wait, Discovery was given a full year in which to decide whether or not to appeal this ruling, and we had no recourse to any further action until then. This meant a further 21 months in which we had to find the money to pay for our daughter's treatment, while Discovery hid from their obligations. By this time, my own personal funds were completely depleted, and my access to loan money to pay for my daughter's treatment was very limited. While waiting for the results of the CMS complaint, we were forced to upgrade Jessica's medical aid plan at an additional cost to what she had been paying of 2,194 Rand per month, so that Discovery would then pay for some of her treatment, even though legally they should have been paying all of it on the plan we were already on. In the now 27 months to date since then, Discovery Health has, through this, unfairly benefited from this amount to the tune of 59,238 rand coming from my pocket, and I will never be able to claim that back from them. My debt level had risen to this point where I was forced to sell my house in order to continue funding the costs incurred. A third recommendation to this inquiry is that the time delays at CMS be investigated and that the time allowed for appeal be shortened. You will see from what I say next that this appeal was used as a simple delay tactic by Discovery Medical Aid. Just to clarify, I think officially the time for the appeal is 30 days, but the year was how long the whole process took in reality, but perhaps the CMS people could tell you that. So this brings me to Chapter 5, in which Discovery do or don't lodge an appeal with the CMS ruling, and the CMS fails to enforce its own ruling. In July 2014, I was informed by the CMS that Discovery had lodged an appeal against the ruling, that there's an attachment 9. A full year later, now 3 years since Jess's accident, on the eve of the hearing, July 2015, CMS informed me that Discovery had dropped their appeal. My frustration resulted in further Facebook postings, and again I was contacted by Dr. Brumberg, CEO of Discovery Health, who by now actually himself joined our Facebook group, How I Was Messed Around by Discovery Health. I will summarize the next course of events by quoting directly from email correspondence between myself and Dr. Brumberg. I did all along share some of these emails with the Council for Medical Schemes. I've selected extracts from some emails just to shorten the presentation, but have submitted the full text of these emails with my documents. All emails from Discovery Health do contain a standard confidentiality disclaimer, and I did take legal advice where I was told that they could form part of my testimony. However, yesterday, Dr. Brumberg gave me permission to use the emails as well, so they can be released from the confidential clause. So, after waiting a full year to hear the results, the details of Discovery's appeal, they dropped their appeal at the last minute. When questioned about this, Dr. Brumberg first claimed that the matter should, and this is a quote, should never have been set down for appeal in the first place. When I asked him to explain why they had not settled our claims if they had not intended to appeal, he responded saying, and this is another direct quote, Discovery Health Medical Scheme did appeal against the CMS ruling at the time. We did this because we believed, and still believe, that the CMS ruling sets a precedent which has massive cost implications for the medical scheme, and hence for members' premiums. When CMS make a ruling in an individual case, this may have major implications for the long-term financial stability of the scheme. Our judgment was that this decision did pose this kind of risk. As I've stated before, this was thus honestly not a delaying tactic. We appealed after very careful consideration and discussion for the reasons outlined above. He went on to say that it was the CMS's fault that there'd been such a time delay, and that Discovery had hoped to, quote, resolve the matter without a formal appeal, and had been in private discussions with the CMS on the matter. I, of course, had a question about the correctness of my daughter and I being excluded from these alleged discussions. So, firstly, CMS informed us that Discovery had dropped the appeal. Then Dr. Brumberg said they hadn't appealed. Then he said that they had, but had hoped to resolve without a formal appeal. He did not explain why it had taken a year and the issue was still not resolved, except to blame CMS for having the backlog. You can perhaps see why I experienced this as a delaying tactic. He also informed me that his major concern was the precedent that my daughter's case might set, and the potential financial costs that this might incur for his company. For starters, as I saw it, the PMB laws were promulgated in 2004. Have Discovery Health been refusing their obligations to brain-injured patients since then? In 10 years, it would seem that they had no precedent yet for paying these claims. In a 2013 study entitled Traumatic Brain Injury, the South African Landscape, published in the South African Medical Journal, the author Dean Naidu says, South Africa does not have a TBI data bank, and contemporaneous studies on the overall incidence and prevalence of TBI are lacking. In 1991, Brown et al. Reported an average incidence of 316 brain injuries per 100,000 persons per year. A 2015 report from the South African government's Department of Occupational Health states that an estimated 89,000 cases of new traumatic brain injuries are reported annually in South Africa. One could, although it's beyond my statistical ability, estimate from these figures what the prevalence of head injury in medical aid members is. I'm pretty sure it's high. I have no doubt that this issue extends beyond my daughter's needs. Perhaps an audit of the claims on this code is necessary. I have recommended that an audit of claims containing PMB codes be carried out on all medical schemes to determine which of these claims have been refused. Discovery no doubt has a team of actuaries working for them, whose job it is to balance out the claims of members against the rates and premiums paid. It's quite simply not my problem that it is inconvenient for Discovery to abide by the PMB law and thus honour their obligations to my daughter. It seems Dr. Brumberg is afraid other members might refer to my daughter's case and realise that they too are entitled to PMB treatment. It shouldn't be the job of a mother to see her daughter go illegally untreated in sympathy with a multi-million rand corporation's financial concerns. Dr. Brumberg assures me that this is not personal. Nothing could be more personal to me than the well-being of my child. When I asked for further details on how Discovery intended to resolve the matter, Dr. Brumberg repeated his earlier concern, saying, as I note above, we appealed here on grounds of principle and precedents that would be set. Our discussions with CMS therefore dwell on how this individual matter can be resolved without creating a very high-risk precedent for the scheme and its members going forward. He then raised the scheme's alleged need for progress reports on Jessica's recovery in order to make a decision on how they would progress. Discovery had already received numerous reports, motivations, and PMB applications, which were submitted as part of our original funding requests. I referred to these earlier. These were resubmitted as supporting documents to the CMS complaint. The scheme had never requested further progress reports, though at this point they claimed to have approached the medical practitioners directly. I followed up with each one of these practitioners, who unanimously denied having been contacted by Discovery. I asked Dr. Brumberg and Shivani Singh, his legal advisor, to supply me with a list of practitioners that Discovery had approached and when they had approached them. This list has never been forthcoming. There were numerous requests, and you will see it in attachment 10B, which are all my emails with Discovery Health, some of which were copied to Louis Ports at CMS, and Shivani Singh was Discovery Health's legal advisor. Dr. Brumberg stated in an email to me, I can also assure you that we have in fact made contact with every single provider that we have mentioned to you. We would absolutely never lie to you about this. Yet, all of the practitioners claimed that this did not happen. Only after I had followed up with the practitioners myself, then Jessica's neurophysiotherapist and speech therapist, those two practitioners received phone calls from Discovery. Again, this seemed to be a delay tactic on the part of the scheme, as I wasted countless hours following up with practitioners, asking for details from Discovery, returning to the practitioners to chase up unnecessary reports that they were then forced to waste hours on, the practitioners, while they repeated much of the information already reflected in reports that Discovery had in their possession. Even this was not enough. Despite having requested and received guidelines from Discovery Health's legal advisor on what exactly they wanted the reports to cover, once the reports adhering to these guidelines were submitted, the legal advisor shifted the goalposts and said that they now needed monthly reports from each practitioner for the entire 3-year period. Note that would have been 36 per practitioner. And there were 14 practitioners. Again, I believed I was being manipulated with further delay tactics. If you look at the PMB guidelines, all that the CMS ruling did was to reiterate the very clear law that Jessica was entitled to diagnostic and rehabilitative services. All it took for me to understand that law was to read the very clear guideline issued by Council for Medical Schemes on that law. I said to Dr. Brumberg, a quote, "If you are indeed serious about resolving the issue, it would be quite simple. You and your team need to go through all the claims that you have processed for Jess's rehabilitation since 2012 and to reprocess them and pay them out as PMB payments. You can, if you choose, ask for further progress for the 2014 and 15 years. Or you could choose to accept that no ethical rehabilitation therapist would continue to treat a patient who had reached a plateau in her therapeutic progress." To this he responded, again, "The issue of principle at stake here is vital. There are a huge range of outpatient rehab requirements and demands for patients at every level of injury. If Discovery Health Medical Scheme or any medical scheme is forced to fund all of these from their risk pools, the cost implications would be crippling. We have to find a way to balance the needs of individual patients and those of the entire collective membership. This is the reason that the issue of rehab needs careful debate and discussion with CMS." So, every time I asked him how I intended to attend to the issue of Discovery's responsibility to pay for my daughter's treatment, he referred again and again to the concerns of the entire collective membership and avoided dealing with our case. I sent a number of emails to various people at the Council for Medical Schemes during this period. I asked repeatedly what the penalties were that could be applied to a medical scheme that did not honour CMS ruling. I have not received any response to this question. It is therefore my recommendation to this Commission that A, there be clear penalties for parties who do not adhere to the CMS ruling, and B, that these penalties be enforced. Chapter 6, in which Discovery Health finally agreed to reprocess claims but fall short of including all the claims. In September last year, 3 years after they were initially submitted and after another 3 months of up and down correspondence, all seen in your attachments, in which further obstacles were placed in our path, Discovery Health finally sent me a review of the claims they were now willing to settle for 9 of the practitioners. In this review, there were still a number of practitioners whose bills they were refusing to settle. One of these was a physiotherapist, a discipline that was definitely covered by the CMS ruling. A second practitioner was involved in diagnosis but not treatment, which the PMB legislation does cover, but Discovery is still arguing. A third practitioner was someone who Jessica had only begun to see in 2014 after the paperwork had been submitted to CMS. In September 2015, the CMS said they would reopen the case. I have had no replies to my emails to the CMS since then. The amounts that Discovery did agree to settle in September last year totaled R87,546.32. Of the total, R52,026 had, they said, been paid to my daughter. 5,000 rand was paid to providers, all of whom I had already paid. 14,900 rand was the amount that Discovery Health said they'd refunded to my daughter's medical savings account. This only after I had told them that I was aware that it was illegal to fund her PMB conditions from her medical savings. That is nearly 90,000 rand, and there's still a lot more that needs sorting. This is money that I had to borrow, fork out, and pay interest on in the meantime. By the way, the money that was paid out to the practitioners was done despite my having already paid these professionals. Discovery said that I had not provided sufficient proof of payment, even though the practitioners provided statements showing full details and that there was no outstanding monies due to them. When I asked what sufficient proof of payment would be acceptable, I received no answer. Thus, I was left having to track this money from each practitioner individually. In early February this year, I managed to again take more time off from work in order to begin the arduous process of reconciling Discovery's list of reviewed claims against my list of the claims which I'd submitted to them. Their review was so shoddy that they failed to provide accurate treatment dates for many of the claims. They also omitted a great many claims, saying they had no record of them, despite my having complete records of the original dates they were submitted and dates rejected by Discovery Health. The full details of the queries that I sent to CTICC, their legal advisor, are contained in attachment 11. Claims to the value of approximately 35,000 have simply been omitted from the Discovery Health review. So, my final chapter before I let Jess speak, chapter 7, in which we discover that Discovery Health have not paid what they promised. On the 19th of February this year, I decided that I'd better reconcile the actual payments that my daughters and others had received last year against those which Discovery had promised and which I'd assumed they had paid. The promise was in September of 2015. I'm going to tell my last chapter simply by quoting from our most recent frustrated Facebook posting made on that day. In the posting, I quote an email I wrote to Discovery Health today. Dear Jonathan Bromberg and Shivani Singh, I'm running out of adjectives to express my horror and disappointment at Discovery Health's handling of our matter. In addition to my previous emails where I pointed out the number of treatment dates that have been excluded from your summary, I've today made an attempt to reconcile the payments my daughter did receive from you compared to the ones you promised in September 2015. Some payments were made into Jessica's account and some to providers. On the attached sheet, you will see my attempt to reconcile what was paid with what was promised. There is a clear shortfall of 15,010 rand and 71 cents in what you actually paid to Jessica compared to what you promised to pay, and another shortfall of 2,088 rand and 60 cents, the difference between what you promised to pay to providers and what you actually paid. Please ensure that these amounts are paid immediately. I carried on in Facebook. In July 2015, Jonathan Bromberg offered via this site to help me sort out my daughter's problem with Discovery Health's refusal to pay for her treatment, even after a CMS ruling had ordered that they do this. They then reworked all her claims. There were a number of claims that were left out of this reworking that I've informed them of. To my horror today, I discover that even those claims they agreed to pay have been short paid by 17,100 rand. Jonathan Bromberg, are you going to sort this out now properly, or was your offer a simple public relations ploy? And I have put it in attachment 12, I've shown the financial reconciliation. To date, I've received no response from Discovery Health to this posting. The response to my many emails and my reconciliation so far has simply been to tell me that Shivani Singh is, quote, too busy to deal with me at the moment and to refer me to a new consultant on the case. She did telephone me to say that she needs some time to familiarize herself with our case. That was nearly 2 weeks ago. I haven't heard from her since. Neither the queries regarding the claims they admitted from their review nor the money they promised 6 months ago but have failed to pay have been answered. In addition, a repeated request for a statement of Jessica's medical savings account, which I thought I'd better check too now, has been ignored. I remain with one question. What is my legal recourse? And I'll hand you over to Jessica now. Thank you.
Yes, thank you, Ms. Naronsky. Yes, Ms. McCarthy.
Hi, Ms. Jess is good. Or just Jess is even better.
Or Jess.
So I'm not going to speak long. I just wanted to write from the point of view of the patient and the actual medical aid member, which is me. When you wake up in ICU with double vision, bruising on every part of your body, so disorientated you don't even understand that you're in hospital, and with no comfortable part of yourself to lie on, surrounded by fluorescent lighting and beeping machines, and filled with fear because nothing makes any sense, you're in no position to think about whether your medical aid is going to follow the law or just quietly break every law they can to save themselves some money and leave you stranded. I was the most vulnerable I've ever been in July of 2012 as I lay in my bed, my poor brain working overtime to try and repair itself, my sodium level so dangerously low I had to be dehydrated just to keep me alive, having just received 6 units of blood in a life-saving transfusion and spent 4 days in an induced coma. I spent a further month in hospital, 2 weeks at home with my family, another week in hospital, and then many more weeks living at home with my parents. In this time, I couldn't get out of bed without help. I couldn't bath myself. I couldn't make food. I couldn't even walk on uneven ground or stairs without help, without a Zimmer frame, or a person to hold on to. Just a few weeks before that, before the car accident, I had been a final year drama student on the Dean's merit list for the 4th year in a row, living completely independently and with every reason to suspect I was about to graduate cum laude. And suddenly I was like a child. I distinctly remember how my family and I celebrated the first time I managed to make myself a piece of toast. You suddenly appreciate the little things. Even when I did move back to my own flat, which was a move that my mom allowed prematurely just because it was so difficult for me to live as a child completely dependent on her, I still had medical practitioners visiting me at home every single day and a companion to help me with cooking, shopping, physio exercises, even bathing. I couldn't even handle the basics of my own daily life at that time. The only reason I'm putting you through all this detail is to give you a picture of just how vulnerable I was in that time. I was absolutely not in a position to deal with the legal duckings and divings of my medical aid scheme as they then played out, and as you've heard detailed by my mom. Just for starters, nobody at Discovery explained to me that my diagnosis, diffuse traumatic brain injury with severe axonal damage, was a prescribed minimum benefit. Not that I would have known what a PMB was, because that was never explained to me either. So when they began to refuse to pay for my treatments that my specialists considered vital, I didn't even know that they were breaking the rules. When Discovery's medical panel, who had never met me and I was not even allowed to know the names of, began overruling my specialists' detailed reports and medical recommendations, I was not in the mental state to question the ethics of even the existence of such a panel. At that time, I couldn't even work out what colors went together, so I couldn't choose my own clothing. The only reason I had a fighting chance at getting the treatment I needed is because I was blessed with a mother who was willing and able to take on the whole issue for me. Just to be absolutely clear, and I'm sorry if I'm laboring the point, but at that time I was not even capable of submitting a claim to my medical aid, never mind arguing their decision to refuse that claim. I couldn't write, I couldn't handle looking at a computer screen, I couldn't even read a magazine. So because I am as lucky as I am, my mom stepped in. She stepped in not only to fight with them, but also to pay for the treatments that they refused. She went so far as to sell her house and move to a smaller place just to counteract the immense costs she had been saddled with, thanks to Discovery choosing not to abide by the laws around PMBs. Because when it's your child who might not be able to lead a normal life, I guess you don't count the pennies. And there was no way I could have afforded to pay for those costs myself. I was a full-time student at the time of the accident, and obviously not in a position to even return to studies, never mind work at that time. So had my parents not done everything in their power to scrape together the money to pay for my treatment, and, by the way, continue paying for my medical aid premium, which had more than tripled, I quite simply would not have gotten the treatments I needed. Without those treatments, I would not have returned to university to finish my degree. I would not have entered the working world as I'm beginning to do now, and I would certainly not be sitting here being able to talk to you, to this esteemed panel, or anyone for that matter. Even now, nearly 4 years later, I still don't understand all the intricacies of the incredibly messy story of our fight with Discovery. I certainly would not have been able to give you clear testimony myself, which is why, even though I am the main member and I am an adult, I am relying on my mom to explain it all. When my friends have asked me why I don't just change medical aids if Discovery is going to keep making my life so difficult, I've had to explain to them, as I know everyone here will know, that medical aids are entitled to implement a 12-month waiting period on pre-existing conditions. So because I come already with a brain injury, I'm stuck with Discovery, even though I wish I didn't have to be with them. That point, by the way, is the point that was added in the new version of my chapter, which I felt was quite important. Throughout my journey towards recovery, I've come into contact with many other traumatic brain injury patients, many of whom have not even known that they were entitled to rehabilitation. So it's for their sake, as well as my own, that I'm very grateful to have had the opportunity to share our story in this forum. And it's not a nicety, I really do want to thank you for listening to us. And I think the last part is for my mom to just speak to her recommendations. Thank you.
Thank you.
Thank you. I have mentioned most, but there is a summary of recommendations that pulls together. So I'd just like to read those. My recommendations are, and there's 6 of them. Number 1, that the education of all medical and allied practitioners include in their initial curricula and their ongoing professional development courses detailed knowledge of the workings of medical aid schemes and how to interact with them, including clear guidelines on the writings of reports and submission of forms required by these schemes with special reference to prescribed minimum benefits. Each practitioner should be equipped with full knowledge of those PMB conditions that pertain to their particular area of practice. 2, that clear and definite penalties should both be outlined and imposed upon medical aids who flout the rulings of the Council for Medical Schemes. 3, that the limits of time for both cases and appeals against CMS rulings to be heard be shortened to a maximum of 30 days, and that provisions be made for urgent hearings in respect of life-threatening illness. Recommendation 4 has an A and an B, that the Health Professions Council of South Africa be directed to undertake an investigation into the medical panels employed by medical aids, and to rule on the ethics of their prescribing treatments for patients they have not examined. B, that the names and practice numbers of these panel members be made available to the patients and members whose cases they are reviewing. Number 5, that an audit be carried out on all medical aid savings accounts in order to correct for PMB conditions that have been illegally funded from these accounts. This was one of Angela Drescher's recommendations as well. 6, that a further audit of claims containing PMB codes be carried out on all medical schemes to determine which of these claims have been refused. I further voice my support for these recommendations made to the inquiry by Angela Drescher, that medical aid schemes, brochures and websites need to have far more information on PMBs, including a visual flowchart of both the applications and the claims process. This flowchart must include the recoding, resubmission and reconciling of PMB pathology and radiology accounts. Number 2, that medical aids must be held legally responsible for identifying PMB ICD-10 codes on all claims, accounts and prescriptions presented to them. All medical aid scheme computers need to flag these specific codes. If no PMB is applied for or approved, the medical aid scheme must be held responsible for contacting the member. The consultants who do these follow-up calls must be trained specifically to deal with PMB queries. And the third and final one from Angela, the 2010 PMB Code of Conduct recommendations and procedures must be implemented as agreed to by the Department of Health, the Council for Medical Schemes, the Health Professions Council of South Africa, and the medical aid schemes. Thank you very, very much for listening.
Thank you, ladies, for that input. My colleagues will put questions to both of you just to get to clarify any matter that they may wish to clarify from the presentation that you've made. Thank you. Dr. Bengo.
Thank you very much for your presentation. I just want to look at the recommendations that you make. First of all, just picking up from a presentation from Ms. Drescher last time, she indicated that the scheme concerned made an effort to meet with her and make some changes within its environment to accommodate. I can remember the PMB documentation and all of that. Has such happened in your case as well?
No.
Okay. What is the current status now? I'm not sure. I remember your question where you say, what legal recourse do you have? But just to be sure I'm not missing, are you at a situation where there's 17,000 that's outstanding? Is that where it is?
There's that 17,000, and there are a number of claims that, as far as I'm concerned, fall within the CMS ruling, which they are still refusing to pay. And there are a number of claims which they simply, of practitioners that they agreed to pay for, but they just ignored, for example, 3 months of claims from one of the practitioners. That's the 35,000 Rand of claims that we picked up. So there are those 3 areas. Plus, I haven't been able to check if because they didn't refund me what they'd promised, I feel I need to check whether they actually have returned to Jessica's medical savings account what they promised, and they are ignoring my requests for a statement on that account. The only one that we can get online refers to the last year, but of course this issue goes back 4 years, so I would need them to provide that statement.
Sorry, unless I've remembered wrong, even online we can't find a statement. We can find an amount. So it says how much money is currently in my medical savings, but it doesn't have a statement of what has been paid from there. So it's still possible, because they originally were paying out of my medical savings when they shouldn't have been, that they've continued to do that. We don't know.
Okay. No, that's fine. Now, other recommendations here, how would it help to have the names and practice numbers of panel members to be published? How would it help in a fight similar to yours?
As I said, I couldn't approach the Health Professions Council myself without those names, seeking advice on the legality and the ethics of what they've done.
Do you think that's the better route, or should maybe the panel, if it's so inclined, rather recommend that the schemes be compelled to give that information to authorities? Or is it that important that you must know exactly who sat on your case?
I think the major issue that I'm questioning is whether these panels should have the right to override treatment recommendations for patients who've been examined. And where medical practitioners have made clear recommendation and these panels are overriding those recommendations. I think in Angela Drescher's testimony, I can't remember how many she included from that Discovery, how it was messed around by Discovery Health, that Facebook page. But we've seen it's a common story on that page. Even, it happened in Jessica's case, but even patients for treatments for cancer, where they've overridden what the doctors recommended. So that issue just seems to me that it needs addressing on a very broad level. But in the meanwhile, as an individual not having that power, I simply wanted their names and practice numbers so that I could raise the issue with Health Professions Council.
Okay.
Can I just add, from the patient experience, I had obviously been examined and, gone through so much testing by so many doctors and allied professionals as well. And, I really had seen across the board so many different people, and they were all agreeing, those who'd actually met me, that I needed certain treatment. And then to have someone who's never even seen me, who I'm told is an expert, but I don't even know who they are, just go, nah, she doesn't need anything, she's fine. It's a very disconcerting, scary experience. Okay. Because obviously I placed my trust in the people who examined me.
Yes, as Jessica says, we're also having to rely on Discovery Health's word that these are, even doctors, we don't even know if they exist.
Okay.
We're just told there's this medical panel.
Oh, okay, I get that. Now, my last question really, having used so many avenues to conduct the scheme, which modality or means of conducting the scheme do you think is most effective? Which draws most response? This question, of course, is meant to be applicable industry-wide.
May I answer?
Yeah.
So far, just looking at the evidence of our story, the only thing that seems to get a response is to attack their PR or their public image by going to Facebook or Hello Peter. That's the only time that we got a really timeous response from them was when we publicly said we're not getting help. Because, my mom was on the phone, as she said, more than 5 times a day between running to look after me and all of that, and that didn't do anything. Even many of the emails directly to the CEO have gone unanswered, for example, about the medical savings account and the recon that didn't make sense between their paperwork and our paperwork. We just haven't got responses, even though we're going as high up as we can. So it seems, yeah.
Okay.
I really thought that, we were being given this privilege to bypass the call center, which is a nightmare, because every time you phone, you speak to a new consultant who doesn't know your case and who gives you different advice to the previous one. We were given this open door to the chief executive officer, even though I found it strange that he should have to deal with things like this, but he offered. So the normal channels completely failed us. But even now, we sit, what's in the story is hours and hours of administrative work done on my side in order to write every single email and contest everything. So I can't answer you. I don't feel like our needs have been addressed yet.
No, thank you very much.
Who is Peter?
Hello, Peter.
Yeah, who is Peter?
Hello, Peter is an online website dedicated to consumer rights and consumer complaints. And you can complain about any company and their bad service there, and then the companies respond from that site.
I understand.
Thanks for your testimony, Jess. I wanted to ask you if you can remember how you first got to join Discovery, why you joined Discovery, what you heard about them, if you had a broker. Can you tell us that story?
Sure. I had previously been on a more comprehensive plan with MediHelp because my dad was a doctor and there was some relationship. But then he left the country and I became an adult and was going to open my own plan. And I bought the sugared candy that I believe most people buy about Discovery, and I went, well, I'm young and healthy. I don't need anything except for emergencies. So this is not specific to Discovery. Any medical aid plan, I would have gone just onto a hospital plan because I thought, I'm young and healthy, I don't have any issues unless there's an emergency. Then when come back to the sugared candy, I went, Discovery Health has Vitality. I can get a cheap gym contract. I can get cheap movie tickets. I can get money back on the fruit and vegetables I buy at Pick and Pay. And I did approach a broker and I said, this all sounds really fun. Is Discovery Health good? And they went, yeah, they're great. And I thought, well, most people, I think if I'm not mistaken, the greatest proportion of the country that is with medical aid is with Discovery, but I stand possibly corrected on that. I thought, well, if so many people are with them and they have all these great benefits and all their sort of PR stuff sounds so great, I'll just go with them.
And this broker that you spoke to, did they then take you to Discovery?
Yes.
And did the broker assist at any point during this process? Did you have any ongoing relationship with your broker?
Initially, I don't think my mom knew the broker, but I put her in contact. I was in hospital, so maybe you should answer.
When we came back to Cape Town, one of the practitioners that Jessica was seeing introduced me to a broker who specifically had started his brokerage. It was really a sideline thing for him because his own brother had had problems receiving treatment from Discovery Health. And they were willing to help. They really went there. They helped me process every claim in the beginning and helped us lay the complaint at Council for Medical Schemes. But I did move from Jessica's original broker to them in order to get that help.
And did you have to notify anyone that you were using a different broker? Did you tell Discovery you'd got rid of that broker and now had another broker?
They were notified. We had to sign a form which went to them. Yes. Okay. Sorry, may I go back to the previous question? There was one piece of information that I forgot to mention. I've been listening to a lot of this Commission's proceedings, and there was a question asked by Professor Von on one of the submissions where she asked, in fact it was Angela Drescher, where you asked if any contact had been made with the trustees of Discovery. And that sounded like a great idea. It was the first time I'd thought of that. So I went to try and find contact details for these trustees. I managed to find their names, but I've been unable to get any access to contact details.
Thanks. That reminded me of my second question. I wanted to understand something. You got an email from Dr. Brumberg in which he spoke about Discovery Health Medical Scheme. Who do you think you've been dealing with?
Up until I was listening to the Commission's I thought that he was the medical scheme. I knew that both things existed, but in the way that he's responded on the Facebook page, where he's often sort of very defensive of the medical scheme because people talk about being bullied by it, as you saw in the emails, he has definitely, for me, created the impression that he's from the scheme.
Just to clarify, as the member before the accident and everything, I didn't even know that there was more than one body of Discovery. I just knew Discovery.
And you'd never had any contact with the chief, I don't know what he's called, chief officer, principal officer of Discovery Health Medical Scheme. You don't know who he is? Or...
No, and I wouldn't know how to contact. And I did go and look at the website to try and find that. They did have an escalated appeals process on the website, but it doesn't say who it goes to.
Thanks.
When you took the decision to join Discovery, did you know at the time that there were two Discoveries?
No, I didn't.
Which one did you think you were joining?
I feel like I'm revealing too much of my own ignorance. I just thought I was joining a medical aid that was going to help me if I was ever in an emergency, and in the meantime, give me cheap access to the gym.
And that was based on what information? Where did you get that information about that medical aid?
From the broker that I approached. He was recommended to me, and online I went and looked at their website.
Yeah.
I now realize that I really should have thought about this more, but, you know, when you're 20 and you think, oh, I'm healthy, this is just in case.
What's the name of your broker?
The broker who originally... Andre van der Berg, I think?
I don't remember, but I do have emails, and if you need me to send
Sorry.
that information, I can.
But the brokers who then helped us later was Lee Pluk at PBSC.
Yeah.
And they were incredible. They were really amazing.
Yeah. The original one who introduced you to the scheme, did you have any contact with him after you had been introduced to the scheme?
Initially, just some administration, but I don't think I ever laid a claim until the car accident happened. And at that time, you were handling it.
Yeah. And did he maintain any regular contact with you?
No.
Just introduced you and then he disappeared?
Pretty much.
Did he explain to you what you were joining and what are the benefits that you were entitled to?
Yes, very, very basically.
What did he say? Can you remember what he said?
Sorry, I don't know if I can.
Yeah. No, it doesn't matter if you don't. We all.
I do remember, although I know that this isn't the issue here, but I certainly know that I was never told that Discovery has apparently a clause somewhere that if a member is in a car accident, that Discovery can enforce a claim against the Road Accident Fund and claim back their money that they've paid out. I certainly didn't know about that. And although I don't remember the details, my mom raised me to read contracts very carefully before you sign them, so I would have remembered if I'd read that. But I know that's somewhat besides the point.
Well,
Here.
and you weren't expecting to get sick, were you?
No.
Right.
I'd been healthy till that point.
Yes. Did he say anything about the PMBs that you can remember?
I'm pretty sure that I would remember. I don't remember being told anything about them.
Thank you.
Thank you very much for your presentation and sharing your experience with us. Most of my questions have been covered by my colleagues on brokers. I just have one question on your recommendation of making the panel's names and practice numbers public. My understanding of that recommendation is that also the practitioners you were dealing with did not know who the panel is. And it is also there for their benefit to know which colleagues they're dealing with. Am I understanding that correct? I just wanted to get clarity that it was not only for your benefit, but also for the practitioners who are dealing with you to know who they were interacting with.
Yes. I do think, and I'm not absolutely clear on this, that practitioners can phone and request to speak to members of the medical panel. We did have one time where, as you noticed from the presentation, there were thousands, well, it felt like thousands, not really, of times that I had to go back to our practitioners asking them for reports. And the one practitioner wrote and just said she just can't fit this into her life. And Jonathan Brumberg then offered for her and a few other of our practitioners to make verbal reports rather than written reports, which at the time I thought obviously that he was being helpful. I now realize it means that I have no record of those reports, and I've asked for transcripts and they can't give them to me. So if we need to go back to CMS, we can't prove anything. But just to go back to your question, is so at that time, they were, from what they were questioned, the practitioners were questioned by the medical panel, so there was that level of meeting with some, but I don't know the details of who was on the other end of the phone.
Thank you.
Thank you, Jessica and Mother. As Jessica said, I don't even, and I'm not sure whether I fully understand the details of my messy case. Well, my file is now turning out to be messy as well after I read it, but I read it. And as explained by the chair, of course, we're primarily interested in how competition works and how access works in the South African private healthcare system, and the primary aim of this meeting is to understand how you interact with the different players. I do think I got an impression how you interacted with Discovery Scheme, and Discovery Administrator. I can tell you clearly what the distinction is between the two. You interacted with Dr. Brumberg, who's the head of the CEO of the administrating the scheme. So I do think that I understand how you interacted and how you did not interact, and how you communicated and not communicated, and through which channels. I made a note of a number of questions I have for the CMS. They will probably be present here and listen to your story, or were familiar with your story, and there's some interesting elements in your presentation to discuss with the CMS. On the medical panel, we have already had two colleagues asking you, and you said I wanted to have the names and the contact details, maybe to interact with them directly, because the medical scheme and the scheme and the administrator sort of left it to the panel to decide whether your doctors and helpers were correct or not. And I do understand that it is an interesting element, let's put it this way, that they made a decision without even seeing Jessica. So that is really something to probe into. But then you said, I also need the details because I wanted to lodge a complaint with the HCPSA on this particular occasion of the case of Jessica. Have you been in contact with the HCPSA on this?
No, I haven't. Without those names, I didn't feel that I could ask them to investigate anything.
My point is that I can imagine that Discovery is reluctant to bring the names of the medical panel in the open. There are arguments that I can think of myself, but it must be possible for the HPCSA, without a doubt, I think, to find out what the identity of the people, of their members are, working for Discovery, and to ask them questions on this.
Okay, so it would be worth following up then.
I think I'm not in a position to advise you, but I think if I
Yes.
think about it,
No, I didn't realize that they could access those names. You know, I just sort of thought that if you're going to lay a complaint, you have to say who you're laying a complaint against. And how could I lay a complaint against somebody who quite honestly, I don't even know if they exist.
that's right. No, I understood you, but it's quite unacceptable that you can't lay complaint because of this.
You know, and
because of this reason. There must be a way for institutions to communicate without revealing the precise identity of the people behind it. So, yes, I wanted to find out whether you had yes.
At some point, and it must be somewhere in the emails. No, it was in a telephone call with Abigail Adams. The response was that the doctors are not prescribing treatment. They're just insurers prescribing funding. And yeah, I suppose that is an issue that somebody else might have to consider. I just need to say from a patient point of view, it was prescribing treatment for us.
Well, yes.
And even if it wasn't prescribing treatment, it was refusing treatment. So it was prescribing not getting treatment that specialists felt I needed. So
yeah.
I think that's semantic.
Yes.
And in addition, you know, there have been cases on the Facebook page where they've specifically changed treatment protocols with those cancer patients, where one protocol was prescribed by the oncologist that consulted and another one by the medical panel.
Yes.
A different one.
So the thing I wanted to find out whether you had been in contact with the HPCSA and what their decision was. If you are going to be in contact, will you please let us know what the answer is and whether you can proceed.
I will definitely make contact.
Thank you very much.
Thank you
very much.
I'm trying to make sense of these, of the annexures to your presentation. Now, you referred to a team of the professionals who assisted you, who assisted your daughter. Is that right?
Yes.
Okay. Now, then immediately after the presentation, you have annexed an exchange of emails between yourself and Dr. Jonathan Bloomberg. Is that right?
That's right. Yes.
Okay. Did you designate that as any annexure?
That is attachment 1.
Yeah, that's attachment 1.
Yes.
That's the attachment 1 that you are referring to. Okay.
Oh, sorry. No, I think there's a... Oh, yes. Sorry. They're two different attachments with Dr. Brumberg. That one is with Abby Adams and Dr. Brumberg.
Yeah.
All those emails pertain to the hospital authorization problem that we had, the first issue.
So what is that? Did you designate that as, did you give it any?
Attachment 1.
Yeah, that's what
Yes.
I thought. Okay. And then that's followed by a document which has headed problems with discovery, health initial approval.
Oh, okay. No, you're quite far down. I've got all the attachments here.
Well, they go up to page 20, the first email.
I do have a list of attachments on the first page.
Yes, I understand that. I'm just looking at what has actually been attached. So after that exchange of email, which runs from page 1 to page 20, there is the next document. I think that document...
Sorry, just can you repeat what your next document is? Because
Well-
I have all my attachments printed here.
Right.
And yours seems to be different to
Well,
mine.
the next document is titled Problems with Discovery Health Initial Approvals.
Just sorry. That sounds like it might be a piece of. Can I provide you with this full
Well,
thing which has all the
yes,
attachments?
yes. I wonder if you could provide us with fresh attachment in the sequence in which they are reflected on, at the foot of page 1 of your presentation.
I can.
Yeah.
I mean, I did email them, and each of them was labeled, but something may have happened in your printing process.
That is the problem.
It does make quite a big pile. So
Yes, and I think if you could put them in the order in which they appear in your presentation.
I have that here
Right.
in front of me.
And then if you could also mark them as you've done here from attachment 1 through
Yes.
attachment 11. No, I beg your pardon.
Yes, that I've done by
20,
hand here,
yeah.
so that would make it easier for you.
Yeah. Okay. Now, so you don't have a record of this document that I've just referred to?
I do. I remember referring to it in the talk,
Yeah.
but I think it's a part of one of the other attachments.
Yeah. But anyway, I think,
That formed part of the CMS complaint.
Yeah, okay.
That we did, where we went line by line
yeah,
through
yeah. Okay.
the practitioners.
Okay, very well. Now, but what I would like to do is perhaps draw your attention to the first paragraph of that document. Do you have that document in front of you?
Could you perhaps, it might involve going through all of this because we're not sure where it is, but if you could read to me, I do remember a lot of
Yes.
that.
Okay. This is what paragraph 1 says. We've been, well, I think what's relevant here is the second sentence. This, despite the fact that Jess has been referred by her treatment team to the following practitioners. I think what I'm interested in is the treatment team.
Yes.
Now, the treatment team that is mentioned here is the general practitioner. What is that, Doctor?
It's a big team. It's all those people that we applied for benefits for.
I understand. I just want to
Yes.
get a sense of who are the specialists
Okay.
that you referred to.
So there was a general practitioner who has a special interest
Yeah.
in rehabilitation, which was Dr. Geffen,
Yes. And then you have a neurosurgeon, Dr. Welsh.
Dr. Welsh. Yes,
And then you have a neurologist, Dr. Frost.
that's right.
A plastic surgeon, Dr. Bruce Twat.
Twat, yes.
And then you've got Dr. Hoekstra in Port
Yes.
Elizabeth, yeah?
Yes, because Jessica.
Okay. Yes. In addition to this, do you have any others? I see there's also the dentist, Dr. Lopsha,
Yes. There was also
an orthopedic surgeon,
yes,
Dr. Carter
Yes.
from the hand clinic.
yes,
And then you've got also a psychology counselor, Taryn James, yes?
yes.
Right. And then you have an occupational therapist, physiotherapist, speech therapist. Now, when you refer to a team that compiled reports to Discovery, are you referring to this team?
All of those
Yeah.
people,
Yeah.
plus, because Jessica was moved between PE and Cape Town,
Right.
there was a team there consisting of the same fields, occupational therapists, speech therapists, physio, etc., who also submitted reports in order to support what this team. That's why there were so many practitioners who, in the end, I think the number was 23 reports.
Yes. 23 report by two different teams, or just one team?
There were two of the teams were actual teams from inpatient units, the rehab unit in PE, and the others were private practitioners themselves, but they formed a team in that they met with us as a team. So the reports went from each individual practitioner.
Okay, I understand. Now, just to get the dates correct, the claim that is an issue that you're still pursuing was lodged with Discovery in September 2012, is that right?
From September 2012, when her rehabilitation started, rehabilitation took a few years. In fact, she will still need some treatment, but I mean that intensity of treatment.
I mean, when you lodged the claim, with when you raised
the first application for PMBs was September 2012.
Right, and then when there was no response, it was in September 2013 that you approached the CMS.
That's right.
Right.
Yes.
And then it was 11 months later, which would have been sometime in 2014, is it?
Yes.
When the CMS ruled in your favor.
Yes.
And then you were then told that Discovery had lodged an appeal.
Yes.
Did anyone indicate to you how long it would take?
No, and I did ask that question. I emailed, I'm not sure if you have these, and if I need, but I emailed Mr. Ports every few months, I mean, I still do, to say, what's our next step, what's our next recourse, and how long.
No one
But
told you.
nobody answers.
Right. No. But it was only on the 15th of July last year, I think it was, when you were finally told that that Discovery had decided not to pursue its appeal. Was that it?
Yeah. Yes, just prior to that, we received a notification that the hearing of the appeal had been set down, and that.
No, yes, I understand. You didn't receive the notification, and there was,
Yes.
there was correspondence from Dr. Bloomberg, which was to the effect that the appeal shouldn't have been set down, as I understand it, right?
Yes.
But it was on the 15th of July that you received this notification
That had been dropped, yes.
that it been dropped. Now, did anyone indicate to you what's going to happen thereafter?
You mean from CMS side?
Mm-hmm.
No.
Yes.
No. I have asked.
Yeah. Okay. Now,
There was only that one time, because I was copying them in on all the correspondence with Dr. Bloomberg, and there is one email, I think it's in August, late August that year, where Mr. Port said, clearly the parties can't reach an understanding, so we will have to reopen the case.
mm-hmm. Yeah.
I've since written a few times to say when do you intend reopening the case and what needs to happen, but not had response.
Yeah. If this is not the position, please say so. Now, do I understand your concern, or your desire to have the names of the specialists who advise Discovery published as being your dissatisfaction with the way they dealt with your case, so that if necessary, you can have them reported to the council?
That was one thing, and if I can just clarify, I'm not asking for their names to be published, I'm asking for their names to be made available to those people whose cases they're reviewing, which
Yes,
I think is...
yeah.
And I would have liked to have been able to make contact with them. I would have liked to have asked them to examine my daughter.
Yes.
But, you know, the laying of the complaint is one issue. But it felt, why should the practitioners have access to them and not the patients? And even the practitioners, it's very limited access.
Presumably, they would have relied on the reports filed by your physicians.
Yeah. You know, I didn't share those actual reports as part because of Jessica's confidentiality, and it felt like a line to cross. But I'd read all those reports, and it didn't seem to me like the medical panel was taking anything from those reports into account.
Yes. Okay. Now, if I may ask you, Jessica, some questions. Now, at the time when you took out the medical aid, did you fully understand what you were entitled to and what you were not entitled to?
I thought I did, but I suppose I didn't.
Yeah.
It all seems like I was so naive now. I thought I was entitled to emergency care. And although I don't think I understood about prescribed minimum benefits at the time, when I took out the policy, or is it called a policy, whatever it's called, you know, I have since learned that I should have been, that I was entitled to that, to the rehab treatment and stuff. I didn't know that at the time that I joined Discovery, because I didn't really think that I would ever need to know. I suppose I didn't think I'd ever be in a car accident.
Well, assuming you thought at the time that you might need that, would you have paid more attention?
Perhaps, but as I said, I definitely, I mean, we're talking many years and a brain injury ago, so I can't say that I remember every meeting with the broker, but I certainly, I didn't just sign the paper, you know, I did read what the benefits were, and I thought they were more than enough for someone who didn't have any illnesses, wasn't involved in any extreme sport or anything. You know, I didn't have any reason to think I would have any kind of crazy claims to make. So I certainly read what information was available to me.
You know, let me tell you why I'm asking you this question. You see, some of the consumers, you know, have told us that invariably they come to know of what is and isn't covered by their medical aid when there is an occurrence requiring coverage. That's when, for the first time, they become aware.
Yes.
And what I would be interested to know two things. Firstly, whether at the time when you take these medical aid, does anyone, or your broker, or the agent, or whoever, you know, talks to you about this, explain to you fully what is or isn't? I understand the excitement of taking a medical fund and the hurry to sign on the dotted line on the assumption that this will never occur to me, I just need this. And paying less attention to the details. That's one thing. But it is another whether or not any explanation was given to you at the time.
Yes.
And if you do not recall, it's okay.
Thank you for explaining. Because I suppose I was getting distracted by feeling like I should have made more of an effort. No. I definitely agree that, my experience was also that I only found out what was available when I really needed it. And even then, I didn't find out about the PMBs from Discovery. So I don't mean to sound dramatic, but I would go so far as to say they concealed from me that I actually had access to many more benefits. And again, as I say, had I not had a mom to chase them on that for me, I would have just gone, oh, well, I can't afford treatment.
I mean, you can sound dramatic. You are a drama student.
Oh,
anyway.
well, thank you.
Okay. But, I mean, when you reflect now, when you look back at the time when you take out these funds or scheme, is there anything that you would suggest should have been done which would have made sure that at least you pay attention, not necessarily at the time when you sign this, but subsequent to that, so that at least you know fully what is covered and what is not?
Certainly the PMB issue, and some explanation of what that meant, specifically around the fact that the legislation covers not only limited treatment, but the diagnosis, the treatment, and that the treatment is until such time as a patient reaches a plateau. So, I mean, the reason I've sort of, from my experience of this, bring up those particular things is, as my mom mentioned, Discovery refused to pay for a practitioner who needed to diagnose. They said, oh, well, she didn't find anything, so we didn't need to pay for her. But the session with her was prescribed by a specialist who said, we need to rule out this issue. So obviously, as far as I understand it, the legislation covers that. And also, particularly the issue of that patients should be treated until they reach their pre-morbid function or as close to that as they possibly can, and that only when their treating specialists say that's as far as we can go, then the medical aid is no longer responsible. It would have made the world of difference to me if that had been explained.
Now, the initial broker, for how long did you remain with that broker before you got another one?
I can't remember when I first joined them. Was I in the first year?
I think so.
I think that I joined Discovery and therefore was with that broker in 2009. Mm-hmm. And I stayed with them until 2012 but I never used I never used them. I never claimed. So I changed brokers only once all this started, and as my mom said, we were recommended to join PBSC.
Now, from 2009 to 2012, did you ever have any contract with your broker?
Not that I recall.
Did he ever send you any information, brochure, latest information, or anything of the sort?
The only thing that I remember was a copy of the sort of membership join-up, which I remember meeting him at a coffee shop to sign, and then I think he sent me a scanned copy of that.
That was at the time when you joined?
When I joined.
That was in 2009, is it?
I think so.
Yeah. But subsequent to that, you didn't have any contact with him?
Not that I recall.
Not that you can recall?
Not even price increases.
Yeah.
Perhaps, I don't know. I could check. I'm very bad at deleting old emails, so I probably still have any correspondence if there was any.
Yes, I understand. And that broker, who referred you to that broker?
As I recall, my stepmother's sister.
Yeah.
It's just a family.
So it was a family. I understand.
And,
Yes, understand. And then the subsequent ones, how did you find those out?
How did we find them? I wasn't really involved.
That was me, and as I mentioned to Professor Van, one of the practitioners of the one physiotherapist told me that this person was very committed to helping with PMV issues. She's a neurophysiotherapist, so she obviously knows the brain injury very well and has educated herself about the medical aid issues.
And is she a broker?
No. She
she's
said
the one.
that she described this particular broker as a unique broker in that he was committed to helping with claims.
Yes.
More than...
I understand, yes.
May I say that also, because obviously at the time when Jessica joined the medical aid, she is somebody who phones her mother for advice a lot. And I remember very clearly saying to her, I'm really worried that what's behind all this vitality, because that was what she was excited about. Yeah. And that is what drove her decision.
I'm ashamed to admit.
No, I'm not blaming you.
No,
and I think that the marketing is very, very... There's a lot spent on marketing, and it's way beyond online.
And I mean, with regard to your earlier question, what did I know about them when I joined? What made me join? It was about that, about the gym contracts and the movie tickets.
And you would have asked a lot of questions about that, would you?
Sorry?
Did you ask a lot of questions about that?
At the time, yes, I asked the broker.
In all probability, you would have done that.
Yes.
Yes, I understand. And less about what was the scope of the coverage.
Yeah.
Okay, yes. And did the conversation turn around the Vitality program with your broker?
There was a fair amount of conversation around that, yes.
Yeah, okay, very well. Okay, yeah. That's the end of my questions. I mean, is there anything that you'd like to add to what you've told us that perhaps you had set out to say but which you haven't had the opportunity to say?
Okay.
Sorry, this has been such a drawn out and emotionally charged process that I do feel a sense of panic, like I better have gotten everything in. And it sort of feels like it becomes quite a cold, boring story when you just go through these endless lists, but I don't know if I can do justice to how overwhelming it is to have the experience of having put my trust for literally my life, my health, in a company that, as we said, claim to have paid me X amount of money, and then I look at my bank statements and the money just isn't there, and claim to have contacted my practitioners who, again, I've trusted with my life, and they individually, it's not like they were all in a room, they individually got phoned and all said, no, I haven't heard from Discovery. So just this experience of going, well, they're lying, but feeling like a very, very little man up against this Goliath, and feeling like because they have such a huge membership, I can feel how much they don't care, because I'm just one person. What's the worst that can happen from their point of view? I just leave. It's small change to them. So I hope we've covered that all and made it clear, and it really is an honor to at last have a chance to speak to that story, and hope that it isn't just about us, that all the people we've come into contact with along the way through the Facebook group and through the people I met in hospital, that this can have benefit for them too.
By the way, do you get information about the meetings of the members of the scheme?
Sorry?
Do you receive notification of meetings of the members of the scheme?
No. I think I have received the odd email about an AGM.
Right. And have you attended any of those meetings?
No, I haven't.
What makes you not to attend these meetings?
What makes me not attend?
Uh-huh. Maybe.
It's fine.
Maybe. Do you know what they're supposed to discuss?
No.
You haven't looked at the agenda, do you?
No, to be honest, most emails that I receive from Discovery, I just want to crawl under my bed and eat an ice cream because I get depressed.
Before that?
Before the accident. No, I don't think I had ever read any of the agendas of the agencies.
Well,
I don't, I'm obviously wrong. I had not assumed that they were for members' benefit. I had assumed that they were for the corporation's benefit.
Did you know that you could attend that meeting?
No. I mean, as I said, I've received emails, so I suppose I should have understood
You
that,
didn't
but
pay
I didn't understand that.
Okay. You didn't think that this was a notification addressed to you as a member, telling you of an annual general meeting of all the members of the medical aid scheme, where you can attend the meeting and raise whatever concern you have. You didn't know that, did you?
No, I didn't understand that.
Yeah. And were you ever told at the time when you joined that there will be those that you would be required to attend those meetings?
No, certainly not.
So when you received those notifications, you just thought that, well, this is just notification that the corporate scheme will be having a general meeting.
Yes.
And that you have nothing to do with that.
No.
Yes.
My experience has been, I've understood that I have no power.
I understand.
Except the power to pay my premiums.
Yeah, I understand. Is there anything else there? Yes?
Sorry, forgot the mic. Just to your earlier, the closing thing, like with Jess, I just want to say that today gave us a feeling of hope that somebody would hear us. So, we're very grateful for that. When I reread my presentation, I became aware that I'd focused on trickery as the basis and delaying tactics on the part of Discovery Health. And I wondered for the first time if this was just gross incompetence. And that was found even more frightening in a way. And I realized that I'd assumed that this organization is as slick as they portray themselves. I don't know what there's any meaning of that, but because that's not in the written thing, I just did want to mention that, that when you look at the details, yeah.
There's just one thing that just come to mind. Somewhere in this document that you sent to us, I remember seeing the name of Mr. Strick, unless it was some other document. Did you have...
sorry, I didn't hear you.
Mr. Strick.
Is that a name?
He's the principal officer of the medical aid of Discovery.
No, I didn't know that until I listened to his testimony here
Okay.
at the commission.
You'd never dealt with him before?
No.
Yeah, I understand. Thank you.
No.
Okay. Thank you for coming to share your story with us. And thank you. We will look at the recommendations that you've made. And thank you so much indeed.
Thank you for listening.
Thank you for your time.
Thank you.
So, just to check, should I leave these attachments?
Someone from the technical team will come to you and get those attachments. Thank you.
Thank you.
Yes.
Is that mine? Let me just put it all together.
Is Mr. Kyle Thresher here? Thank you. If you could just state your full names just for the record.
Me?
Yes, sir.
Kyle Dean Drescher.
Yes. Okay. How old are you?
I'm 19 years old.
Yes. And you're going to speak for yourself, right?
Yeah.
Yes, indeed.
That's correct.
Yes. Now, you have prepared a written submission.
Yes.
For which would be the basis of your oral presentation to us.
Yeah.
There is an earlier one that you had sent in, and we received another one subsequently. Is it one and the same document?
No, it's...
Okay.
No.
So the earlier one is replaced by the
Yes.
subsequent one. So we should focus on the subsequent one.
Yeah.
Okay, very well. Do you want to go ahead and then tell
Yeah.
us what you want to tell us?
My name is Kyle Drescher. I'm 19 years old.
Yes.
I live with major depressive disorder. I completed my matric last year at Michael Oak Waldorf, where I received a bachelor's pass with 2 distinctions. I'm now currently a full-time student at City Varsity, studying for my diploma in professional photography. I live with my parents who have been married for 26 years. I am a shy, sensitive, and kind of introverted person. I do not abuse any drugs and only drink socially. In grade 11 at Constantia Waldorf School, I began to suffer from headaches and battle to sleep at night, waking up at 2 a.m. and not being able to get back to sleep. I began to feel more and more stressed, tired and anxious, as well as angry and depressed. In March of 2014, my mother took me to our old GP, where over a few weeks I saw 2 doctors, one who said I had depression. She gave me a prescription for antidepressants and sleeping pills. They also did blood tests and found that my iron levels were low, and I was given iron supplements for 2 months. I was not referred to a psychiatrist or psychologist, and no one said that I should go for any kind of therapy. By August 2014, I was feeling completely burnt out. We had started our matric syllabus to write at the end of 2015. I was feeling incredibly worse now, and my mother became worried for my health. So she closed her business to look after me. I woke up one day and decided I could not go back to school. I was angry, confused, depressed, and stressed out. My mother knew that this was a crisis. Our school counselor gave my mom the name of a psychiatrist, and I went to see her. After 2 sessions with the psychiatrist, I was diagnosed with major depressive disorder and anxiety disorder. She changed my medication. The next time I saw her, she told us she wanted to put me into hospital. This was not an ideal decision for me. My mom had already called our medical aid to find out if I had any cover for therapy, but they told her that I only had cover for therapy if I had bipolar disorder. But I could go to hospital for up to 3 weeks. We realized that hospital was the only option for me on our medical scheme, and we trusted my psychiatrist and our medical aid scheme. My parents paid for the psychiatrist, even though the correct code for major depressive disorder was on the account. Discovery never paid us back for the money my parents paid for my sessions out of their own pockets, except a small amount that they took from what was left in our medical savings account, and my mom says this is illegal. The psychiatrist admitted me to Kenilworth Clinic Adolescent Unit on the 22nd of September 2014. It was a locked-up facility with other teenagers who were much younger than me that had alcohol and drug problems. I had spent the night sharing a room with a gang member who had earlier told me how he stabbed someone as an initiation to enter a gang. As a result of this, I was terrified to fall asleep in case he may have harmed me. I also was required to attend a 12-step group, even though my only problem was that I had depression. I saw my psychiatrist only once or twice in the hospital, even though she charged us for 2 therapy sessions and 2 follow-up visits. I felt like a criminal being locked up in this facility. It felt like I was there as a punishment and not to get better. I had to get out of this facility. I told my psychiatrist this, and my parents fetched me the following day. Discovery paid for everything in the hospital without a problem. 2 days later, we saw a psychiatrist again. My mother asked her if she was sure that I was not bipolar, and she was certain I wasn't. She mentioned Discovery only pays for therapy for bipolar, but not depression. I saw her twice more, once in October and once in November, and my parents paid for these sessions too. And I've attached papers saying how they paid for these bills. She then suggested I see a psychologist and referred me to one. I began to see Martine from the 4th of November 2014, every week, for the whole of 2015. I still see her, but now I go every second week so that I can manage my depression. I still currently take my medication. I refused to go back to school. Just the thought gave me a panic attack, and I stayed home the whole of the 3rd term in 2014. I basically stayed in my room and was inactive. I was starting to feel a bit better by the start of the 4th term. My medication was working properly, and my mom forced me to go back to matric and finish school. With this decision she made, I was furious at her, and I hated her so much. She suggested I go to Michael Oak, where I attended from class 7 to class 10. As their pioneer matric was only 7 pupils, I'd been with them before. I started Michael Oak in the last term of 2014. I changed all of my stressful academic subjects for more practical and less stressful ones. I began to play golf again. My mother would take me to Westlake Golf Club, where we'd have a coffee after school before my therapy session each week. I went back to gym. With the medication, therapy, and exercise, I began to get better, although the sleeping still took many months to improve. In December, just before we went on a holiday, my dad was phoned one night by his diabetic specialist, who said he must go to hospital immediately, saying that he has a life-threatening emergency, and gave him the code E87.1. My father is a type 1 diabetic, and when they did his blood test, they found his sodium levels to be extremely low. My dad's specialist was actually on holiday, and we had to find another doctor at short notice during the December holidays. My dad phoned Discovery for authorization, but they said no, E87.1 is not an emergency code, even though the PMB list calls it as a life-threatening condition. And they said he must phone back in the morning. My mom was really worried, so she went to the computer and researched E87.1 and saw it was called hyponatremia. She then looked up hyponatremia and found a 343-page list of 270 sicknesses called prescribed minimum benefits, part of the Medical Schemes Act. She was up the whole night studying this list and found also under mental illnesses, major affective disorder. She then looked up affective disorder and found mood disorders such as depression. On the list, it said that all treatment was either 21 days in hospital or 15 sessions of therapy. She also read that all emergencies are PMBs. When we got up, she had told us what she'd found and was furious, tired, and upset, as well as having to take my dad to hospital. With being a type 1 diabetic, he sometimes goes into comas when his sugar gets too low, but thankfully we have local paramedics who treat him at our home. He spent 2 days in hospital. They had to slowly bring his salt levels up and do lots of tests such as brain scans, CTs, MRI scans, and blood tests to see what was causing the hyponatremia, including checking his brain for swelling, his lungs for cancer, and his kidneys to see if they were damaged from his diabetes. We were devastated and worried. They found that it was a condition called SIADH, and my dad has to have salt tablets and very limited liquids to drink for the rest of his life. My mom carried on investigating his PMBs until we went on holiday, and also phoned Discovery a few times about depression cover, and they sent her the PMB application form for me and my dad. While on holiday, my sister's best school friend was stabbed to death, Tembi, who would usually stay at our house a lot, and we saw him as family. We were all devastated. When we got home, my mother began a 7-month battle to get our PMBs and claims approved by Discovery. But they were saying that my dad's sickness was not an emergency because he was not rushed to hospital. But they were the ones who said he could not go. She was still trying to get our money back for my therapy, the diagnosis of my depression, my dad's blood tests, his specialist bills, all the money we had spent on PMBs. She was always on the phone to Discovery, and they made her furious and upset. She began to get ill, and my dad had to take her to our doctor. From January to March 2015, 55 of her calls were logged at Discovery, and many phone calls shown on our bill were not logged at Discovery. But she refused to give up, even though it was affecting her health so badly. She hardly ate or slept. Her obsession made me angry at her, and we had some really big arguments because the only thing she ever spoke about around the household was Discovery. She was on the phone all day to Discovery, to all our doctors, pharmacies, the Council of Medical Schemes, even the government. She was on the computer all night, writing hundreds of emails, trying to get our money back and our cover approved. She tried to get a broker to help, and she and my dad even went to Discovery's offices, but they messed up the situation even more. I could see that she was trying not to fall apart, but I had my own depression and stress to deal with, as well as matric work. I nearly went to go stay with my sister in March, as my mom had broken down and her doctor wanted to put her into hospital. My mom was also seeing a therapist, and she begged the doctor to let her stay at home. Her therapist prescribed her stronger tablets, which again Discovery would not cover either. She then wrote a complaint on Hello Peter's website, where Discovery Health got 2,100 complaints over the past year, and was contacted by Mr. Singh, a caring and helpful man from Discovery Health, and within a few weeks, the therapy money for my 15 sessions per year had been paid back to my dad. but it still took until the 22nd of July for Discovery to approve my father's blood tests and salt tablets. They had only approved the salt tablets when my mom told Discovery that my dad was threatening to stop taking them, since they did not think that the salt tablets were necessary or in the basket of care, and that they could expect him in hospital again in a week. They approved the tablets the very next day. It was finally all over. We had got all the cover and all the money back that my mom had fought for. It was a lot of money, and my parents wanted to use it to pay for my therapy once the 15 PMB sessions were used up, as my parents paid for 8 months of weekly therapy after the PMB benefit was used up. Why did my family, especially my mom, have to go through such trauma and sickness to get medical benefits paid for that we pay for and were supposed to get by law? Why did our doctors not know or tell us about these benefits? Why did Discovery's Health's computers not pick up these ICD-10 codes that identify these PMB sicknesses and call us to explain the PMBs and tell us how to apply for them? It's hard enough to get well again or look after family members who are sick and that need a lot of time and strength. The months of stress in our household caused by Discovery made it so hard for my dad and I to concentrate on getting better, and it nearly put my mother in hospital as well. Luckily, my parents could afford to pay for my therapy of 2,400 Rand per month, so every week my psychologist and I could help deal with the chaos at home caused by Discovery. Discovery only paid for 15 sessions up to the end of April. My parents paid for the rest of the year. It was the same with my mom's therapy. Without all the therapy for the year, we would never have made it to where we are today. I know that most families can't afford to pay 650 Rand for 50 minutes of therapy, but why would Discovery be so happy to pay over 100,000 Rand for 3 weeks in hospital with therapy and medicine every day in hospital, but will only pay 9,000 Rand every year for private therapy? I know I would not have been able to do so well at school, go to varsity, and have become so close again to my family if I had not seen Martine, my therapist, every week. I know of other teenagers who have depression, and my mom and I both wonder if they know about the 15 sessions of therapy. Most of the doctors and therapists don't know or don't tell you. When I read about a 14 or 13-year-old that committed suicide, there were 2 or 3 in Cape Town last year from top schools. I wonder if their parents knew that they could have got therapy. My mom and I were looking at the benefits for mental illnesses on the PMB list. Out of 343 pages of all PMBs, 80 of these pages, or 1,600 codes, are of ways to commit suicide. There are only 26 codes for depression and bipolar disorder, and none for anxiety disorder or other mental illnesses. This does not make sense. Surely it's better to treat mental illness before the person tries to commit suicide. I know that some teenagers do need to go to hospital, especially if they have addiction or weight problems or cutting themselves. But those who are like me with clinical depression could maybe do better at home, seeing a therapist every week. But I feel 15 sessions is not enough to help someone with depression, especially a teenager who is still young and vulnerable and learning about life and how to cope with stress, peer pressure, temptation, and depression. If medical aids are forced by law to pay over 100,000 rand for 3 weeks in a clinic, why can't they be forced to pay for weekly therapy for a whole year instead, which would only cost around 30,000 rand? I know that I may have to live with this illness my whole life, but I know now how to deal with this illness, and I'm aware of the treatments available. Every year I'll learn more about how to deal with cope, and I'll learn how to deal and cope with my depression so that it will never take over my life again. While watching the Discovery people talk at the hearing, my mom noticed they showed a chart that says they receive 35,000 phone calls every day. My mom showed me a financial statement which showed figures of 50,000 phone calls every day. And Dr. Johnny Broomberg had sent my mom a message on Facebook to tell her to stop telling people to complain on Hello Peter. In that message, he mentions that they receive 100,000 phone calls every day. How can we believe any of the numbers they have shown at the hearing if they either don't know their facts straight or they're lying? I have attached papers and messages from Discovery with these different numbers on them. Thank you for giving me the opportunity to speak at this hearing. I hope my story will make a difference in the lives of other teenagers and parents and other people living with major depression. My mom still currently spends a lot of her time helping people with PMBs using all the research she has done.
The document that you are referring to, which you are attaching, it's a media released by Discovery Health Medical Scheme, which is with the heading Discovery Health Medical Scheme delivers strong performance for 2014. Is that the document that you're referring to?
Yeah.
Okay. We shall include this document as part of your presentation and would mark it KDD1. Yes, thank you. My colleagues are going to put questions to you to clarify any matter that they may want to clarify. Do you understand that?
Yes.
Thank you.
Carl. I was just the first to speak, so. Thank you very much for your presentation. Courageous to sit there and tell your story. We heard your story already before, of course, because your mother presented to us the whole story. In the first submission that we had, the first presentation always is very clear on your mind, of course, of the whole series of presentations that we had. So we heard the facts of what happened to you, to your father, to your mother, and your mother's struggle with getting the bills paid with Discovery. So don't have any more questions. I think it's quite clear to me what happened. Nevertheless, so I have no questions here. Nevertheless, I think you did well to present it from your perspective here. It's very good to hear what it does to you if you see your parents struggle. Thank you very much.
Thank you.
Hi, Carl. Similarly to Case, I remember Mr. Richard on our first set of hearings. And thank you very much for sharing the story from your perspective and giving us a detailed picture of what it is like to live with depression and to have the experiences that you've had with interacting with the medical scheme and also observing your mother interact with the scheme.
Yes. Professor Fong.
I just want to clarify one point that you, I think, are recommending, and that is that it might be cost effective for medical schemes to think through an alternative between inpatient care and out-of-patient care, and that could even be cost-saving for them to provide out-of-patient care. Is that one of your recommendations?
Yes. Yeah.
Thanks.
Thank you very much for coming out to present your story. It is noted, and the one point that I really wanted to say specifically is about the mental health benefits in what Prof. Fawn has referred to, and of course the question of the number of days on an outpatient basis. That's noted. Thanks, I have no question.
Yeah, the initial submission that you made to us had a number of attachments, and you did not refer to those attachments. Should they form part of your? They should form part of it.
Yeah.
Yes. Okay. Well. Shall we go through those attachments and just make sure that they form part of your testimony? There is a first document which it's not clear what the heading is, but there is some writing here which says significant investment in human capital.
It's showing the amount of calls which Discovery receives per day, stated on there.
That's 35,000.
Yeah, 35,000.
Okay. Very well. And
Can I say that is what was presented to the Commission, if I may?
yes, I understand that. Can we then mark this document KDD2? And then the next document has a heading, Johnny Broomberg.
This is a personal message sent by Johnny Broomberg to my mom.
Yeah.
And in it states that Discovery deals with 100,000 calls a day and that they resolve 80% of these calls immediately.
Yes. Okay, and then shall we then mark this document KDD3? The next document has already been entered in the record. That's KDD1, which is immediately released. Is that right?
Yeah.
Yes.
Yeah. Okay.
That's where they refer to 50,000 calls a day.
Yes. And then the next document is a 2-page document which is headed Discovery Health Complaints.
Hello, Peter.
Oh, is this? Oh,
These
this
are
is
the
yes.
complaints from.
So this is a hellopeter.com record.
That's 2 pages of a 70-page list of 2,100 complaints that they received last year,
Yeah.
including many about PMBs being paid from medical savings accounts.
Yes. Now, but you've only attached 2 pages of that.
Yeah.
Okay. Shall we mark that? I've lost. What is the next thing? What is that KDD? What was the number? 4. 4. Okay. And then the next document.
Then the rest of these documents are invoices which show my billing for my psychiatrist, which had been paid through my father's own
medical savings account.
From his medical savings account.
The reason that we included it is because the practice code, treatment code, and ICD-10 code F32.2 clearly indicated as being a PNB. And Discovery said that they had implemented the code of conduct. So my question is, why did this then not flag as a PNB, as it was supposed to in the code of conduct?
Yes.
And then why, on the following pages, which is a statement of how they processed the claim, were all these PNBs paid from, as it states here, our medical savings account?
Well, when you say following page, what page are you?
Okay, so now we go, there are 2 pages from the psychiatrist. I don't want to mention her name.
Okay, well, I'll tell you what. Why don't we go this in sequence? This document, which is from Dr. Laura Comrie.
Yeah.
Shall we mark that KDD5?
You can.
Right. And
That's 2 pages.
That's 2 pages. And then this is followed by a tax invoice.
Yes, from Carl's psychologist, Martine.
Yes, right. Crook, is that right?
Martine Casson-Crook.
Yes. Okay, shall we mark that KDD 6? And then that's followed by an email.
Okay, this email is actually to Kate Kagazi at the Council for Medical Schemes.
Yeah.
We attached an email from Discovery showing that the claims for the PNB for Dr. Comrie and Dr. Martine Casson-Crook were paid, if you go on to the 3rd page, 800 Rand from our medical savings account, and the last page, 2,400 Rand from our medical savings account in contravention of Regulation 10.6 of the Medical Schemes Act.
Yes.
Which
Okay.
indicates it should be
Sorry,
paid from the risk pool.
Yes, it should be paid from the risk pool. That's why I put it in there specifically.
This document, where does it end? There are 2 other documents which are very difficult to read.
Yeah, they are very difficult. It's an issue that I've come up with on the Discovery web page, is that their print is in a very fine light grey or blue, and it does not print very well.
Yeah.
It's actually an issue because you can't, it's very difficult to put anything on Discovery's website into hard copy.
Yes. Now, this email, does it consist of 1, 2,
3, 4 pages?
4 pages.
Yes.
Okay. Can we mark? Shall we mark that KDD7?
Yes.
Is it possible to get clearer copies so that at least we can read them? Because otherwise, as I stand at the moment, it's difficult to read.
What I'll do is I'll have colour copies printed.
But
we just don't have a colour copier, but I'll have colour copies printed and I'll send those to you.
But the point in including this is simply to illustrate that these invoices were paid from the medical savings account, something that should not have been done. That's what you're saying, yes?
Specifically, with the invoices showing the code F32.2, which is the ICD-10 code for the PMB major depressive disorder.
Yes. Okay.
So again, it was just another illustration that where it had been stated that the code of conduct has been implemented in full. Firstly, this didn't flag, and secondly, it was paid from the medical savings account. This is one of a pile of bills, but I just thought I'd put a few on as an example.
Yes. Okay. I understand. Now, is there any document that I haven't referred to which should form part of your submission?
So there was a document that I sent through with the last transmission, possibly to Pamela, which includes my correspondence to the Council for Medical Schemes and Cassie Chambers at South African Depression and Anxiety Group, just from about January, March last year, just setting out
And when was that document sent?
A couple of days ago, yeah. It's an attachment to to the submission before this. So I can,
Well,
I'm sure Pamela Halser could give that to you.
Well, the annexures that have just been referring to, these are annexures which appear to the original submission that you made.
Yes.
So,
and it's just a couple of hundreds of emails, literally, just one or two, just explaining what I was writing in these 2-3 page emails to the Council for Medical Schemes, to ANWIS at the Department of Health, to Discovery, trying to get some kind of resolution on this issue.
yeah, so is it? So there's an additional document that's not here, and is that an email messages?
Yes, they are. They're copies of emails that I sent. Yes.
Okay. And these emails reflects a correspondence between you and the Council for Medical Schemes and who else?
South African Depression and Anxiety Group.
Okay.
Because I was phoning Cassie Chambers to see if I could get any help from her.
Yes. Okay. Very well.
I can add those in. Well. Can I just please mention something, if I may?
Is it in connection with these annexures?
No.
Okay, please. Okay, well, can we finish this first, and then we'll come back to what you want to say.
Sure.
So those email messages which you have attached to the original submissions, we will then mark them KDD 8.
Okay. Correct.
Okay. Someone will please make sure that we have those. Copies of email messages.
Yeah.
Yes. What did you want to say?
Okay. It's just something that came up in Cheryl Naransky and Jessica's presentation about the claim made by Dr. Johnny Brumberg that patients or members are only reading about their rights or benefits at the time when they need them. Now, the 2015 Discovery Health brochure, prescribed minimum benefits are first mentioned on page 23 of a 32-page document. It's a paragraph of about 2 lines. And then again on 25, it's a paragraph of about 4 lines. Chronics are right up on page 2, but the PMBs they're actually a non-issue in the brochure and the booklet for 2015. Through last year and all my negotiations and stirrings and whatever I've done, Discovery's booklet for this year is an 80-page document. PMBs are now on page 6, and they take a full page. In addition to that, at my request, under mental health, they have included the option of the 15 out-of-hospital therapy sessions for prescribed minimum benefits. So just that in itself is a progress made, certainly regarding people reading about prescribed minimum benefits, because they're now one of the first things mentioned in the brochure. And then the mental health issue. I've also asked them to include the prescribed minimum benefit for postnatal depression, which is in Latin, and include it with the pregnancy benefits, so that if somebody falls pregnant and they're looking through the pregnancy benefits, they will see that there is a PMB for postnatal depression, and if they ever need to use it, because it's called severe behavioral and mental disorders of the puerperum. And when you're in the midst of postnatal depression, that means absolutely nothing to you.
Yes. Okay, very well.
Thank you.
We have not been given copies of those brochures.
They were, I think, in my submission.
When? Subsequent to the hearing. Yeah, okay.
Well, I can send those through.
No, yes, I'm told
Yeah.
they gave us last week.
Again, there is this issue of
Yeah.
the difficulty with being able to put Discovery Health's anything on their website into hard copy because of the color problem. I'm also in negotiations with the head of the telephone department, the guy who runs the call center and the telephones, who is testing out cell phones other than smartphones and their ability to actually call the toll-free number.
Yeah.
Because they can't.
Yeah.
And he is busy investigating that at the moment. So I am trying to work with them and cooperate in trying to make things a little bit more accessible to the consumers.
Yes, very well. Is there, yes,
Carl's session.
Mr. Treasurer, is there anything that you'd like to add to what you have told us?
No, not that. Everything that I wanted to address has been addressed. Thank you.
Okay, very well. Thank you for coming to us and sharing your personal story with us. We really appreciate it. Thank you so much indeed. Thank you.
Thank you.
Yeah.
Thank you very much. Sorry, could I ask that we be excused so I can get Carl back to university?
By all means, yes. Thank you. You are excused. Thank you so much.
Thank you. Thank you very much.
Yes, thank you. Thank you.
Thank you very much.
Thank you very much indeed. Thank you. Okay. Now, okay. The next presenter is the Council for Medical Schemes. Are you ready? Is the Council for Medical Schemes here? Could you please come forward, please? Yes. Okay. We are running somewhat late, and we are. I wonder if at this stage, whether it would be convenient for you for us to take a tea break now. Yes. Okay.
Yes. Thank you, Chair.
And then can we take a tea break and perhaps come back at 11:30? Yes? Thank you. Okay, very well. Are we ready to start?
Yes, Chair.
Yes, very well. I think if you could just indicate to us who is the leader of the panel and how you propose to make your presentation, and also just for the record, if you could place your name on the record indicating who's part of the panel.
Thank you, Honorable Chair.
Yes.
The leader of the delegation. I'm Dan Lihucho.
Yeah.
I'm the acting registrar at the Council for Medical Aid Schemes. I'm going to be dealing with about 20 slides in this presentation, and my colleague, Paresh Prema, will be dealing with the rest of the presentation. He is the general manager in the Benefit Management Unit. And another panel member here is Anton de Villiers. He's the general manager in our Research and Monitoring Unit. And on my immediate right, I've got Nondumiso Kumalo. Yeah. She's also a senior researcher in our in the Research and Monitoring Unit.
Yes. I think what would be helpful is when it's the term of each of your panel members to make a presentation, if the member could just place himself or herself on the record so that at least we know who we're dealing with.
Thank you, Honorable.
Yeah. And then sometimes it might just be helpful for those who are transcribing these proceedings to spell your name just in case, so that we make sure that we've got the names right.
Okay. I said my name is Dan Lihucho, or Daniel Dan for the short name. My surname Lehuto.
Lehu TJO. And how do you pronounce this name?
Lihucho.
Lihucho.
Yes.
Okay.
Yes.
Very well. Thank you so much indeed. So you're going to lead. You're going to start.
Yes. Sure.
Very well. So if the rest of the panel can do the same, when it's their turn to start.
Okay.
Yes. Very well indeed.
Okay.
Yeah. Now, there are a couple of housekeeping matters that I need to deal with. First of all, it's been drawn to my attention that the next presenter, that is the Allied Health Professions Council of South Africa, they've got severe time constraints, and they do have to fly back, around about 2:30, I think it is the first one. So what that means is that we need to focus on the issues that matter for the purposes of this inquiry. Understand that? Yes. The other issue is, what are we working on? Now, I just want to make sure that we've got two documents that have been sent to us. The one came in this morning or yesterday evening. The one document, it's a slide presentation. Okay, is that a replacement of what you sent to us, previously?
Yes, I think we're working on the ones that we submitted yesterday. Not yes.
Okay, very well. So we should remove the first one and then work on this one. Okay, and then you've also presented to us an evaluation of contribution increase assumptions for 2012, a document which indicates that the contract person is Nondumiso Kumalo. Is that part of your document as well? Very well. And then in addition to those documents, there are comments on competition marketing inquiry where you respond to what you have described as inaccurate statements by other stakeholders. Is that right?
Yes, Chair.
Very well. And then there is the next document are your comments on the draft statement of issues, which was published in May 2014.
Yes, Chair.
Right. Now, is there any other document which should form part of this, which I haven't, excepting for the last document that is here, which is the annual report for 2015 and 2014, 2015? Is there any other document?
No, Chair. Those will be our documents.
Okay. Okay, very well. I think we should. This annual report has not previously been sent to us, is that right? And the document by non-domicile has not previously been sent to us.
Although, Judge, it was given to your technical task team members.
Yes, I understand.
Yes.
That. Okay. But you want to form the basis of this presentation? Okay. The other documents, of course, we do have that on record, your responses. Okay, yes. Very well. So I just want to make sure that we don't lose this document we as forming part of your record. So you will be who will be introducing this document? The main speaker, presumably. Is that right?
Yes, I think we'll be referring to those documents in our presentations.
Yes.
In the main, Paresh will be talking to those documents.
Okay.
Yes.
Well, for the purposes of this record, then can we do this? Can we mark the document titled "Evaluation of Contribution Increase Assumptions for 2012"? Can we mark that document DL1? And then the annual report 2014-2015 as DL2. And then perhaps the main presentation, we can simply mark that DL3, which is the slides that you're going to present to us. Okay, very well. Can you then, are you ready to proceed? Yes, very well. Thank you.
Thank you, Chair.
Yes.
Thank you, Chairperson.
Yes.
We've taken note of the issues that were raised by just the presenters before us, and indeed they're concerning to us. And also that they highlight a number of issues in as far as we are concerned, the whole issue of the PMB legislation, the role of the brokers in this environment, and our complaints process, our appeals processes, member education, and communication between the CMS and the patients. In our presentation, we are going to try to cover this. I think we're making reference to our complaints process. I think we'll be able to answer these questions as well as the brokers. And of course, the PMB issue is a serious matter for the industry. Just as a start, we're going to be dealing with the overview of these introductory remarks, our regulatory features and concerns, the challenges in our regulation environment, as well as, I think, in conclusion, we're making some recommendations. As a start, we want to define ourselves as the Council for Medical Scheme being a statutory body established in terms of the Medical Schemes Act, which provides regulatory supervision to the private healthcare financing through medical aid schemes. As we are a public entity under the Public Finance Management Act, but we are responsible for the accreditation of regulated entities such as the medical aid schemes, managed care entities, and administrators, as well as brokers. The council is managed by a board of about 15 members, the council being appointed by the minister from various disciplines: medicine, actuarial sciences, accounting, law, and the civil movement. These council members then report to the minister, and the registrar as well is appointed by the minister. The council functions are conferred in terms of Section 7 of the Act, which include, amongst others, the protection of the beneficiaries, which is of very, very significance to us. We also are charged with the responsibility of managing the affairs and functioning of medical aid schemes. We make recommendations to the minister on the criteria for the measurement of quality and outcomes. We investigate and resolve complaints, which is what we've just said now. We also collect and disseminate information about our private health care, which is what is contained in our annual report, Chairperson. And we advise the minister on any matter concerning medical aid scheme and perform any other function that may be conferred by the minister in terms of this act. In terms of the act itself, there are about 4 pillars of this act which we rely on in pursuit of the protection of our beneficiaries, being open enrollment, community rating, and the PMBs, as well as the governance of medical aid schemes. In terms of our own internal operations, the CMS, we are funded through the levies from medical aid schemes. We are just projecting how the levies that we collect from medical aid scheme grew over the last 5 years or so. As you can see, in 2010-2011, we only charged principal members per annum 18.29 rand, and today, in the financial year 2016-17, we've proposed a levy amount of only 32.53 rand per principal member per year. And we're bringing this, Chairperson, just to indicate that if you compare that, what we collect with what the industry is collecting of 140 billion, it's a very small amount of less than 0.1%. And we're supposed to be regulating this massive industry. And we only have a staff complement of about 106 personnel, which are situated only in our head office in Pretoria. We only have one office in Pretoria. This slide shows the various role players in our regulatory environment. On the left-hand side here, we show in the supply side, which is the delivery side, our healthcare providers, which we do not regulate, and which include your private hospitals and public hospitals, as well as GSP and non-GSP entities. On the other side, we have the financing side, which we have a serious role to play there. At the center of that, we have got the medical aid scheme. The medical aid scheme there, whom we've indicated that every medical aid scheme in the country is registered by ourselves. And we also have got managed care managed care entities also, they are accredited by ourselves. And up there, we've got our administrators. We also have got brokers. We've indicated they're also accredited by us. And more importantly, this is our important person, the beneficiary, being the principal member as well as the dependents of the principal member. The red lines, as you can see, it shows the flow of funds between these entities. Managed care entities do contract with the supply side, the healthcare providers. Medical aid scheme as well, there's a flow of funds between the healthcare providers as well as medical aid schemes. Medical aid scheme as well do pay the brokers at this point in time for the services that they are rendering, and also they do pay services for the managed care entities for the services they are rendering, as well as paying also the administrators. The beneficiary, being the principal member, pay a premium on a monthly basis to the medical aid scheme for the cover that they enjoy. We have demonstrated our regulatory interaction there as the Council for Medical Schemes. We are accrediting the brokers, and there are also other entities like the Board of Healthcare Funders, which also interact with the medical aid schemes and the managed care entities. I think we just want to demonstrate the relationship that exists between these various entities in our environment. An important aspect also of our regulatory function is the governance of medical aid schemes. In terms of the governance, the Board of Trustees are responsible for overseeing the affairs of the medical aid scheme. They must also appoint a principal officer who acts as a chief executive officer. And in terms of good governance requirements, they must have other committees like your audit committees, other committees, investment committees, your HR committees, and the like. And I think we obviously are saying that schemes do not exist without members. The members are there so that a scheme exists. And this Board of Trustees are charged with fiduciary responsibilities to manage the affairs of a medical aid scheme. The Board of Trustees are elected, 50% of the Board of Trustees are elected by members in a general meeting. And in this election, the BOT do not have to have some specific qualifications, but they just have to be members of a medical aid scheme to be able to be elected in these positions. BAT, as I've indicated, have got a fiduciary responsibility to manage the affairs of the scheme in the best interest of the members. And the election process is dealt with in terms of Section 57 of our Act. Now, the challenges we've noted in our experience in regulating this environment over the years is that we often get to put schemes under curatorship because we have been made aware of some irregularity governance concerns that are there in the scheme. And when that happens, we remove trustees in terms of Section 46 of our Act and place a scheme under curatorship. This is an interim arrangement until such time that a scheme goes back to be governed by a Board of Trustees. That's why what we normally do, sorry. Why we always place schemes under curatorship is because we have been made aware of some irregularities that exist in schemes or poor management in that regard. But I think we must also make an emphasis here that schemes are not necessarily in poor financial state as we put them under curatorship. It's just because we've been made aware of some irregularities of governance in those schemes. But through these interventions, we have seen that scheme successfully convene good elections and put schemes back in the Board of Trustee governance. And we have seen governance improving over the years. I think we're indicating that since 2001, we've put about 11 schemes under curatorship, and I think this extends to a period of about 14 years to date. We've started to be actively engaged in reviewing the AGMs and attendance of these AGMs by members of medical aid schemes. We call on for schemes to issue us with their agenda, the location of this, where these AGMs will be taking place, and member participation and attendance, which is very poor. Our experience have shown that member participation in the affairs of scheme and attendance is very poor and is concerning. We also are looking into the distribution of materials that are going to be dealt with in the AGM in terms of the language and the complexity of these documents, as well as the cost of holding those AGMs, because this is very important. The scheme membership must go to risk financing, not only to the cost of holding these AGMs. As part of our governance processes, we've provided guidance to medical team regarding trustee remuneration. Trustee remuneration has been an issue. We've been attending these sessions. Last week we've had schemes, we've had people complaining about the trustee remuneration. Our annual report will show you that we've got about some schemes that are paying some trustee remuneration. And you look at the membership of the scheme, it's not very commensurate with that level of payment. Also, the fees paid to our principal officers, our chief executive officers, contribute to what we call non-healthcare costs in our environment. We've also are disclosing that in our annual report. We've introduced a governance and compliance instrument last year so that schemes can also look into a self-evaluation exercise for completeness and diligence, the evidence proficiency in the use of the outcome, as well as transparency. This circular or this instrument, schemes will advise us of the composition of the board, whether all the committees exist, and once they've done this self-evaluation, they can see the results almost immediately, and they get sent to us, and we evaluate that ourselves as well. Also as a quest to promote governance in medical aid, we do conduct some trustee training. We had, in the year 2014, about 1,038 trustees, and of this, we have trained about 7%, which is a figure of 73 trustees, and the other percentage of about 23% is being trained by the schemes themselves or other institutions. And our concern is that 70% of our trustees have not received training in as far as we're concerned, but I'm sure they could be receiving training in other institutions as well. And I think we're saying that lack of this training may lead to governance concerns because trustees, as we've indicated, are charged with the responsibility of ensuring that schemes are well managed. We've also introduced an accredited program with the South African Qualifications Authority just to promote the training of trustees as well. And we're just giving statistics there that last year we've trained about 40, and 10 of those 40 were declared competent and they were issued with certificates, and about 77 received induction training. And we've also trained brokers about 258 of the brokers, so that the brokers can provide the necessary good service to our members. Although that is not within our mandate to train these brokers. Membership in schemes over the years, we are just demonstrating that in 2005 we had a total membership in both open schemes and restricted scheme of about 6.8 million. And as you can see, in 2014, the total membership of we have in the medical scheme industry is about 8.81%, which represents about 16% of the South African population, which I think we have demonstrated that. There's been a growth, as you can see, in membership over the years, but not as significant as we would have liked it to be. And just in terms of the number of schemes that we have now in the industry, in 2000, we had about 144 medical aid schemes. Today, we only have 83 schemes, 60 of them being closed schemes, and 23 are open schemes. So we have seen a consolidation of the industry in terms of the number of medical aid schemes in our environment. And I think at this point in time, Honorable Chair, I'm going to give it to my colleague Paresh to continue with the rest of the presentation.
Yes.
Hi. Morning, Chair. It's Paresh Prema, General Manager of Benefits Management.
I didn't get the name.
Paresh, P-A-R-E-S-H. Prema, P-R-E-M-A.
Thank you, Mr.
Thank you.
Mm-hmm.
So the next slide is a graph on how a healthcare rand is spent for 2013 and 14. In 2014, 79.9 cents gets spent on healthcare expenditure. 11 cents of that rand goes to non-healthcare expenditure, and 3.7 cents of the rand goes to reserving. So I think it's important that in the contributions, the balance of the contributions that are collected goes to the benefit of the members in the reserves. It remains in the scheme, and that's the non-profit element that we have for medical schemes. In terms of our complaints process, a lot of it has been discussed, I think, over the past few weeks, and maybe just to give you an explanation of how it works. So our aim is to have a transparent and effective process in terms of managing complaints. It's one of the requirements in terms of Section 7. Once a complaint is received in terms of Section 47, we have a written acknowledgement sent to those members within 3 days. In terms of Section 47 in the Act, medical schemes are obliged to respond within 30 days, but what we've done is we've put in a process to deal with urgent complaints. So we have a 24-hour turnaround time where we compel schemes to respond sooner when there are urgent complaints that we receive. Once we receive a response, we analyze it, and we give comments within 4 days. Upon receipt, we make a decision or ruling on the response received from the scheme. These usually are made within 125 days of the referral to the complaint to the communicated parties. The next step in the process in terms of the Act is schemes or the parties involved have a right to appeal against the rulings made to the registrar. They are referred to the Appeals Committee. The Appeals Committee is a subcommittee of our council that meets approximately once a month or even more, depending on the backlog or the number of appeals that are needed to be decided upon. And those decisions as well are appealable to the appeal board. So they two other layers of appeals in terms of the Medical Schemes Act. Some of the complaints trends that we have, most of the complaints that we receive deal with PMBs. I've given a graph there showing the proportion of PMB complaints and what they relate to. The main trends are limits imposed on the PMB benefits paid, which are contrary to the Act and the rule provisions in the scheme's rules. So we get the scheme rate argument that comes out quite a bit. The misunderstanding of the DSP provisions. What we do find is members accessing a DSP may not be alerted to the other providers in the DSP being non-DSPs, and that's a difficult, it's a communication issue that schemes have, that they don't communicate all these issues to the members on pre-authorization or accessing. So that's, I think, in terms of complaints, quite prevalent. What we do also have in terms of our legislation, if you are involuntary, if you involuntary access a non-DSP, your claims need to be paid in full. And we have a lot of complaints dealing with members being forced to use a provider that is not on the DSP in emergencies. In terms of the Act, they need to be paid in full, and that's a lot of the complaints deal with the involuntary use of a non-DSP. Then again, the other issue is there are coding issues, because what happens, because there is no standard authority on coding, providers either add codes because of new technology or procedures, which schemes don't always accept because it hasn't been taken to there isn't a relevant authority authorizing what codes need to be applied and what treatments are to be provided. So that also we deal with a lot in our complaints process. Okay. The next section of our presentation is on regulatory features and concerns. Okay. So our main concern around, from a member perspective, is information asymmetry. We've heard a lot about that, and especially around the benefit designs and their complexity. The concern as to the access to PMBs and the definition of PMBs, sharing of information regarding DSPs and access to them, especially the availability and the quality of the service. We don't see that coming through when a list of DSPs is provided to members. Affordability is a huge concern for members, and it's something that we deal with on a daily basis, and we have put in certain mechanisms in place to try to manage the increases in affordability of these schemes. Again, access to PMBs and quality of care. And the challenge, and we've seen from the two members this morning, around knowing that this is a PMB or an entitlement, what the benefit is. I think that's very difficult for us. And we do that, that's something we strive to do every day, and communicate as much as we can around PMBs in whatever forum we have. I've got a few slides where we deal with that as well. There was an interesting point made 2 weeks ago about price takers, and our view is, if you are a member needing care, you don't have a choice whether you want to be sick or not. So you are the one actually ending up needing a care and having to be the taker of the price. So ultimately, if a scheme doesn't accept the price charged by the provider, the balance is still to be paid by the member. So the member still bears the full cost of the care that they need. So they don't have a choice. Further concerns regarding members, it's difficult for them to make informed decisions, because obviously it's at an event where they need a service, and it's sort of a lot of the times a dire need that they're facing. They can't make decisions on the goods and services to be purchased, because firstly, they're not in a position to shop around for providers, and the providers usually are the ones that make the decisions as to what the member needs. So they don't always have the choice to decide on the intervention or consult on different interventions. What makes it more difficult is they're not, because of the scarcity of resources, if they choose not to go to a certain provider, it's difficult for them to get access to another one in a short space of time, or compare what a different provider would charge for the same service that they would get from another one. That's where the difficulty around the tariffs come in that if they don't have, firstly, the choice, they can't compete on price, and the tariffs are not regulated, so they sort of stuck in taking what they need urgently. They don't also have the skills to judge the appropriateness of the treatment and negotiate costs. As far as consumer education is concerned, I put up a slide on the summary of some of the sessions we've had in rural areas trying to explain medical schemes, how they work, what benefits are provided in terms of the Medical Schemes Act. It's more statistics on what we do in terms of consumer outreach and getting the message across. A lot of the times we do this by attending consumer groups that request us to present to members or rural communities to provide further information. This is an ongoing process, but it also depends on the available resources so that we can do it more over time. What we also do as a regulator is we publish CMS news, which are quarterly, on relevant healthcare issues. We have a CMS script which outlines PMBs and what is the benefit entitlement to members. We have a comprehensive website. We use social media. We have exhibitions. We go to the community workshops. We present to unions and large employer groups. We use medical scheme communication channels, so we'll explain our complaints process in medical schemes newsletters. We are a lot of times on community radio stations having interviews and presenting medical schemes, and we do get a lot of feedback once we do that to say, okay, it's in a different language, and people then understand that if they call in, there is someone that can understand, explain to them what medical schemes are and how they work. We do advertisements as well to try to promote and make CMS more visible. What we also do as a regulator, we also have deal with stakeholders. We have various forums. We deal with principal officers. We have trustee forums where we communicate these issues and what message we want them to send out. We have a marketing forum where we deal with schemes, giving them our communication guidelines, which was published, that they need to adhere to in communicating with their members. We deal with guidelines around what the call center should do, how members should access and understand or be explained benefits at a call center. We have Indaba. So these are some of the interventions we have in dealing with the industry. In terms of our concerns with medical schemes, we know bigger schemes have more bargaining power to negotiate better rates with service providers. We've seen that with some of the providers presenting and saying how they enter into DSP contracts. Sometimes they are forced to take certain prices or agree to a certain scale. When we say economies of scale, when we look at the large administrators, we don't see the economies of scale coming through in that the cost of administering medical schemes, the fee component itself, reducing as the size of the scheme increases. There should be actually that benefit being passed on to the member by administrator growing over time. We don't see that happening. I think an important thing is the fiduciary duties of trustees in ensuring when they're contracting, the best interests of members are always at heart in trying to reduce those costs. We saw the presentation by GEMS in the non-health being at the level it is, and I think they've gone a long way in trying to prove that is possible in our environment to bring non-healthcare costs down. What we do find also with medical schemes is the DSP method of selection is not always transparent. It's not defined from the scheme itself. But our emphasis is that when you do, it should be based on cost effectiveness, quality of care, and affordability of these DSPs. We don't always see that through. We don't see why a certain DSP is chosen. We do know that a lot of the times it's the parties that have negotiated a better rate. In some instances, we see the rate actually being higher for you to be in a DSP, which we find actually in a situation where you've been channeled more services or work, you should actually have a discount and not a higher fee structure in order to access the DSP. So that's something that we have a concern about. It's not only medical schemes, but it's both sides. In terms of the industry, medical schemes are comply, majority of them comply with the 25% solvency requirement. In 2014, the solvency of all schemes average was 33.3%. So the industry is healthy. The restricted scheme solvency level is slightly higher than the open scheme at 37.9%. In terms of solvency, we are aware of the comments. I think a lot of schemes have put that around the 25% benchmark or solvency requirement in Regulation 29. 25% equates to 3 months of contributions. And obviously, as CMS, we are responsible for enforcing the regulations, Regulation 29 being the solvency requirement. We are aware of the concerns, and we also have commenced work on a review of the solvency framework. We've published a discussion document on risk-based solvency that we've invited industry comments on the solvency requirement. In terms of administrators, we have the 3 large administrators dominate the market. Out of the 5 biggest, they dominate 83.8% of the medical schemes industry. That graph just illustrates the market share. We know that GEMS has a joint administration contract, so that the market share is split between Metropolitan and MedScheme, so that's may not be entirely accurate the way it's presented, but that's the one double administration contract that we have, joint administration contract.
Then what would be the more accurate way of presenting it?
The more accurate, well, I think it depends on if you want to look at it in terms of membership, then the membership, you may have to split it between the two because they both administer the same membership. So if you want to look at the market share in terms of how many members, it may be depending on the analysis you want to do, or if you want to do it according to their revenue and see how much of the total revenue is split between. So there's 2 ways of doing it depending on...
Well, perhaps at some point you will tell us what is the more correct way of dealing with this.
Okay. An important point on this slide, and I think it's come out and maybe not, it's our opportunity to put that forward, is the relationship that schemes have with administrators. It should be at an arm's length basis, but what we're seeing is there's a mixture of perceptions by my members saying, if you say, for example, a scheme that has a insurance company linked to it, you don't see the scheme, you see the insurance company. And a lot of the other perceptions we get is medical schemes are making money, so why aren't they paying for claims? Whereas actually it's the administrator is the for-profit part of the system, whereas the scheme is there to provide benefits to its members. There's no profit incentive for them except to be solvent. So I think that's a concern we have from our side. It led us to actually publishing an undesirable business practice declaration. In terms of our act, we may publish a declaration like that and publish it in the Gazette as to any undesirable business practices in our industry. And in this one, it's how do you separate the scheme from the administrator? So there needs to be a clear demarcation between the two, so that you don't have instances where the administrator makes the decisions on behalf of the scheme. So that is something that we have done from our side, which in terms of our legislation we can enforce. The next slide is total benefits paid per discipline. We see that hospitals make up the largest chunk of the spend with 37.6%, and all specialists, the 5 categories, make up 23.5% of all benefits paid. The total would then be 77.7% of all benefits going to specialists and hospitals and medicine. This next slide just gives a breakdown by speciality as to how the 23.5% is split amongst the specialities. So our concerns relating to specialists, we've heard a lot about the relationship that specialists have with hospitals and other providers like pathologists and radiologists. I've also seen some of that coming through in the OECD report, where they look at how the bulk of some of the services are split between the hospitals and how it changes between medical and surgical, between the pathology practices and the surgeons. So I think that's something that is a concern for us, but we need further investigation into that relationship and maybe some way in which we can we can see what effect this has on the industry. Specialists in South Africa have market power, and they are scarce resource. Again, the DSP issue comes up with specialists in that the specialist groups differ in terms of whether they become part of the DSP or not. You get some groups telling their members that they should be, some don't want to join DSP groups. There's no transparency in that process and what tariffs are set between the scheme and the specialists. So I think that's also a concern for us. There's no transparency in that process. In terms of the comment around scarcity, I've put in a slide there showing the distribution of specialists by region. We can see the higher than normal proportion of surgical specialists to membership in 2 provinces, Gauteng and Western Cape. It just, again, illustrates how the distribution differs by province.
Membership of what?
Of members by province. So if you look at the number of members per province, and we look at the number of specialists per province. So membership of medical schemes by province. Our annual report has splits of other specialities. I've only put the one slide to illustrate how the distribution is not equal by specialists and other providers in the market. Our further concerns relating to specialists is we see that larger medical schemes enter into arrangements with specialist groups, but we don't know what the traits are. They mostly are fee-for-service arrangements. And what we do find is sometimes the balance of the schemes cannot enter into any arrangements because they cannot channel the amount of members to a specialist group because of the size. So then it makes it difficult for them to indemnify their members by having a DSP because they can't contract with the DSP. Now moving on to hospitals. Hospitals are a key cost driver we've seen in the previous slide. Other factors influencing expenditure that we've seen is the fee-for-service reimbursement incentivizes utilization. We've seen that new medical technologies also drive up costs or utilization. The other points made in previous presentations is the disease burden and aging have also been cited as drivers of utilization. And I think just to give a point around aging in our medical schemes environment, we've seen the green line being the average age of medical scheme members over the years. At the moment, it's 32.1 years old for a beneficiary, and that has remained relatively stable over time. But what we do find is the split between the different age bands vary over time. So even though the average age remains the same, the underlying profile also changes of membership. So that affects utilization as well. So there is that effect that affects utilization. The problem we have, or the challenge, is splitting that utilization between different components, whether it's only aging or demographic, new medical technologies, or other elements that, like supply-induced demand, that affect utilization. We haven't comprehensively been able to work out the components of utilization. In terms of the hospital market, we operate with the private hospital market that is an oligopoly. They are partially regulated, meaning they have to get a license to operate, but the license is not based on any other criteria in terms of the membership it's servicing, the quality of service that is being provided, the size of the institution. What we did see in some of the previous presenters showing an increase in usage of a new hospital coming in there. But we don't know if that is actually based on the actual need, if there was a shortage of the service and that's why there's an increase, or some other element. So it's not completely defined. But what we do know is there is a need for more regulation on the private hospital market. They do enjoy an advantage over their competition, especially the smaller hospitals, the private hospitals, and there are barriers to entry in terms of capital costs to enter into a market like this. We even see that with the day hospitals, where the prevalence of them is lower compared to the international benchmark as to day hospitals. What we do see also with
may I interrupt you?
Yes.
Now, in the previous presentation that you submitted to us, you had a slide dealing with concerns relating to specialists, where you dealt with provider-induced demand and defensive medicines. That slide is no longer here.
Yes.
Is that right?
Yes.
And why has that been dropped out?
I think we do deal with it later on in the presentation. We didn't want to repeat those issues and try to keep the slides more comprehensive when we discuss that. So it will come up later.
Oh, you still rely on that?
Yes.
Okay, very well.
In terms of medicines, we've seen a lot of issues around biological medicines because they are not required in terms of PMBs. And they are expensive. It makes it a very difficult issue to deal with, especially as these cases are usually the last resorts for a lot of the members. We do have we know that there are issues around the registration of new drugs. It's time consuming. We know there's been comments made about the incentives between providers and the drug companies. So there are issues which need to be further investigated, and this results in limited competition because of those relationships. In terms of quality of care, our view is the value of quality of care is quality over the cost. And we are in a process to determine or identifying minimum standards of care for CDL conditions. We've done work on 9 of them so far, and we've collected data of 7 of them in our annual statutory returns. What this involves is taking the CDLs, looking at what the process indicators are and what have been done by schemes or managed care entities. Now, an important point to make here is in assessing the value of managed care, we need to assess what is required of managed care and seeing at what cost that is provided to assess the value. Then we can, I think, and then compare that to the price being charged to medical schemes. And this is one of the reasons why we've embarked on this process to review the quality of care. In terms of, just to give you an example of some of the CDLs, these are the 3 most prevalent CDLs, and we've put in, these are the tests that are required, the process indicators, and some of the outcome indicators that we have for these conditions. I've given a sample of the most prevalent CDL condition. In 2014, 404,000 beneficiaries were registered on a hypertension program that amounts to 18% of the members. Out of that, we look at the electrocardiogram test. Only 38% of those actually registered on the program got that. Only 43% got the eGFR test, and 61% got the cholesterol test. But I think it shows where there's still a lot of work that needs to be done by managed care entities and schemes. So if you register on a program, we'd actually want to see a larger percentage, maybe not, we cannot maybe get to 100%, but we want to see an increasing trend over time. What we do find is when we looked at outcome indicators, we looked at, for the same members, the hospital admissions for a day and more than a day. And we looked at whether they suffer from more than one of the CDL conditions. And 22.7 of these in 2014 also were registered for diabetes. So I think it's important that not only looking at what is required of schemes to provide the members, but also managing the other conditions is also an important part of quality and ensuring members get what they need. In terms of benefit options, medical schemes need to comply with Section 33(2) of the Act. In terms of that section, they need to include all PMBs. It's interesting to note that there are only 5 options that have only PMB benefits, and they cover less than 1% of the beneficiaries in the industry. In terms of Section 33(2) scheme, these options need to be self-supporting, they need to be financially sound, and not jeopardize the financial soundness of existing benefit options. Over the years, the average number of options registered by medical schemes for all schemes has been 3.3, 2.3 for restricted schemes and 6 for open schemes on average. All these options have a variety of benefits, and these benefits range from in and out of hospital benefits, medical savings accounts, there's things called self-payment gaps, threshold benefits, preventative benefits, and day-to-day benefits. So there's quite a wide variety of benefits that schemes provide their members, and all differ by where you access, how you access, and what your contributions are. My next section is on the challenges of regulation. So PMBs are important from our perspective to protect members against catastrophic events that could bankrupt them. When we say there's no evidence that abuse of the PMBs in full is widespread, is that we know that there are instances of abuse, but we don't know to what extent. Is it 5 specialists out of 100, or is it 95 out of 100? What is the extent of the abuse? Because we know that there is abuse, we've seen that, But is that the only cost driver? So that further work needs to be done. We haven't been provided that evidence, although schemes mention that every time there is some issue around the in full provision. And also one of the ways in which we can look at whether the PMBs are charged over or charged more than the non-PMBs to compare the two. I think that's also one useful way of looking at what the provider will charge in maintaining their practice or running the costs or paying for the cost of running the practice. And then what we do see is the tools that schemes have to manage the costs. I think it's Regulation 8.2 and 8.4. Regulation 8.2 and 8.4 deals with pre-authorization. We know that schemes are able to contract with DSPs, but those DSPs sometimes are difficult to negotiate. But when they do, they are able to limit the cost of PMBs because they have a negotiated rate. If there's no DSP, then we know the involuntary use of a DSP provision would apply. We have formularies that medical schemes can use, but the formularies need to be based on evidence and needs to be cost effective. So it's not choosing the cheapest drug, but it needs to be the drug that is most cost effective and affordable for the scheme as a whole. We do also have instances around protocols and issues around there where they need to be based on evidence. There must be alternative treatment, so our Regulation 15 deals with that. So if you need further treatment, there needs to be an allowance for that if you've exhausted what is already available. So that's something that schemes need to apply in their interventions. We've seen that a lot of the time it's very difficult to get schemes to actually allow you to get further benefits if you've exhausted what you actually do need in terms of what the PMBs provide for. In terms of prescribed minimum benefits, I think a lot of the issues also relate to them not being reviewed regularly. In terms of our legislation, explanatory note to Annex A, which relates to PMBs, these regulations need to be reviewed every 2 years by the Department of Health. And I think that would go a long way in dealing with a lot of the outdated coding or definition issues. It can even go to the Regulation 8 provisions dealing with the in-full issues. We have done a lot of work. I think in 2010 we presented a review to the department, and one of the comments was from that is we needed to include more primary and preventative care into the PMB basket. We are currently working on that to advise the department on how we can include that in the PMB basket. Just to give more background on the PMBs and Regulation 8 in particular, and some of the recent judgments that we've received. In terms of Regulation 8.1, payment in full, there is a SCA decision on the matter where in full means the invoiced amount. As CMS, we have a responsibility to ensure that we interpret and apply the legislation as is prescribed either in the legislation or in this matter, the SCA. There was an amendment that the department had proposed on Regulation 8, which we also aware of and tries to address some of the issues that the in full issue raises. So over the past few years, the challenges to Regulation 8 we've seen the BHF seeking an order to say or seeking a declaratory order on the definition of in full provision. Unfortunately, the order was dismissed because all medical schemes failed to join that application. Then the most recent one is a Cape High Court ruling or Cape High Court case against the Minister of Health by Genesis Medical Scheme, challenging Regulation 8, saying it's ultra vires. So I think they in the High Court or SA dealing with the intervening parties at the moment. So we haven't got to the actual number of the case. In terms of PMBs, and you'll see this in our annual report, the actual cost of PMBs per beneficiary per month is 567 rands. This makes up 52.5% of all risk benefits paid out. So 47.5% of all the other benefits paid out are for non-PMBs. In this slide, what we're trying to show is the distribution of membership by age of medical schemes over 2013 and 14. We see that the lines indicate the cost of PMBs by age. So the one that drops and goes up is the one. So as people age, the cost of CDLs increase. The average cost is the orange line that's straight through, which is the 567 rands. On the next slide, in this slide we want to illustrate what the cost of PMBs are by scheme. So PMBs range from under 400 Rand to over 1,000 Rand by medical schemes. So this is some of the work that was done with the risk equalization fund work, the shadow returns, and we still collect that data annually as part of our statutory returns. So schemes do not compete at the same level. There is quite a large variation in risk profiles between medical schemes, and PMBs vary quite a bit. In terms of contractual relationships, and I think this deals with the DSPs. In terms of another court case recently, if a scheme chooses not to appoint a DSP, then or does not negotiate a DSP, then members should be able to access PMBs in full anyway. There's a recent case in the SCA where a scheme refused to fund PMBs if the member did not go to the state facilities, because the scheme relies on section 29(10) which says if you go to the state for services, the scheme must pay it in full. That provision was brought about to prevent schemes from dumping members onto the state, so that when they do access benefits, schemes cannot then send the members to state. What the scheme relied on is using that as a default position, that the scheme would be by default a DSP. The ruling just confirmed that if you don't appoint one, you should pay in full wherever the member goes. So you cannot rely on that provision in forcing members to go to the state. So the ruling reaffirmed that position around if you don't go to if you go to the state or you don't appoint a DSP, you cannot pay zero if you don't go to the state. It's important for us to note that's the most recent development around interpretation of DSP and Regulation 8. Okay. There were previous complaints lodged with the Competition Commission around schemes refusing to let providers be a part of the DSP arrangements, which have been dismissed. We know, and I just may be repeating the point again, if a DSP is not accessible, then the member can use any provider without co-payment. So it's important that provision also needs to be communicated, and schemes need to enforce that, to say you have a DSP arrangement in place, you don't make sure it's available, then the member involuntarily goes somewhere else and should be paid in full. The penalty is more to entice members to go to a DSP. But if they involuntarily choose to, or cannot choose to go there because of an emergency, they can't be penalized for that. In terms of DSP arrangements, we've also seen practices where schemes use Section 59(2). Section 59(2) refers to the benefits or the monies being paid for services can either be paid to the scheme or the member. What we do see is sometimes schemes use that to get the DSPs or the providers to sign up contracts because it's more onerous for them to recover their money from the members directly. Medical scheme inflation. CMS's view on medical scheme inflation is that it's made up of two elements. Tariff inflation, which is the CPI-related element of the increase in tariffs, and utilization. We've done work in the past where we've looked at how much that component make up the total utilization. That's what we've presented. Approximately 5 to 7% is tariff, and 2 to 4% is utilization. Again, utilization refers to increase in prevalence, aging, member movement, provider behavior, all of that which affects utilization. But the challenge again is how do we separate the different effects? But I think the pricing of tariff setting is just one element in medical inflation. The utilization is something that still is not an easy one to manage. Again, this table illustrates how much contributions have increased over and above CPI. So the red line is the contribution inflation, and the green line is the difference between the two. We see on average medical inflation is 3%, on average 3% above CPI. I think an important issue to raise as well is when scheme talks about the level of reserves. This is a graph showing what is the net healthcare and the surplus result for medical schemes over the years. And we see that when the orange line goes below zero is when schemes in general are making deficits. And that's when they place reliance on reserves and investment income from their reserves. So the pricing of contribution is not only to ensure that they can pay the tariffs, but also to ensure that there is enough collected so that the scheme can be solvent and accumulate reserves. So in those years where schemes are relying on their reserves, the future years they'll need to recover so that the reserves are built up to the statutory level. I think it's something we all know, but it's illustrated well in this graph to show how the effect of pricing and the reliance on the reserves is so important in our industry. We've done some work last year on out-of-pocket payments. The data that we have is not complete because we rely on what the claims that have been submitted to medical schemes. So if members are on plans that don't have day-to-day benefits, the out-of-pocket payments are not captured. So what we've got is what has been claimed and what hasn't been paid by medical schemes. Over 2014, that amounted to 20.7 billion, and a bulk of that has been to medicines and specialists. So it differs by option to option depending on the level of day-to-day benefits, the level of co-payments. It's interesting to note that, but more work is being done to deal with or to analyze that information more. One of the other issues that we'd like to raise, and I think we have presented, and a lot of people have made comments around that, is we need a system where there's a central authority dealing with pricing, and I think even coding, because we haven't seen a lot of that coming through. They both need to be done. We're not. If we don't have the one, the other one cannot work effectively. So if we're dealing still in a fee-for-service environment, the authority needs to obviously be established. It needs to be independent. So there shouldn't be people involved that who have an interest in the ultimate outcome. It needs to include all the relevant stakeholders. There needs to be a way to make sure that the authority and the results of that are binding. So we don't have a situation where providers contract out, they use the term contract out, where you get billed directly, you pay before you receive a service. It needs to be, the system needs to be developed so that they have to charge what is being determined in that bargaining process. The process also, though, needs to be based on evidence and scientific. So if there's an argument around the cost of running a practice that needs to be incorporated in the ultimate decision, so that it doesn't, it benefits the members in terms of certainty, but not, and the providers also obviously run sustainable practices. The issue with the coding, again, if we don't have codes, you're going to have the situation where schemes don't pay for benefits because there isn't an established code. But that code also needs to be standardized in that the people making the decision should not have a direct interest, but should be an authority in introducing the codes, because it talks about different procedures, practices, new technology, and all of that that needs to be dealt with in a standard way. We've seen presentations on other health insurance products, and this deals with demarcation regulations. The regulations seek not to ensure that these products do not undermine the social solidarity principles in medical schemes, but they also serve a need in the environment for protection against health-related risks. Now, there's various products out there. You've seen the hospital cash or contingent liability plans. You get the gap covers, and you get the products offering like a primary health care or almost like a medical scheme type of benefit. So what we've done, what the Treasury has worked on these regulations, the main issues around the regulations is if we do allow these products to be sold in the market, they should not discriminate against members by age or any other criteria. There needs to be more marketing disclosure requirements, so you shouldn't be selling yourself as a medical scheme, and also limitations in the type of products which are allowed to operate in the industry. In terms of what we're doing as well, I think the challenges of regulation has brought about the need to amend the Act, because we face an environment where there's challenges at every front. I mean, we can make decisions and they can be appealed. Appeal processes take long. Schemes sometimes abuse the process to the point where it results in a backlog of appeals. That's why decisions get taken months later, because they get scheduled. There's a limit in terms of how many appeals hearings we can have and how many issues get dealt with. So the issues, and that's just one of the issues, but the main issues that we deal with in an amendment bill that we've crafted is to improve the efficiency in regulating the industry. The issues dealt with are obviously improved information management, membership and contribution related issues we deal with there, updated complaints and appeals processes, enhancing the system of governance when we looked at the issues around election of trustees, conflicts of interest. There's another undesirable business practice declaration dealing with conflicts of interest and election of boards of trustees, because we see there's a lot of sort of gaming, or the way the system works is not transparent enough. Updating definitions as it relates to other definitions, the powers to establish guidelines, publish guidelines and enforce guidelines, extend the limit of liability, the fines and penalties, and how do we try to enforce the provisions, so improving those provisions, how reports are submitted to the office. What we've done with brokers is also remove the alignment with them with medical schemes, as it currently is, where a broker is paid by a medical scheme. We've changed it to align it with the financial services sector, where the member pays the broker for the advice and not get the income from the scheme. So we've dealt with that in our amendment bill. There's a code of conduct for administrators and also standards for self-administered schemes. So in our conclusion, just to highlight the main issues in our presentation, lack of regulation of hospitals is the largest cost driver in our industry. Our regulation needs to be reviewed in terms of the PMB regulation and the Medical Schemes Act or the Medical Schemes Amendment Bill. consumers need to be empowered more to make informed decisions. I think a lot of the people presenting showed there is a lot of either miscommunication or no communication. Contracting with service providers need to be transparent and promote access. There's an issue with the relationship with the schemes and administrators around the arm's length arrangements. We've done work around that, around undesirable business practice, but I think it's going to take, it's a work in progress for us, but we acknowledge that there is that issue. The demand and supply effects of healthcare. So demand by users we know there's an issue, but there's a moral hazard where the party receiving the treatment, where they are not responsible for the payment. I think that again comes with consumer awareness as to the decisions that they've been making. There's absence of risk adjustment, so there's no risk adjustment and that speaks to the graph where I showed the difference in profiles by schemes. The need for the pricing and coding authority. Prescribed minimum benefits as it needs to be reviewed. I think not only necessarily reviewing the PMBs itself, but also seeing how complex it is, changing the way in which the benefits, minimum benefits need to be provided. In that, is it worth looking at changing not by illness, but by service? That members need to get these services no matter what disease they suffer from. So that's part of some of the ideas that could come through, and also we are working on the inclusion of preventative and primary health care. We also looked at the review of Regulation 8 in terms of that review to deal with the in-full issues. The private hospital licensing system, again, there's no emphasis on the needs-based criteria, and there's no diversity in ownership of hospitals. Failure to address the central systemic cost factors on the supply side of the health system would lead to a challenge. We've seen that. And access to medical schemes in terms of affordability and the services and quality of services that medical schemes offer. That's the issue with it not being regulated. I think that's important that healthcare costs are regulated. Okay, thank you.
Yes, thank you. The matters that are set out in your conclusion, are these matters that must be dealt with through legislative measures, or can they be dealt with otherwise than through legislation?
The matters that can be dealt with through legislative changes to our environment we've put in, but it's not a solution to all the problems. It requires other interventions.
Okay. For example,
outside.
one of the conclusions you make is that consumers have to be empowered to make informed decisions concerning their health. How does one achieve that?
Well, I think the first thing is strengthening the need for medical schemes to communicate with their members. So there's a lot of factors affecting that. Firstly, governance. If medical schemes members or trustees are not have conflicts of interest or not managing the affairs in the interest of members, they wouldn't communicate. Yeah. So we need to strengthen the governance provisions. We need the schemes to understand that they are there to benefit the members, and the members need to be informed. So, and that can be in various forms. Firstly, obviously by the schemes themselves, but also by regulators like us, which we strive to do in some of in the channels that we use.
Yeah, I understand. Now, is there further presentation from your members of your panel?
No, not.
Okay. Now, this document, DL2, is anyone going to speak to the document? Or has it been subsumed in the presentation that you've made?
It has.
Okay. Yes? Okay, very well. Can we take a lunch now? now? Into the first one? No.
Let's go ahead with questions.
Hold on. And then we have lunch.
Somebody has to leave it first too.
But will it be finished by 2?
I'd rather do at least some questions. We'll just have it like half an hour ago.
Okay, we will go ahead with the question and take the lunch. Who's going?
I was going to say good morning, but it's good afternoon already. Thank you very much for your extensive presentation and the submissions. And I'm sure you could keep us busy for the rest of the day on all the issues that you raised. You just touched upon them. And we will, of course, meet you at least a couple of times when we deal more specifically, more in depth with competition dynamics and expenditure in both on the funding side and on the hospital side. So I will not go into that, into these issues, and you raised a couple of very interesting points. And we will, in our last set of hearings, we will deal with government and regulators, of course, and you are in depth, and you are a very important regulator, if not the most important regulator of the industry. So we'll deal with you, and we'll see you, and I'm looking forward to deal with a number of issues that you raised. I'll keep to sort of high-level issues that I'm interested in. It's two issues. We are, as the judge explained this morning, we're interested in how you engage with the other stakeholders. Obviously, the members are and you put them at the top of your list, and you will probably be the first to acknowledge that is a very complex matter to deal with all these individual members and their complaints. I myself will concentrate now on two other stakeholders. One is on government, and the other is on the schemes and administrators. And what I would like to find out is whether you yourself think your powers are in balance with with the powers that you need to protect the interests of the members, both in respect to the government, because that is a very important stakeholder for you, I think, to manage and to be managed, and to schemes. As from the beginning of the inquiries, we were struck by the fact that you have a legal obligation to evaluate PMBs every 2 years. You mentioned undergoing in your presentation, you did that in 2010. And then you mentioned one of the outcomes, which I can't imagine that's the only input that you gave in the whole evaluation process in 2010. One of the outcomes was that primary care would have to be covered more broadly in the PMBs. As I overlooked the hearings and also the inquiry, I think your evaluation in 2010 was much broader. And there must have been much more recommendations that you put in. And there has not been a 2012 evaluation and 2014 evaluation, and you're not at the moment doing a 2016 evaluation. Can you talk us through this? Why is the 2010 the last one? What happened with it? How was the reaction of the Department of Health? Can you in fact talk freely to me about your relationship with the Department of Health and their actions or lack of actions upon your evaluations?
Okay, thank you, Chair. I think we do have a good relationship with our National Department of Health. As we've indicated, the review that we've submitted, the department had concerns that it does not contain the preventative component of the PMB. And they said we must work on that, and I think whilst we're working on that, this competition commission going on, and the minister said that he will deal with that when he make the presentation as to why this were not reviewed over the last 2 years.
Just, I mean, if I can refer to Annexure A of the provision, it says that the Department of Health recognizes there's a change in practice and technology. Consequently, the department shall monitor the effectiveness of PMBs, and a review shall be conducted every 2 years by the department that will involve the CMS and other stakeholders. So I think it was important to refer to Section 7 of the Act, which even though we regulate the industry, decisions on policy and what needs to be covered is still made by the department. We enforce policy and regulations. We can advise on them, but the ultimate decision maker is not the CMS. The policy decisions made by the department.
So, Mr. Perez, what you say to me, ask the Department of Health.
Well, the chair, Dan has said that the minister will be dealing with that in his.
We'll ask him on Friday. Then I'll keep a note in my. Just as a matter of interest, when is the amendment bill? When has that been introduced, and where is it now? Because there are a number of very interesting topics being dealt with in the amendment bill, and it's needed, isn't it? So how is that process going now?
Well, at the moment, the amendment bill has been submitted to the department, I think in 2014, late 2014. We've completed the socio-economic assessment also that is required in terms of any new legislation.
Yes.
But again, we may only advise on what is required. I think in terms of, and it relates to your first question around our powers, we can only do, the amendment bill is meant to increase the level of control or regulation we can have in the industry, but that needs to be decided upon by, again, the department in their view on what role we have in the industry.
We'll ask again on Friday. Thank you very much. My second subject is what I call the balance of powers between yourselves and the schemes and the administrators. You mentioned to us that you have 160 people, personnel. I'm sorry, 106, yes. You wish you had 160, isn't it? Because I heard you say only 106 people, personnel, and you mentioned budget. Discovery administrator has 4,000 plus personnel, isn't it? Just to give it an idea. Now, my question is, so you regulate the smaller schemes and the larger schemes and the et cetera, and you mentioned, and of course in this industry with a number of for-profit players needs a very strong regulator. And my question to you is actually do a sort of self-assessment. Are you strong enough? We heard evidence yesterday of a province actually putting on record that it was afraid of the legal powers of Discovery in its actions. Later on, it was taken back a bit, but these were the clear words. You, for example, mentioned that your guidance on the arm's length distance between schemes and administrators is a point of worry to you. We have had very clear evidence over the weeks, but also this morning, and again, I'm sorry I take Discovery as an example, of Jessica McCarthy, that she wasn't even aware of the existence of Discovery scheme, and that all communications, was done by the administrators, whereas you mentioned that this, I take from your word, should have been done by the administrator. So, by the scheme. So then you ask them to do a self-assessment, you get a self-assessment back, you assess the self-assessment. What then happens, Mr. Parrish? because it's obvious to everybody that this particular scheme does not comply.
Thank you, Chair. I think in as far as whether we're strong to regulate the industry, we can say yes because we've got the legislative framework. We've got the law that we must enforce. In as far as that is concerned, yes. But in terms of the resources available to us to pursue this, I think we can say we wish we could have more personnel, because I think these administrators, for example, we go out there and conduct what you call on-site evaluation just to see whether they're doing things right. And I think we're thin in terms of the resources that we have. But the legislation is there for us too.
The legislation is in place, the guidance is in place, but it's obvious that one of your largest members, or the largest companies that you regulate, does not adhere. Now you have the law, and you only take. I think you need one lawyer to take the company to court. So my question is, I hear you about the law, but that's not the question. The question is the balance of powers between yourselves and the industry. So if I take a look at it from this distance, I'd say you're not effective in regulating the industry in this respect, at the arm's length issue. Can I have your comments on that?
Sorry, can I ask you this? Can I ask you this question? The complaint, the issue that my colleague is putting to you, has that been drawn to your attention by anyone concerning Discovery?
Of course.
Yes.
And have you investigated it?
Yes, I think we constantly do that because...
Have you investigated this particular complaint?
Yes, we have.
And what were your conclusions?
I think at this point in time, Honorable Chair, we can go back. We do not know the status as to where we are now.
But it is still under investigation.
Yes, we are dealing with
So
that.
you can't reach any conclusion as to whether or not they have been violating your rules or any rules, can you, at this stage? Because the matter is under investigation.
Yes.
Chair, if I may answer that question. The Undesirable Business Practice Declaration seeks to address that issue.
Well, I understand the declaration, but I'm simply asking you, is the issue still under investigation, or has the investigation been completed?
It's not under investigation because we've investigated in the past. We see the clear overlap in the two structures, and that's what led to the declaration. Because I think, to answer your question around the powers, we obviously would like to do more, but I think we also need to do it smarter. And changes in the amendments to the Act will enable us to do it more efficiently and better because of the balance of power. We're in an industry where it's very litigious. Every decision made is appealed or taken to High Court. So the amendment bill seeks to try to find ways to enforce provisions that we put on medical schemes more effectively, so we don't always have to go and challenge these administrators at that level.
I rest my case here. Just one small question, also relating to the balance of powers, also relating to what we heard this morning. So we heard a mother explain about the situation with the daughter and her fight with getting her legal legally her cost paid. She had to sell her house because the reaction time of Discovery on a complaint were quite long, a year. And then after your decision, Discovery was given another year to decide whether it would challenge your decision. And then I can't really reconcile that with what you told us of your periods of 30 days, if I remember well from the top of my head, and 4 months. That's one part of my question, and the last part of my question is, so once you then reach a decision, what about the enforcement of the decision? What I see and what I hear and what we heard before is that schemes, and particularly the stronger ones, don't adhere to it. And then the beneficiary, not CMS, but the beneficiary itself, have to chase these very powerful companies again to try and let them adhere to the decision taken by CMS. Can I have your comments on that as well?
Well, the members' concerns are obviously they're valid, but the situation we face is when a complaint is received, we instruct the scheme to provide a response, and after that, analysis is being done, and if it's a clinical one, a clinical review gets done, ultimately to a point where a ruling is made. The challenge we have then is, in terms of our provisions, Discovery has almost 90 days to appeal that decision now, because there's a definitional issue in terms of our regulation, in terms of our section 48 and 49, where the one gives you 30 days and the one gives you 90. So now schemes have up to 90. What Discovery does in that case would be wait till the 90th day to appeal. So that suspends the judgment or the ruling. What happens then is we need to schedule that for an appeal committee hearing, which then also has to deal with the backlog. So it's not that it's deliberately taken the time. It's our processes can't cope with some of the volumes or the way in which the providers use the system. So our appeals process...
Sorry, I'm not sure that you understand the question. The first question relates to the first process. As I understand the Act, and I think it may be Section 47, I think it is, which deals with the timeline. Once you receive a complaint, and in this case, you would have received the complaint in September of 2012, I think it was. No, 2013, I think it was. Now, within 30 days, you have to call the scheme against which there is a complaint to respond. And they have 30 days within which to respond. Now, so if you receive the complaint in September, at the very latest, you'd have had a response by the middle of, by the end of, I don't know when in September, but at the very latest, you'd have had the response by the end of October 2013. And thereafter, the registrar or the council would then deal with the matter. And presumably you'd have about another month or two to deal with the matter. But in this case, the matter, at least at that first level of hearing, it took, on my estimation, approximately 11 months. Is that right?
Chair, I'll have to get the details, exact details of the complaint.
Well, I think based on what she told us,
yes.
Unless you have information to the contrary. So it took about 11 months on what she told us before there was a decision in her favor. So the question is, how long are these processes supposed to take?
Thank you, Chair. For a record, I'm Anton de Villiers. I'm the General Manager of the Research and Monitoring Unit. For this specific case, if I remember correct, there was outstanding information. So yes, the office did took 11 months to make a ruling, but we were waiting for outstanding information, clinical information. And sometimes it really it took some time to get reports from providers, doctors and so forth.
The delay in this particular case was occasioned by you having to wait for clinical information from the members. providers?
First of all, the case was evaluated by our complaints and adjudication unit. If they cannot make a ruling, then they forward the complaint to our clinical unit. Our clinical unit then deal with it at a technical clinical level, and if they need more information, then yes, they've asked the scheme and sometimes also the providers themselves for additional information before they can make the ruling.
So in this particular case, the delay was occasioned by the fact that you didn't have clinical information from the member or from the scheme?
Chair, that is my understanding. We did not have at the time all the information. That's most probably the result for the delay.
From where? From whom?
Well, I'm not sure from when, but obviously it was evaluated.
Who was supposed to give you the information?
Well, the information, my understanding is from the providers, the treating doctors.
Okay, when she told us that all the report from all the treating physicians, and I think we counted them, we estimated them to be somewhere 13 or 20, I can't recall the figure, that those documents were sent. You've got no knowledge of that?
I'm not sure what was sent and what was outstanding. I do know it was not complete. So I think it's something that we can go back and look in detail what was submitted and what was outstanding, and if possible, report back to the technical team.
Okay. And then the second part of the question dealt with the appeal. The appeal is supposed to take 90 days. It must be lodged within 90 days, is that right?
Yes.
Within 90 days, right?
Within 90 days it
Right.
may be lodged.
Okay. Now, how long did it take you to launch that appeal and to finalize the appeal? Because from what we were told, she was told by the scheme, I think it was on the 15th of July 2015, I think it is, that you told her on the 15th that the appeal is no longer being pursued. Is that when you got to know of that fact?
No, I think when it was lodged, we set it down, and I think she reported that at the point where we're supposed to hear the appeal, Discovery withdrew it, and that could have occasioned the delay.
Okay. Wasn't that almost another year later?
Yes, it was a year later, Chair.
And what then was happening between the time when she launched the appeal and the time when you went back to her to tell her that the appeal is no longer being persisted in?
I think, Chair, in her explanation, she said that CMS had made a ruling, and after that ruling, the scheme appealed that, and there were exchange of correspondences between herself and the scheme. And in as far as we are concerned, we thought that we've made the ruling. And at the point when we became aware that there was still an exchange, this was when the appeal was going to be lodged, and we set down the appeal. The exchange between the scheme and the member were not being made aware. We had thought that we've made a ruling, and when we've put down we set down the date for the hearing, and then Discovery then said the appeal is withdrawn. But I think, Chair, we can go back and look into the details of this, because I think, yeah.
I think it would be helpful, because it does seem to me that we appear to be speculating perhaps to a certain extent, because I think we need to understand, and I think that's the gist of the question, how efficient your complaint processes are. If it can take 11 months to process a claim and a further year to process an appeal, I mean, we need to know, when did you receive this and what was happening? If you could provide us with this information, I think it would be helpful when you come back next time around. But you did mention, though, that urgent emergencies or urgent matters are dealt with differently. What is an urgent matter? I would have thought that all medical problems are urgent.
There are certain categories where it's emergency cases. So most of these complaints that are lodged either after a decision is made by the funder for certain treatment. But in cases where a member needs immediate treatment, so all of those where they need immediate admittance.
So in this case, she didn't need
in this case, we only were aware of it after the claims were rejected or the payments weren't made completely, where we received the notification of the complaint.
And then given that lapse of time, you didn't consider that it required to be expedited.
It does, but again, like
and it wasn't.
Dr. De Villiers said, is a lot of information that was required was outstanding in order to do that, and that's what led to the delay.
Thank you for your presentation. My first question continues in this theme that was discussed now. The Cape Medical Plan in their submission raises this issue differently. So they argue that the disputes declared over the payment of prescribed minimum benefits puts members of the scheme in adversarial positions and while the disputes are pending, suggesting that the delays might be quite common. So in your response to them, in your written response to them on page 27, you say the CMS experience as a regulator has been that providers are reluctant to institute legal action against the patients as it results in legal fees that have to be paid. Then in a few lines below, you say there should be no reason why members should be financially disadvantaged based on the fact that when the dispute is resolved, there will be a clear indication if they were entitled to the benefit, in which case the accounts will be paid. Given the evidence we heard this morning from the first presentation, the delay and the amount of catastrophic expenditure that they had to incur, do you still maintain this statement?
So your statement is that when we made the point about the catastrophic...
That you say there should be no reason why members should be financially disadvantaged based on the fact that when disputes are resolved, there will be a clear indication if when they're entitled to the benefit, in which case the accounts will be paid. So to me, the statement does not take into account that people actually have to pay upfront while they're waiting for the matter to be resolved, which is the issue that Cape Medical Plan was raising. So here you say there should be no reason why they should be financially disadvantaged. So that's what I'm asking, if you're still maintaining that members, there should be no reason that anyone would be financially disadvantaged while they're waiting for disputes to be resolved on the payments of PMBs.
Yes, they should not be financially disadvantaged. But I think the issue around PMB claims is that, and it came through in the Code of Conduct, in that when determining if it is a PMB or not, there may be a situation where the member may face some of the payments, especially if it's not in hospital benefits. So then that's where sometimes the weight comes in to see whether the member would be entitled. And in a case where it is a PMB, the member should not be disadvantaged.
Chair, if I can add, if I can quote the PMB Code of Conduct, page 6, paragraph 7, where a medical emergency is provisionally diagnosed and is not confirmed by additional medical evidence, the scheme will be held liable to cover costs as PMB benefits up to the stage where a PMB condition has been excluded.
My point is that in your earlier slides, you say you represent the members, the beneficiaries of medical schemes. To me, what the statement indicates is no appreciation of the implications of not having PMBs paid. And so when you say that members should not be financially disadvantaged, so if there is a dispute over a payment, who then pays? And does that not qualify as being financially disadvantaged because of the dispute?
It does. The scheme must pay up to that point.
So you do agree that then you are no longer in agreement with the statement that you've made here that they shouldn't be financial, because they are in practice financially disadvantaged if they have to pay until the dispute is resolved, in particular if they're resolving the disputes take the amounts of time that we've heard this morning.
If it is an emergency, it is clear the scheme is liable until it is demonstrated that it is not a PMB. Yes.
But these aren't when it's not an emergency?
If it is not an emergency, there's a process that the scheme must go through according to the PMB Code of Conduct to identify whether if the claim was a PMB or not. If they follow that process, they will be very accurate in to classify schemes accurately. The bulk of the claims, at least we've heard previously, more than 90%. If there's not enough evidence to classify a claim as a PMB, then at a later stage, once the evidence is available, maybe from a histology report and so forth, then schemes must then go back and reverse the claims and make sure that it is paid out of the risk pool.
Yes, I understand all of that. But in the meantime, while you are resolving that, the member of the medical scheme is financially disadvantaged. Do you agree with that or not?
I agree with that.
Okay, thank you. My second question relates to your slide 11, when you talked about poor management of medical schemes. And I just wanted to get a better understanding of what in practice would constitute poor management. What factors would you look at?
Oh, okay, thank you. Some of the aspects that we refer to as poor management is like conflicts of interest, for example, and procuring some services or goods without following the right internal process or your policies as a medical aid scheme. Those would be some of the examples.
Okay. And then later you talked about the training that you provide to trustees. I think you quoted you trained 40 trustees and 10 were declared competent, and then the other 30. And I just wanted to know what were the reasons for not declaring the other 30? What were they lacking?
Well, it's a new program that we've embarked on. It's an accredited program with SACWA. So it's one where members can get accreditation to be a trustee. So it's a new program, and they have to do certain exams and tests to be able to be accredited, and that's where the 10 were declared competent in terms of that program. So it's a new program that we've...
So would you declare the other 30 incompetent then?
I think not. Yeah. So in terms of the program, then all of them attended. So they would be declared that they have been part of the program and have attended. The 10 would be the ones that have completed the assignments and all of that. So they have attended the course. So they do get acknowledgement that they have attended it. So it's a new program that we've brought about. But those ones that didn't complete still have an opportunity to do that, to complete the program.
Is it voluntary for them, or are they required to?
It's voluntary.
Sorry, my last question is on slide 12. When you were talking about the attendance of the annual general meetings, so I wonder if you could give us, on average, what is the percentage of members who attend these general meetings across the board? And first,
well, I think we do not have specific percentage, but the attendance is very, very poor. We are just concerned about that. We could go back and look into the number of AGMs we have attended and work out percentage per the sessions.
Do you receive reports from the medical scheme as to what's the attendance at these general meetings are?
Yes, we do, because we also attend by way of being observers.
So you not only go to these meetings to observe them, but in addition, you receive reports from the...
Yes, we do receive reports.
And you've got those reports?
Yes, we do.
Okay. I think those are the reports that we would like to have a look at.
Thanks very much. I just want to get some clarity on some of your slides. On slide 23, your issue around quality. Do you require any quality reporting? If so, what indicators do you use? And if not, is this something that you want to do? Are you in a position to force disclosure? I suppose the real question is this in the Medical Schemes Amendment Act in any way? And if not, should it be?
Well, further on in the presentation, we had a slide on quality. We have started collecting information to determine indicators for quality in the environment. So we want to do more in terms of determining and doing an assessment of quality. At the moment, we've done it for 7 of the CDL conditions, and we are expanding on the list every year.
And is the environment such that you're able to demand this information and you're given it? Is the environment such that you can do it, or is it voluntary? And if it is just voluntary, should it be something that should be legislated?
Thank you, Chair. Some of the indicators we collected through the annual statutory returns, and that is mandatory, it's not voluntary. So we started for the CDLs where we collect process indicators and outcomes, And we believe the more we collect and more we report back on quality, hopefully that will have also a positive impact on the industry in measuring quality and make sure that beneficiaries do get quality treatment.
I understand that.
But,
and I'm pleased you're doing it, and great. My question isn't about if you're doing it. My question is the environment such? Is it enabling enough for you to do everything you want to do in terms of measuring and reporting quality? And do you need anything in that environment to change?
I would say in the beginning phase of the collected data. The data quality can improve over time. The lowest level that we do collect data through the statutory returns is at benefit option level. We do not have the capacity to go lower and collect data, raw claim level data. That will definitely help us. But the quality is also part of the accreditation process. Going forward, the MCOs must demonstrate the value proposition to the Council of Medical Schemes. And if they are not able to demonstrate that value, then definitely we can ask the question, are we going to accredit them going forward? And I hope that will improve the process, and it is part of the accreditation process already.
Now, those who are required to supply you this information, do they cooperate with you when you are looking for this information?
All the schemes did submit their data on the health quality indicators through the statutory returns because it is mandatory. On the accreditation process, we've just defined the variables and the data spec. We haven't started to collect the data for the accreditation process yet.
So I just want to ask this question one more time. Can you ask for what you think you need, and must they give it? I understand you're still developing it. I understand that you might change it. I understand all those things. What I'm asking you for is, does the current legal environment allow you to ask for everything you think you will need, and does it oblige them to give it back to you? Yes or no?
I think yes. At this stage, yes.
Thank you. That's what I'm trying to find out. And in terms of disclosure, you say you're going to disclose it. Disclose it to whom?
The results. Well, we will publish a report for the industry to see.
And this would be in your annual report? This will be on your open side of your web page?
It could be part of the annual report in one of the annexures where we will publish the results by benefit option, or it could be a separate quality report.
And there's no restriction on you making that publicly available?
No, not so far as I know.
Can you please go to your slide number 36? Maybe you can put it up on the board so people can, that's a bit boring for them otherwise. I just don't understand the percentages of what is going on in this slide. I think maybe the title isn't so fabulous.
The percentages is the distribution of the beneficiaries over the 9 provinces, as well as the distribution of the specialists over the 9 provinces. So, for example, if we had 100 beneficiaries for the population, then what was it? 40% was in the Gauteng province, and we compared it with the availability of surgical specialists in that province. So both bars, the blue bars and the orange bars, are percentages. So you compare the percentage of beneficiaries in a province compared to the percentage of available surgical specialists in a specific province.
The correct title would be something like percentage of beneficiaries and surgical specialists by region.
Yes.
Okay, thank you very much. You mentioned that on slide 41 that the biologicals are not required in terms of PMBs. And I just wanted to understand what you meant by that. If biologicals at some point became evidence-based standard of care, would they not then, by definition, be part of PMB treatment? I understand they might not be now.
In terms of the definition of what is included in the PMBs is what is prevalent in the state. So you have to compare what is state practice or level of care, and then that's what PMB's levels are pegged on.
So biologicals, if they were standard of care in the state, then would be a PMB. Thank you very much. It's not that they're not defined as PMBs. Okay, thank you very much. In relation to your slide 46, this is where you list the options by design, and they have the following benefits: in and out of hospital, medical savings account, self-payment gap, threshold benefit, preventive benefits, day-to-day benefits. And part of your brief, as I understand it, is to make sure everything is understandable to beneficiaries. How understandable do you think these things are? Do you get a lot of complaints about lack of understanding about these, or are you comfortable that all these terms are self-evident and understandable to beneficiaries?
Most of our complaints relate to PMBs and more about how to access PMBs. That's the biggest issue. In terms of the day-to-day benefits, it's just a matter of where the monies come from. So you either have a savings account or you have it being paid from risk. So it's not like a medical savings account. But the biggest chunk of complaints relate to PMBs and short payment of PMBs and those sort of issues, misinterpretation of PMBs. There are other administrative issues, but those are more like cancellation of membership, contribution issues, whether you're unpaid and those sort of things, but not around understanding of benefits.
Okay, that's interesting because some of the members of medical schemes have presented data to us saying they are confused by the options. The brokers have told us that they're absolutely essential to the market because the options are so confusing. The schemes have told us they need multiple options because everybody's different and everyone needs an option designed to their particular benefit. And in your data that you've presented us in a previous submission, you make quite a big point about the number of options available and the fact that every time you have a new option, you have a smaller risk pool. And that the small risk pools are problematic because it's quite difficult then to cross-subsidize. So does the CMS believe that it has a role to play in terms of simplification or minimization of the range or any advice in terms of options, design, option numbers, and its relationship to the sustainability of the industry?
Well, if we speak about the number of options which we've put there, historically, when we speak about scheme rate, we refer to the 100, 200, 300% options, if you're aware, when RPL was still around. But the problem with that system was it wasn't, if you said 100%, doesn't mean 100% of your claims will be paid. It's 100% of the RPL rate. So scheme needed to differentiate its options by the level it paid specialists, and this relates more to non-PMBs. And that's where it started the differentiation of options, and it led to the differentiation in the pricing and the profiles. What has happened now is in order to provide a comprehensive range of options, some schemes then have to introduce options at different levels with different benefits to deal with the markets that they need to appeal to maintain their membership. So that's where some of the schemes introduce new options to deal with that. I know the other issue around complexity, there is a role for us to play. We all constantly trying to simplify benefits, making schemes to simplify benefit structures and explain it to their members. We've published guidelines as to how do you explain and what should be part of benefits. So that's where Section 33(2) comes in to say what is the minimum requirement and what additional benefit should be allowed in a benefit option.
I understand sort of how it all developed, but my question really is if the CMS has an opinion on the relationship of the number of options and the sustainability of the industry long term. Are lots of options a good thing? Are they a bad thing? Or do you have no opinion on the subject?
Nondumiso Khumalo. Prof, I think at a very high level, trying to cover your question, my response would be, you would have seen that in the initial submission, we did highlight that actually the Medical Schemes Act, as we have it now, it does have gaps. You know, initially when the Act was conceptualized, there were certain pillars that were supposed to be there to support, you know, the other pillars that are there. So part of the problems that we have now, whether it's issue related to the cost of PMB, the non-payment access issue, all relate to the fact that certain other provisions have been delayed, probably for good reasons, you know. So because there is no mandatory participation, and we are interested in ensuring that the industry grows, because we are interested in financial protection of other people, you know, the 8.8 million members. Should there be no financial protection of those members, you know what would happen? They would go to the state and it would just become a catastrophic problem. So whilst we understand that these multiple options create some challenge in terms of members understanding what the differences between these options, but the schemes also are put in a corner in a sense that they're trying to grow their risk pools. You know, so I think it's one of those tensions that exist, and probably the Competitions Commission's work will also assist the industry and CMS in addressing such problem.
Well, we'll try. If you give I'm asking your advice on what you think we should do.
Well, we're assuming that the panel will be able to get information from the scheme, you know, also in terms of, you know, how have these options benefited, first the risk pools themselves within those options and the entire pool of people covered by those schemes. And if they are lost in terms of efficiencies, then of course, the option design and fragmentation of those options probably would have to be in line with what maybe closer to what the World Health Organization often recommends, that sustainable pools should be anything above, 30,000 members and above, because there you have sufficient cross-subsidization between members. But with that provision, there will be, consolidation is a problem already in the industry. It depends how you look at it. But if we're saying that, these pools are too many, they need to consolidate, they will I think that work also will require detailed research so that we don't create more problems in the industry.
So then let's go to the discussion that you put in your original submission around risk pools. One of the issues that has come up a few times from the schemes presentations and what's in your report around some of the option benefits being non-viable, that they run into losses. One of the, I think that the way they put it, and the fact that that each option has to be self-standing, the way that they put it in the evidence before us was that the CMS is lenient or pays less attention to whether each individual option is in fact viable, and that in fact sometimes there is cross-subsidization, and at this point you haven't done anything about that. My question to you is it the case that how necessary is it that each individual option be individually viable because they are, it seems to me, maintaining their viability by sharing risk, a kind of almost internal risk equalization inside the schemes. Is that something you're worried about or not? And if not, why not? Maybe it works.
I think in a way you answered the question around the risk equalization argument. The intention was that if you have an environment with open enrollment and community rating, schemes that will want to compete on profile. So if you have an equalization mechanism, then you wouldn't need schemes trying to get young and healthy members because they would end up being net payers into the fund. Now, in terms of the CMS being lenient, I think our view is that schemes need to have a plan as to how they're going to maintain those options and ensure they become more solvent, because some of them would require increases overnight to make them solvent or to bring them up to the self-sustainable level that regulation or Section 332B requires. So in the absence of an equalization mechanism, this is how schemes have tried to manage the higher risk patient or members in their scheme. What we've seen from some of the evidence is the sicker members go to the more expensive options because they get more benefits, but it then obviously costs more to provide benefits for them. So there is a level of cross-subsidy, but it has to be managed so that the scheme doesn't run into a risk of large deficits, which is carried by the rest of the members of the scheme.
So just to finish that part of the conversation, as I understand from your presentation, you are still running the shadow risk equalization fund. So if that's the case, how ready are you to implement a risk equalization fund?
Chair, yes, we continued with that process to collect the data for a REF, now called SRM, or Scheme Risk Measurement. We collect the data annually now through the statutory returns for the first time. Previously it was a voluntary process, now it is a mandatory process. And we do publish reports, annual reports, and also individual scheme reports where we give them feedback in terms of are they a net payer or a net receiver and how much. In terms of are we ready, we still do have expertise in the Council for Medical Schemes who worked on the old REF project, but in terms of systems, we are not ready. And that will take some time to develop a new system and to roll it out to the rest of the industry.
You made the point in your presentation, and it's also on page 11 of your response to the statement of issues, that there is not a visible transfer of economies of scale to members. You don't, and you refer us to circulars. In those circulars is the evidence that leads you to this conclusion there, and also what needs to change to make that happen, that those benefits are in fact passed on to members?
I think one of the issues that we have is the providers that provide the third-party services are for-profit entities. So their drive and requirements are different to the medical scheme. You heard some of the administrators saying it's in our best interest to get more members because more members mean more fees and more profit. So there's no mechanism to limit or reduce that. We don't see the benefit of an increasing administrator reducing its cost to medical schemes. That's where the governance aspect comes in, where those boards of trustees that are trusted with entering into those contracts have to ensure that by signing up or having this benefit for its members, over time, if they increase membership, it will ultimately benefit them. So we don't see that coming through in the savings to members directly. What we do get is, we're getting a fantastic service, or we have certain systems and programs in place that are better than others, but we can't, and the challenge we have also is splitting the cost of providing all of those services, because if you had to compare fees across the industry, you have to compare like to like. And you can only do that if you can split out the service and the cost of each service to say, is it more or less than a competitor? We don't have that detail at that granular level. So that's something that could assist in getting us or determining how we could achieve economies of scale.
So the question is there something that needs to be done about that? Is there something that should maybe go into the medical schemes amendment bill? Is there something that should go into the rules governing trustees? Is there something that needs to be done to make that happen, and what is it?
Yeah, there are provisions in the medical schemes amendment bill around the capping and the reducing of fees. At the moment, there is a provision, but it deals more with just the fee aspect, but not the overall administration cost and managed care cost that schemes enter into. So that's one of the issues. And then also, when we talk about governance, we also talk about conflicts of interest and related parties for trustees. So we want to remove that link as well because of the interests of some of the trustees and schemes. So I think that's we do see that if we introduce that, it will improve the governance aspect of medical schemes.
So are you telling me that we don't have to worry about that because you've thought of it all and it's already in the amendment?
I think from your perspective, there's always something that we can do more to make us enforce the act easier, make things easier in the market or make it easier to regulate. So I'm not saying that's the final best solution, but in terms of legislation, that's what we can introduce, or controls we can introduce to manage that. Other options and solutions and that were given is, what about not-for-profit administrators? What about not-for-profit service providers like your hospitals that are not-for-profit or HMOs? For example, in our submissions, you'll see we talk about the HMO model in the mining industry where the hospital employs the doctors. They have a special exemption or condition in terms of the HPCSA where they can employ doctors. So I think the entire environment can benefit from moving away from the profit incentive to a more service and benefit orientated industry. So I think that's something that would always improve the industry.
Well, can I remind you that this is your opportunity to tell us this, not by inference or suggestion, but a positive recommendation. And if we had it in front of us, that would be helpful. So maybe in another session, you might want to put that down rather than hint. Okay. I just want you to check on page 29 of your response to the statement of issues. I just want to check on page 29B, the first bullet point. Is that supposed to read medical scheme administrators?
Yes.
Okay. All right. So it's just, we should correct that. On page 32, coming back to your point about brokers, you make the point that, okay, sorry, I understand that. Let's cancel that. It's more than enough questions. Some of these we can put at a different page. On page 41, your figure 12, is that figure supposed to say females on both sides? And then, if so, where's the males? I'm just a bit confused.
Open, actually, it's open and restricted, not gender.
Okay, so we can take the gender off the top.
Yeah.
So the title's wrong, and it's not females, it's just open and restricted. And I don't know what happened to the gender. Maybe you wanted another figure. On page 44, the second last paragraph, the last sentence, you say, within this context, the level of supplier-induced demand continues to persist within a market that is highly concentrated. So I wasn't 100% sure when I had read this that there was evidence that related to this conclusion. Do you have that evidence? And if so, can you provide it? And if you don't have that evidence, what would you suggest would provide conclusive evidence of this?
As you would be aware of issues related to supply and use demand and accessing data towards that, it's a bit of a challenge for us because, as we mentioned in the beginning, that through the Medical Schemes Act, we are only able to intervene at the demand side of the market. And by its definition, supply and use demand is something that is being done by the providers. But we did also mention in the submission that we also have anecdotal evidence where such instances have been highlighted by the schemes. And as we were following some of the presentation by different schemes, they did also touch into issues related to the inducement of demand.
So am I correct then in saying that you think this is happening, but you don't know that it's happening?
Just maybe to provide more clarity, the inflation work that we do at CMS, just unpacking what, at a slightly lower level, those two variables that Paresh discussed, the portion of utilization, there is a percentage which is not explained by any of the factors that he highlighted there, and we often classify that as a residual utilization. So by its definition, it means it's the supply side behavior impact on the demand side, meaning it could be supply induced demand and its impact on the demand side in terms of claims experience in the industry. So we would have such, but it's just proxy indicator. It would need to be investigated even further. And the engagements that we've had with your technical team, where we were actually giving them background information in some of our reports, we did highlight that residual utilization as it relates to provider behavior and issues related to supply and use demand is something that is difficult to quantify, but it is something that is there. It would need an entity with a regulatory power who can then ask for information from the supply side to get that information. So probably at this moment we can treat it as a hypothesis which would need data to either accept it or disprove it.
And the documentation showing that residual amount is in our hands. We have it.
It's Pamela and colleagues.
Fine, thank you.
So I do need to interrupt these proceedings at this stage. There is a group that comes after this, which is pressed for time, and they do need to leave by 2:30. I need to see how we can manage their problems. So shall we take the lunch adjournment at this stage until... Okay. Can we take the lunch adjournment until 2:30? Guys, would it be convenient for you to come back at 2:30? Yeah? Yes. Okay, very well. We'll take a tea break now and come back at 2:30.
You say yes to the match. You don't come with excuses. You don't come with excuses of what you can make more efficient. You just resources.
the explanation. Oh, thank you.
I think we should get ready to continue, please. Dr. Pengo, are you ready? Yes.
Yeah, my first question is actually regarding risk equalization. Are you familiar with the Minister of Health's submission for this, the position regarding risk equalization?
No, I'm not familiar.
Okay. Well, as far as I can remember, there is the position is that of reluctance to support the implementation of risk equalization at this time. Am I right?
That is my understanding also, and that is why the project was also stopped previously, yes.
Now, what is the implication of the fact that you have also highlighted that slide that shows the variation between risk profiles of the various schemes? What the implication is that clearly two entities that are on the same side, but also it is in the process included in the bill. What should we read about the prospects of having this intervention becoming reality?
For the protection of the risk pools, we believe that risk equalization is very important because schemes do not compete at the same level. There are significant differences in their risk profiles. So for a private medical scheme industry to be more effective, that they compete at the same level on quality, we believe that risk equalization is very important. Our submission was also made before the NHI white paper was released. And I think in the light of the NHI white paper and the role of medical schemes going forward, obviously that will be discussed in those NHI working streams. But to have a sustainable private medical scheme industry going forward, we still believe that the system of risk adjustment can assist in that.
I mean, the annual reports that CMS puts out, in your view, are they supported universally by all of the industry stakeholders?
The report themselves, yes.
Yeah, the annual report.
Because they use the statistics in a lot of work that they do, if you see in the presentations.
Yes.
It's the only report that gives quite a comprehensive view of the funding side of the industry. Yeah,
I suppose the more direct question is, on the delivery side, is the report as widely accepted as on the funding side?
Delivering meaning the
hospitals and professionals. Have there ever been challenges regarding the contents or the analysis that's contained in the report?
We've had a few providers coming to the office to query about this, and that when they think that the statistics that has been put forward makes them look bad relative to their group, they often come to the office. But I think those engagements, have been minuted, and in most cases we would always offer some collaboration between us and those stakeholders, where we've said, if in order to ensure that everybody is satisfied with the work that we do, we always say that they must give us access to their data so that we can triangulate with our data in doing this analysis.
How far is that process, if it's ongoing at all?
With the private hospital groups, it went as far as getting them to participate at ITEP, but even that participation in terms of access to utilization data, they were constrained by issues related first to the legislation that we are not their regulator, so they cannot give us access to their data, but they can participate in the ITEP process because we have a variety of research projects that are meant to ensure that there is public participation in the industry so that they know where CMS is going and the kind of research work that we do.
But is that ultimately a goal the CMS would like to achieve, where the data is coming from various aspects of?
Yes, Dr. Pengu, because for us to be able to understand the market comprehensively, we would need to have access to for data within the supply side as well as the demand side. At the moment, the data that we have is the demand side data, and then the experience that they have when they are contracting with the suppliers. Okay. But we don't have actual primary data from the suppliers, though we can provide proof to the Commission that shows that we have requested this data, but it hasn't been forthcoming for a variety of reasons.
But would I'm just thinking, would its inclusion in the amendments of the bill, is it something that you've done? Is something that you've considered? Would it? I don't even know if it could be accommodated within Medical Schemes Act. I'm just asking if.
In our initial submission, we made recommendation that a stronger collaboration needs to exist between CMS and the Office of Standards, because by proxy, the Office of Standards collects a variety of data from the facilities and, the data that relates to quality. But for us to be able to demonstrate value of the expenditure trends that you see in our environment, we would need to triangulate that data with the data that is with the Office of Standards. But we have that in the submission that we made.
Okay. No, a lot of the other questions have fallen away, but the one that I also want to find out about, you've also made reference to the need to have between schemes and administrators an arm's length relationship, and I think the tangible step that you also referred to is the one where you've highlighted undesirable practices that I think along those lines. But I just want to be a bit more specific whether the issue of captured trustee boards is something that is a problem for the CMS. Is there any evidence that it happens?
In instances where we've investigated and found that there is evidence, that's when we institute sometimes the Section 46 removal of trustees or curatorship of trustees. So where evidence is there, we do take action, and that's the method that we use in dealing with those trustees.
Meaning you intervene after the effect. Is there anything along elections in terms of AGM? Is there any intervention at that point? I'm aware that the issue is always about balancing attendance. It's about obviously members of schemes being far-flung. I would imagine if that is the case, there has been reference to the abuse of proxy votes. Is there anything that council can do to nip the bud at that? But of course, if that's not an issue, let me know. I'm just raising it because it has come up.
I think there's obviously a lot more we can do. We do what we can do within our budget and our resources to do. That's why attendance of schemes is important, of scheme AGMs is important, and also the routine inspections that we carry out with medical schemes, because then we can preemptively review the practices of a medical scheme and in ensuring that they are transparent and open. What we do get is constantly we are challenged when we want to go and do an inspection on medical schemes repeatedly. So that's again some way we need more power in terms of the legislation to do that, and that's where it's lacking. We don't need to always go and get challenged in court for doing what we're supposed to be doing in terms of inspecting schemes. So there's a lot of things that lack in our legislation that we'd like to improve, not only powers but also resources to do a lot of that thing. So we do it, but we do it in a controlled way every year with medical schemes. That compliance instrument is one way of getting schemes to voluntarily provide the information without us having to institute inspections and get blocked. So that's also another element that we've introduced to try to enforce governance.
Just regarding the general practitioner coordinator role, what is the council's position? What's the council's preference? Whether members should be in a position to self-refer to specialists, or whether they should go via general practitioner?
In the submissions that we've made to Competitions Commission as well as the Department of Health, the National Health Insurance White Paper, we actually have made recommendations and are supporting the changes in the market structure. As it is at the moment, we do understand the impact of benefit design, that the PMB is hospice-centric, but if if it were to be implemented in an efficient manner, it would have to have strong emphasis on primary health care level service providers. Therefore, GPs would play a prominent role, but not only GPs, even nurses would play a prominent role. We do know that from the PCNS data that we have access to, that there are certain private nurses that actually are providing services or an active stakeholder in our market, but they are not a prominent stakeholder in terms of expenditure. Hence, you see the cost drivers always being, the specialists are up there. But we would, one of the recommendations that we would put forward to the Competitions Commission is changes in the market structure, because currently the market is inefficient in the way it is structured.
But when you say changes, what is your preferred way? Is it along incentives and disincentives, or are you talking about hardwired rules that enforce primary care? Which is the way you prefer to go?
It would be a combination of both, because you would want to have hardwired rules, for example, when it comes to the licensing of these private facilities. Or now I'm now talking about facilities. But then, because it is the same discussion, you would want to have more primary health care facilities with GPs, as opposed to people just going to specialists. And some of the specialists, as we know, they have consulting rooms within hospitals. So, and then when it comes to also innovative contracting, we would encourage, and in fact, in the documents that we've given Pamela and colleagues, we have spoken greatly about encouraging the schemes to enter into arrangements with GPs and other low-level health practitioners.
Yeah, because obviously the concern is the progressively declining share of primary care practitioners of all kinds. And the last question really is whether through the model rules or all other tools that you've got, is this a sufficiently concerning issue for the CMS that it's doing something about it?
We've always communicated with schemes to have, and we've seen that over time that they are developing more comprehensive ways of dealing with members and applying preventative treatments for their members or tests that they do. So it's always a promotion from us. When we do engage with schemes also, we do encourage them that they should use this gatekeeper or coordination of care approach in dealing with the benefits. What we do have is, in instances where there's plans with no discretionary or day-to-day benefits, that's where we lose the ability of a scheme to enforce or try to apply this coordination of care. Where we see it working well is in the network type arrangements where there's good coordination by the service providers in terms of level of care. So I think it's a work in progress, and we can do more to try to get schemes to have a better management of members once they accessing care.
Thank you very much.
One of the criticisms that we heard from some of the people in terms of cases that are brought to the CMS is that the CMS gives a ruling on a case-by-case basis, and they don't class similar things together and then give a class ruling, or do systematic investigations looking for similar such problems. So this can come up around when PMBs are handled in a particular way, or, for example, instructing an audit of medical saving accounts when things should be paid from the risk pool or that kind of thing. Is there something that impedes your ability to do this sort of class investigation rather than the case-by-case basis? Is this something that would make you ultimately more efficient and be able to not have so many individual cases? Is there an issue there that we should be looking at?
I think definitely there is room for something some enforcement mechanism to allow us to do that. To give you an example, the code of conduct came about when we started that process with all medical schemes, where we identified schemes paying PMBs from medical scheme savings accounts. And what started was an enforcement process with each and every medical scheme to reverse those payments and pay PMBs correctly, which resulted in the code of conduct. But even then, the code of conduct is a voluntary agreement by medical schemes and not something that we can enforce directly. And that's where, in our MSAB, one of the ways in which we deal with it is improving our enforcement or our powers as a regulator to make decisions and enforce those decisions on medical schemes. Because on a case-by-case basis, we'll be constantly challenged. But I think there is value in looking at having those powers in doing that.
And is this covered in the amendment or not?
It is covered more generally in terms of the powers of the regulator, because when you make a decision or you have a directive to the industry, it needs to be enforceable directly to those medical schemes. At the moment, we have circulars, press releases, and directives which constantly get challenged in terms of their legal status, whereas from our view, it's a directive, it's ordering schemes to do certain things, and that needs to be complied with. So it's just strengthening that provision.
So that brings me to another issue that we've heard from either submissions or in the public hearings is they think they can rule by circular, is I think the expression that we've heard a lot. Is that a legitimate problem? Are you allowed, you're allowed to put out these circulars. Is it legitimate for you to expect people to do what you say in those circulars? And the other issue is that if you take this code of conduct, it's an interesting thing. It was actually something that was done by negotiation with all role players. It seems to me it should have buy-in. It was a bottom-up process, all those kind of things, yet apparently... So what do? If you do a participatory process that everyone participates in, you come up with an agreed code of conduct, was that everyone agreed to ignore it or everyone agreed to do it? And so there needs to be some kind of enforcement of it, particularly if people agree to do it. Are these things taken care of in your amendments, or do you think the proposed amendments need to be strengthened in some way?
They are dealt with in our proposed amendments. I can give maybe more details if you need from our legal department, but what we do find is, for instance, schemes run close to the edge until they're found to be doing something. So as a regulator, it's very difficult to be the regulator for every single transaction and every single practice that medical schemes do in terms of what resources that we have available. So we have to balance as much as we can with our priorities in terms of what is required in the Act, and also picking up the non-compliance matters as much as we can with medical schemes and trying to deal with as much as we can. But that's where we also, like the comment made earlier, we have limited resources against big companies that can do a lot of things until you actually find out, and then to actually get the enforcement is difficult because it then becomes a legal process. So I think it's maybe just more also a nature of the industry. It's not everyone wanting to do, having the same intention and purpose as we have in terms of trying to protect and ensure members get their benefits, whereas you're seeing commercial entities having a different incentive and drive versus medical schemes, and that's what makes it difficult to enforce the Act completely or fully.
So how is that remedied? Is it the case that you need more resources, you need more staff, you need more money? What's the solution to this problem? You need I don't know, more lawyers? What is it?
I think resources will always make a big difference. And also being able to react faster to changes in the industry. For example, if we need an amendment to the Act that will deal with certain issues. For example, if you look at other legislation like income tax, for example, if there are gaps, they can be quickly closed by amendments to legislation. We don't have that convenience. We have to appeal and make a case and then still not certain whether it will still be accepted or taken to the point where we can actually have it enacted and applied. So that's also a challenge for us. So not only resources, I think that's very important. There needs to be a point at which there's a balance of over-regulation versus under-regulation. So you can't assume that throwing more money and being a better regulator is going to improve compliance to a certain extent. We need also other things like being able to change legislation, having more powers in terms of being the regulator and getting the schemes to comply. What makes it also then a further element is providers are not regulated. So even though we may regulate schemes efficiently or better than providers, we don't have control over what providers do, what hospitals do. So there's an element that we also don't have control over, which one of our recommendations was to strengthen, either introduce some way in which the entities can be managed or regulated. One of it was trying to manage costs, and that's the pricing authority and things like that. But also in terms of quality and practicing, that's not something that we can manage for providers and hospitals. So there's a lot of things like that we've put in our papers to say will help us.
I mean, have you raised these issues before, and if so, with who?
We've raised it, and I think by raising it, it's resulted in submissions in terms of amendments to our Act, submissions in terms of our resource requirements to National Treasury. We've constantly...
So are these issues presently being attended? Is that what you're saying?
They've been put forward. Whether they would be...
How long ago was this?
Constantly. Whenever we go through our budgeting cycle, there's motivation as to why we need additional resources. The challenges...
Since when have you been raising these issues?
Since 2010 or so, we've been raising issues, and that's when the PMB review was presented to the department. When the MSAB that was done previously didn't go through, we've introduced another medical schemes amendment bill. So we are doing it in every channel we have available.
So are you suggesting that since 2010, you've constantly been raising these sort of issues that you've just described now, and that those issues have yet to be attended to?
Yes, to the more structural issues, yes. The ones that...
What do you mean by more structural issues?
For example, like the risk equalization fund and things like that.
I mean,
but for
the resources, the kind of things that you require to work effectively and efficiently.
Yes, Chair, I think in terms of our budget, we always, every year, we're raising these resource requirements and express our frustration with regard to the limit that we get from Treasury, because our budget is approved by our minister in concurrence with the resource requirements we are raising almost every year.
And they're not being attended to?
No, yes, they're not being attended because in some instances...
Yes, I understand. Understand. Yeah. And this has an impact on how efficient you run your council?
Yes, Chair.
Yes.
One of the other issues that came to us in relation to the pharmaceutical industry, one from the ICPA and another from, I think also from them, was about the discounting of medicines, which they said the CMS upheld their complaint that you can't discount medicines, which apparently some of the schemes are doing through loyalty cards. Does this sound familiar to you?
Okay, so yeah, this complaint relates to a scheme, not the scheme itself. It is a loyalty program that gave members cashback if they used one of the providers. So, because and then again that product is not something that is regulated by us. We had a ruling, we had an appeals hearing on that where it was dismissed because that product is not something that the CMS regulates. So even though they had the complaint, we couldn't really make a ruling. We can't enforce any of our provisions on those providers. And then I think, is that the only one relating to?
I think there's another one which I think does fall within your jurisdiction, which had to do with the penalty fee charged on not using a DSP and then the medical scheme paying less than the SEP.
Yeah. So what happened there was they raised a complaint with the minister on them not being able to enter into contracts with medical schemes. And very soon after that, the two largest medical schemes opened up their DSP process and allowed them on. So your Discoveries and GEMS immediately acknowledged that there is a flaw in the way some of their contracts are done with the retail pharmacies. So their argument was, if we charge the same dispensing fee as the retail, then why shouldn't we be allowed to enter into a contract, which they have been. To this extent, they haven't demonstrated whether they still have that problem and to what extent, because we know the largest medical schemes already acknowledge it and have them part of the network. We've also made a comment on the regulations around co-payments, in that in an environment where you have a regulated price like the SEP, then there shouldn't be a penalty for someone that is obviously they're complying. The only penalty should be on the dispensing fee part, which is discretionary by the pharmacy.
Okay, so then maybe some advice to you is to contact them and rectify it, because their sense is that you've done nothing and you haven't ruled on it and blah, blah, blah. So maybe you'd like to get hold of them and tell them again what you have done, because they think you've done nothing.
We've actually investigated it once they've laid the complaint, and we've given them comprehensive responses and provided that to the department, saying, based on this, we recommend that some of the provisions around DSPs and co-payments need to be amended in the regulations to deal with it. But we will go and we will contact them and engage with them on that.
And then just want to clarify, everyone's asked this, but I just want to clarify in my own mind. One of the things is we're seeing the minister on Friday, and one of the questions we might ask the minister is why the PMBs haven't been reviewed. And if he comes back to us and says, well, the CMS hasn't done their part, I mean, what's the real story? What is the delay? Why? Is it you? Is it him? Are both of you passing the buck? What's going on?
Prof, if I can respond to that. The PMBs was revised and submitted to the department in 2010. Thereafter, for a 2-year period, there were various interactions between the department and the CMS. The industry itself, experts from the industry, we've used experts from the industry to help us with the revision of the CDL algorithms. So all the CDL algorithms were revised, and we also cleaned up the DTPs up to a certain extent. The last submission to the department was in October 2012. Then in 2014, we've received feedback from the department that we need to include more preventative and primary care into the PMB package. The CMS worked on the preventative and primary care to be included. We've halted that process now with the publication of the white paper, because we need clarity on a PMB package going forward, because it will determine the role of the medical schemes going forward. Why we've stopped that process preliminary is because in a white paper it is clear that schemes will not be allowed to offer duplicate benefits. That is what is in a white paper. So if primary care is being offered through the NHI, then it is not clear to us will schemes also be allowed to offer primary care through the PMB package. So we need to get clarity on that and what is the role of the medical schemes going forward, and specifically on the PMB package. That is where we are now, and hopefully we can get clarity through one of the working streams under the NHI.
So the short answer is that you've made submissions to the department, but the matter has been put on hold because of the NHI. Is that right?
Yes, I can also add the confusion around bipolar, mood disorder, and major depression was also revised in the submission of 2010. So that was addressed in that submission, but we need to get feedback on the process going forward.
It seems to me, by the Ministry's own admission, the NHI is a process rather than an event. Are we waiting 3 years, 7 years, 12 years? I mean, shouldn't you be doing something anyway?
Now, it is important to continue with the work because the NHI can take another 3 years, 10 years, I'm not sure. And it is important to clear up the definitions, and if we must include preventative and primary care in the PMBs, then we must continue with that process. But it will be very helpful if we can publish a package or revised package every 2 years. I think one of the challenges is not to follow a so-called big bang approach and think you're going to correct everything in one submission. And that is why we need to revise it every 2 years and make incremental changes and improvements to the benefit package.
I think we just want to avoid the point at which it just goes round and round in a circle. Are you, say they said, okay, do it, can you start tomorrow and finish next week? I mean, how ready is ready?
Next week, no, because we've got limited resources, definitely. That is a lot of work. And it's not only the revision of the PMBs. Part of the revision of the PMBs is also the so-called benefit definitions. We've just published breast cancer, benefit definitions on breast cancer. With our resources, we can basically manage only to do 4 benefit definitions a year. And that is a mammoth task. We do not have the resources to finalize that in a very quick time. But every improvement will be to the benefit of the funders and hopefully also to our beneficiaries. And major depression is a perfect example of that.
The last area that I want to explore with you is that of the managed care organizations. So during one of the submissions, we heard of a risk transfer arrangement. And you'll correct me if I'm using the wrong terminology. So what I understand is that a scheme had given a MCO a pot of money, I'm assuming based on what their expenditure last year, and said, right, now you design the care, and here's the money, here are the people, and you keep whatever you make. So that, if I understand, if you make a loss, it's your loss. If you make a profit, it's your profit. That I understand is a risk transfer rather than a risk sharing arrangement. And is that an acceptable practice and a desirable practice in your mind? And how then do beneficiaries benefit from this arrangement? How do you stop an MCO plundering profits from the scheme? Why is this a good system? Because in your response to the revised statement of issues, you also mention that lots of risk transfers did happen. They almost don't happen anymore because apparently you can't make money out of it. Oh, I don't know why they didn't happen. I thought that's why they didn't happen. So can you talk me through if they're good or bad, and how beneficiaries benefit, and how you stop beneficiaries being fleeced?
Maybe if I can start to explain the risk transfer arrangements. We sometimes refer to them as capitation arrangements. So the fee paid should be at least or less than what the services are provided to those members. And a good example was the Centre of Excellence that some of the schemes made, where a capitation fee is paid to the group of doctors and they provide all the services. I think CDE was one of the examples given. And the arrangement should be that the risk or the payment for the risk should be, if not less, equal to the cost of providing those services. So that's a transfer arrangement. Whereas the risk sharing one, where we do pick up where there is a perverse incentive or members' monies are paid which are not commensurate with the services being offered, some of them are told to be reversed. So we do pick that up. But I think a lot of it also comes down to governance as well in medical schemes. In addition to us giving more information on the quality of the managed care services that you get. Because a medical scheme that enters, or the board that enters into that contract, needs to be aware of the costs and the benefits that the members will get. If they are aware of the quality issues which we work on, which we are working on, they'll be aware that what value would they obtain from entering into that arrangement, and whether it's at the level at which there wouldn't be unnecessary or high profits being made by those entities. So there have been instances where we have picked that up and we've asked them to reverse it. But the transfer arrangements are separate to the risk sharing arrangements.
Can I follow up on this? This was an arrangement between a scheme and a managed care organization, not with a managed care organization and its providers. So there's no issue of a capitation system or even risk sharing. It is a reinsurance system, I think, because it's between the medical, the MCO and the medical scheme. It's just, here's the amount of money. The amount of money was 300 million rand to cover a population for dental services. Poor people, by the way. And whatever, and here's 28% administrative fees. And on top of that, if you can make money out of it, it's yours. So it's basically a reinsurance arrangement. My question is it legal?
I think it's allowed in terms of the managed care services that a scheme can contract for. Was that managed care entity accredited? We need to look at that. And there is a view as well in our amendment bill as to what a definition of risk reinsurance is. Is it only where you contract with the insurance company, or is it a transfer of risk itself? And any of these contracts would fall under an arrangement like that.
Now let's suppose. Yeah.
We are running out of time. If you could please just answer the question directly. Is this sort of arrangement that has been put to you illegal or not? Is it allowed by the law?
Can I make it more concrete to you? So there's 28% paid on these 300 million rands, 28%, 84 million administrative fees, right? There's 300 million put aside to cover the needs of the population, right? Let's suppose, to give an example, 50 million is cut back on services to the population and goes back to the owners of the MCO. It's taken out of the fund, goes into the pockets of the owners of the MCO. Is this legal?
Well, in terms of some of the other arrangement, it is allowed. For example, administration services.
Yeah, but that's administration. I talked about administration services, 28%.
Yeah,
No.
I think that's excessive, and I don't think that should be allowed.
No, that's my question is not whether it's excessive. The question is, from the 300 million allocated from the fund to dental services, 50 million, so that's 28%, 84 million is set apart on top of the 300 for administrative service. That comes into the 10% non-medical costs, right? That's legal, I understand. It's a lot, but it's legal. 50 million is taken out of the 300, not devoted or not used to give these treatment to people, but is transferred to the owners of the MCO on top of the 28%. Is that legal?
It's not. It should not be legal. And
it is not legal.
It should not be, because in terms of our act.
So sorry, I don't understand the should.
It's not legal because if we consider that to be a bonus or profit, then in terms of our Act 26.5, which you said is a bonus to the directors, the 50 million, or for providing the services, whatever you can do it within, the balance stays to you. There should not be a payment of a bonus indirectly or directly to any person. I agree, then that should be considered illegal.
Are you regulating these type of contracts? Do you get these contracts? Do you require these contracts on a yearly basis that are being...
We do get these contracts.
So this contract has been regulated as well by you?
It depends, again, whether it's a managed care entity that we've accredited, and we'll have to go back and see.
It's Dennis, yes.
We do get the contracts.
So this has been approved by you?
The accreditation, but not the contract. We will review the contract.
Are you reviewing the contracts? That's my question.
Yes.
Are they being reviewed?
Yes, they are being reviewed.
So there have been. This one is in operation for already a number of years. This one has been approved by you.
I think we have, but we will have to look at the contract. We approve the accreditation when we review the contracts. Whether we approve the contracts, we don't do all of them in that way. We approve the accreditation.
But you don't look into the contracts.
We do where we do find instances like that, we do unwind them.
The question is this: you are responsible for accrediting these managed care organizations, aren't you?
Yes.
Now, when, as part of that process, do you consider the contracts that they enter into with the scheme as part of the accreditation process?
Yes.
So this contract that's being referred to here would have been reviewed by yourself or by the CMS and would have been approved by them. Yes. That would be despite the fact that you're telling us that it's not allowed.
Yes.
Yeah.
One final question, and that is in terms of you're relatively silent on mandatory membership. You don't have a categorical statement on it, but I infer that you're in favor of it.
It's in our submissions as well.
Sorry, then I missed that. Then my only question is, do you have an order of implementation that you think is important? So, for example, would price regulation be important before introducing mandatory membership or not? Does it not matter?
Prof, price regulation, I think that can come before mandatory membership. Together with mandatory membership, you also need to look at RAF, or a system of risk adjustment. But before you look at the system of risk adjustment, you also need to look at tax reforms. Otherwise, the system of risk adjustment will not work. So there's definitely a order, but I think to implement price regulation, that one maybe can do as a first step.
Thank you, and thank you for the amount of time you've given me.
Insofar as Section 7E of the Act, one of your functions is to collect information, collect and disseminate information about private healthcare. What do you understand by the information that you're required to collect? What does that entail?
We collect financial information and then also very importantly utilization information. Yeah. And there's a utilization data specification document.
What about the quality of the services that the private healthcare providers provide? Does that fall in within this?
The quality is also important, but it depends on where do you collect the data. We do not regulate providers.
No, I understand that. Section 7 says, dealing with the functions of the council, the functions of the council shall be to collect and disseminate information about private health care. So what I want to know is, what do you understand about this? Does this include the quality of healthcare services?
Chair, it does, and that is why we started the process, unfortunately late, last year, to collect information on outcomes eventually, yes.
Yes. Now, are you aware of the provisions of Section 66 of the Act, which says any person who fails to furnish the council or the registrar with a return, information, financial statement, document, or any reply to an inquiry addressed to him or her as provided for in this Act, under the Act, within the prescribed and specified period or any extension thereof, shall, irrespective of any criminal proceedings instituted under this Act, be liable to a penalty as prescribed for every day which the failure continues, unless the registrar, on good cause shown, waives the penalty. Are you aware of that provision?
Yes, Chair.
Have you invoked it in the past?
Yes.
So I think Ms. Kumale told us that you have instances where you request information, but the information is not forthcoming. Why was this provision not invoked in those circumstances?
So, Judge, that was in reference to the suppliers, the doctors and the private hospital groups, and we don't have a legislative mandate to actually collect that data. And they actually often invoke that we don't, you're not our regulator, and we have minutes to such discussion.
Are you aware that the National Health Act make provision for that sort of information to be collected? You're nodding. Is that a yes? You're shaking your head.
Yes, we are aware, but in most cases, as maybe could be seen by the Competitions Commission, if we make access to the minutes that we've had with the service providers, they would tell you that the interpretation of the various sections of the National Health Act is open for a variety of interpretation. So we haven't been able, we've tried, as you would see in our minutes, but we haven't been able to use that effectively.
Yes. Do you have the power to enforce your rulings?
Yes, we do. In terms of
what powers are those?
The one you mentioned, 66.3. Yes.
So if you issue a ruling against a medical scheme that they must pay the benefits in dispute, and for each and every delay, you can impose a penalty. Have you done that before?
Yes, we have.
Okay. Do you know why it was not done in the case? Well, was that done in the case of Jessica McCarthy?
We will have to get that information, but we have done that on numerous occasions when we are alerted to schemes not complying with the rulings.
Okay. Now, let's assume for one moment, and we have no reason to believe otherwise. We told that it took about 11 months for the council to process and decide the dispute. Is that the sort of time limit that it takes, or is this on the side of more time than is ordinarily taken?
No, Chair, I think in that particular case, it could be an outlier, because in a number of instances we resolve the complaints within a specified period of time. The length of time, the longest length of time that we take to resolve a complaint is about 120 days, and we have it in our SOP.
If you tell a member on the 14th of July that an appeal has been lodged, and then nothing happens until the 15th of July the following year, which is about 1 year, is it this sort of amount of time that an appeal is supposed to take?
Chair, I think this one we would like to indulge you to give us a moment to go and look at it.
No, I'm not talking about this one in particular. I'm just looking at the time frame. Is this the sort of time frame that it would take to process an appeal?
No, Chair.
So things being equal, this would be an inordinate delay, would it?
Yes, Chair.
Okay. Now, you've attended the annual general meetings of the schemes.
Yes, we do.
Okay. What sort of issues are discussed there?
I think the schemes in this AGM presents the performance of the scheme in that particular, as well as their financial positions.
And that's it?
Yeah. I think they approve that.
I mean, have you attended any of these meetings?
Yes, our colleagues in the, I have not personally attended, but our colleagues in the compliance unit do attend this AGMs.
Yes, but I was going to say that...
You're going to say what?
Yes, that they do attend, and amongst the other things that they discuss are the voting for trustees.
Yeah.
There are motions that schemes would accept before, but not on the day. I think some of the concerns around the general agenda item is sometimes misleading because members don't have the opportunity to bring up issues at the AGM. Those are the sort of things that would be discussed.
I mean, do members at those meetings raise issues such as the complaints that they have lodged with medical schemes and that have not been attended to?
Yes, they do, Chairperson.
And how are those dealt with?
Well, in the general meetings, they will always say they could be referred back to the CMS for further investigation. Like, for example, I think we had one scheme where, for example, the members were not happy about the arrangement of an AGM in a particular venue, and they complained to us and to assist with that matter.
What I'm asking is whether at these general meetings will the issue of a PMB, for example, be raised and be dealt with? To your knowledge?
No, to my knowledge, I've not gotten that particular aspect.
Okay, you've read the report, haven't you? Coming from these general meetings, have you?
There our complaints unit do get.
Oh, you don't read those reports? Or has any one of you read those reports?
Yes, our complaints.
Yeah. Could you call the gentleman, please? And what is your name, sir?
My name is Tamsanga Deniso.
Yes.
Senior investigator within the Compliance and Investigations Unit.
Yes. Do you attend the annual general meetings of the members?
Yes, we attend the annual general meetings on an annual basis.
Yes. Of all the schemes, or some of the schemes?
We select.
We select.
Due to resource constraints.
Okay. What criteria do you use in selecting?
Okay, firstly, we'll focus on the schemes that are under curatorship. Okay. Focus on schemes that are under close monitoring in terms of their financial position.
Right.
And then we'll also look at the size of the schemes.
Yeah. The big schemes?
The big schemes. So
would you attend the general meetings?
Yes, we do.
Okay. At those big schemes which are not under investigation, when you attend those meetings, issues relating to the PMBs, are they raised?
Yes, they are.
And how are they raised and who deals with them?
Normally, the PO or the chairman will say, we don't want to discuss personal issues. Mm-hmm. So they will take it as an aside and they say, we can resolve this on the side because they are not familiar with the details.
Yeah.
So that's how they would normally resolve it outside of the meeting.
Yes. Okay. And would that be reflected on the agenda?
It depends. In some instances, the member will come back and say, I raised this issue. Yeah. It was not properly resolved.
I see. Now, one of the issues that has come up here is the issue of members when they join the schemes, they are required to sign forms. Things are explained to them. But for some reason or another, they do not pay attention, they say, until they get sick. It's only then that they apply their mind to what is the scope of the coverage. Are you aware of that?
Yes, we are.
Yes. Now, do you know what mechanism, if any, can be put in place to make sure that at least consumers, when they join the schemes, at least focus on the content of what are the benefits and the scope of coverage, so that they don't have to inquire about this once they have an accident?
I think from my experience attending the AGMs, one thing that comes across is that the members, they don't feel empowered. Mm-hmm. So they come there from a position of being disempowered and they don't understand their rights.
Yes.
So some may have the information, but they're even scared to raise issues.
Yeah.
So I think once we sort of re-emphasize the fact that the schemes do belong to the members and the members can have a say on how the scheme is ran and the rules and all of that, then they can start to feel that power. And then that, I think, will inspire them to want to know more or want to participate more.
I mean, some of them you may have had that today. They do receive information concerning the annual general meeting, but they simply don't attend it because they think that it's to discuss the financial viability of the scheme. You are aware of that, right?
Yes, we are.
Again, what mechanisms do you think should be put in place to ensure that members attend this general meeting, that they can raise the kind of issues that they normally raise with you?
I think that's basically the reason why we started attending these AGMs, mm-hmm. because we realized that the members were unaware of their rights. So we've been sort of engaging in a pilot project of trying to gather information of what really goes down during an AGM. And the next phase is to try and direct how an AGM should be conducted, looking in terms of which day should it be held and how the information should be disclosed to the members.
Yeah. Have you considered perhaps saying to the schemes they need to review how they convey information about the benefits to their members?
In many instances, we've done where we realize that there is a particular issue that needs to be addressed. Like in terms of the rules, the members not understanding rules. We've tried to go to the schemes and say, you need to say more about this. So there's been issues which have led to AGMs not finishing or not being completed because the members were not satisfied with the amount of information provided.
The rulings that are made by the council, are these published? Anyway?
Yes, they are.
And then do you circulate these to other schemes?
They are published on our website.
Yeah.
Not circulated.
Okay. And the schemes are at liberty to have a look at those?
Yes.
Okay. And the member consent, does the member consent get a copy of the ruling, including the reasons for it? Yes? Okay. You have rules, don't you?
Yes.
Yeah. Are these, how accessible are those rules?
Each and every member needs to get access to the rules when they join a medical scheme.
No, I mean your rules. Do you have rules as a council that govern your proceedings, for example, how you lodge an appeal, how you approach, how you lodge a complaint? Yes? And are these accessible to members?
Yes.
They're in our website.
So if a person doesn't have a computer?
Chair, we also do, as we indicated in the presentation, we go to local radio stations and we talk about such matters, and we also respond to questions that the members would be raising. We do a lot of print media advertisement.
Yeah. And you mentioned here that you also go to rural areas.
Yes.
And you go there to talk about the rules.
The business of Council of Medical Schemes, the prescribed minimum benefit, what is prescribed minimum benefit, and how can members access care, what they must do should the service provider refuse to give them care, and also to just let the members know that there is an entity like CMS that exists.
Okay. Now, you have not had the benefit of looking at the oral submission that was submitted to us by Ms. Cheryl Naruski and her daughter Jessica McCarthy. You've not had sight of that oral presentation?
No, we haven't, Chair.
Yes. But of course, they do refer to the complaint that they sent to you. Okay. Would you be kind enough to go back to your files and look at this time frame that they mentioned and just let us know whether in fact that's true? Because from what you've said, if what they told us is the truth, then there's something wrong with your systems of attending to the complaints.
Yes, Chair, we'll go back and come back to you on that one.
Yes. Okay. We have kept you more than probably you had expected. What is it? Yes.
Two very small technical requests. The 2010 evaluation and the process that followed. You told us about the process that followed with the ministry. Can we have the evaluation and an account of what followed?
Doctor, yes, we can make the reports available to you. Yes.
Plus the process after that, please, as you clearly.
Yes, we will do so.
Very good. And second, you told us about the REF, and I share your views on REF. And in answering my colleague, you said, "Are you ready?" You said, "Yes, on the model we're ready. We're doing that every year, but not on the IT." Can you tell us what investments it would take and how long it would take for you to be ready, both modeling and IT-wise?
It is difficult because obviously you need to test it with all the schemes in the industry. I would say most probably 2 years, but you also rely on the complexity of the model that you're going to use. Previously, our risk factors, we've included age, the 19 age bands, the 25 CDLs plus HIV, maternity, and then beneficiaries on 2, 3, 4 and more chronic conditions. So that was basically a two-way risk table, sort of very complicated. If one opt for age only, or say age and gender or age and maternity, that would be much easier to implement, and it can also be implemented in a shorter time, but it is not as effective as where you include the chronic conditions as risk factors in a model.
In terms, and you do a decent risk equalization exercise and have it up and running, would that be 2 years?
You put me on the spot, Doctor. Yes, I would say most probably 2 years with the resources. But if you go age only, all that you basically need is an ID number.
That's right.
And that could be very simple to implement.
But too simple to be effective. Thank you very much.
Thank you. Thank you for coming to share with us how your council works. But I think I need to emphasize that there is a session that will be devoted to the regulatory framework. Now, as part of the regulators, we will be expecting you to attend that section when we can perhaps discuss more deeply some of the issues you have raised. And speaking for myself, I would be grateful indeed if in the meantime you could look into Jessica McCarthy's case, so that when you come back here, at least you have considered that in particular, the time it took to process, her dispute and the appellate procedure involved, so that if there is anything wrong with your system, we can see what needs to be done. Do you understand that? Yes. Okay. Otherwise, thank you so much indeed for being here. Thanks. Is the Allied Health Professions Council of South Africa here?
Okay, Chairperson, we'd like to thank you for this session. And
I didn't realize that you're still here. Okay. Yes. Yes.
Yeah. We are aware that we couldn't provide some adequate answers to some of the questions. We'll go back.
It's understandable.
Yes, thank you.
It's understandable. Perhaps next time when you come around, you'll be able to apply your mind in the meantime to those issues, and then when you come back, you will probably provide us with more detailed explanation.
Thanks, Chair.
But thank you so much for being here. Yes. I should add, though, that I apologize for keeping you for more than you had expected. Yes. Could you just put your name on record, please?
My name is Danny Pillay.
Yes. Yes.
Go ahead.
And your colleague?
I'm Dr. Anit Simon.
Yes. Now, I understand. Yes. Mr. Pillay, I understand that you have time constraint. In fact, you need to leave at about 4:30.
That is correct, Chair.
Yes. Do you think you would be able to manage that time between now and then?
Yes, I'll attempt to do justice to the presentation.
Yes. Okay. Well, let's try. Thank you.
Thank you for affording the Allied Health Professions Council an opportunity to present. I'm sure someone's got the clicker. Thank you. Just as a declaration of my interest. So part of the agenda for us to discuss is the Allied Health Professions Act, the structures of the council from that act, the scope of practice, education and training, registration statistics, challenges facing the Allied Health Professions Council, healthcare expenditure, medical reimbursements, and then a conclusion on that. So,
I think it should be recorded that you had a third colleague, Professor.
Yes, indeed.
Is it Professor?
Professor Ross.
Oh, yeah, Professor Ross, who, because of time constraints.
Yeah, he had a flight to catch back to Durban.
Yes, indeed, we accept that. Thank you.
All right,
yes.
Thank you. The Allied Health Professions Act, Act 63 of 82, then gave statutory recognition to a certain group of practitioners. It first started with chiropractors and homeopaths, and over the time, and as the Act has been amended, it included other professions. Registration, of course, confers the right and privilege to practice. So currently there are 11 allied health professions, and that's the constitution of the council, with 4 community members appointed by the Department of Health, and 1 person who must have legal knowledge, and then 1 person as a Department of Health representative. So we have 4 professional boards within the Allied Health Professions Council of South Africa. As you can see, the Ayurvedic, Chinese medicine and acupuncture in 1 professional board, chiropractic and osteopathy in another, then homeopathy, naturopathy, and phytotherapy. And then we have 3 therapy professions of aromatherapy, reflexology, and massage therapy. So the scope of practice of a practitioner, in terms of the Act, a practitioner may diagnose and treat or prevent physical and mental diseases, illnesses, or deficiencies in humans. They're allowed to prescribe or dispense medicine, which is subject to their scope of practice, provide or prescribe treatment for such diseases, illnesses, or deficiencies in human. The diagnostic professions, as you can see, they are listed. There are 8 diagnostic professions. And there are 3 professions.
Help me understand. Homeopath, what do they use? Do they use herbs?
Well, homeopaths would use some herbs, but they also use what are called ultra-high dilutions.
Yes.
So part of it, their starting substance would be herbs, plant, animal, or mineral substances.
They use natural stuff?
Yes.
Yeah, okay. Why are the traditional healers not in this group?
Well, the traditional healers have an interim council that runs now, with the Traditional Healers Council, I think it's called.
Yeah.
So it's a separate, these are far more, in terms of keeping of diagnosis and methodologies, different from traditional healing.
I see. So the difference is based on the methodology for diagnosis?
Yes.
I understand.
All right. So then we have the scope of practice of therapists. Therapists treat or provide treatment for diagnosed diseases, illnesses or deficiencies in humans. So they don't have diagnostic capabilities, but limited therapeutic capability. And those are the non-diagnostic therapists. Then in terms of education and training, chiropractic and homeopathy have had training in South Africa, initially at the Durban University of Technology, the then Technikon Natal, that commenced in 1989. And latterly, I think it was 1993, that it commenced in the University of Johannesburg, the then Technikon Witwatersrand. Education and training for Chinese medicine, naturopathy, phytotherapy, and Unani Tib are offered as double professional bachelor's degrees at the University of Western Cape. And in terms of the therapies, there are diploma courses with 240 credits, but this is provided for by private providers of education and training that obviously meet the necessary requirements of SAQA and the council requirements. Ayurveda is not offered in South Africa. The majority of graduates complete a 5-year BAMS degree, Bachelor of Ayurvedic Medicine and Surgery, from India. Osteopathy is also not provided for in South African education. The majority of graduates are coming either from Europe or North America. Acupuncture as a standalone is not offered in South Africa. It's offered as part of the Chinese medicine and acupuncture degree at the University of the Western Cape. In terms of registration statistics, there are approximately 2,700 registered practitioners with the Allied Health Professions Council. As individual registers, there's figures there, notably there's 700 chiropractors and about 570 homeopaths, and there's a breakdown of that. There's 594 therapeutic reflexologists and approximately 200 aromatherapists. So part of this is the challenges that we face as complementary medicine practitioners. Firstly, I know this is about the private healthcare sector, but there's a problem in the fact that there's a lack of access and accessibility to the public health sector. We note that the majority of our diagnostic professions that are provided for in this country are done in state institutions, which get the funding from the state, but the utilization of these practitioners is non-existent in the public space. And that has kind of started an extension from that is into the private healthcare sector. So if you notice in the expenditure, this is information from the Council of Medical Schemes that they publish the information of utilization of services, that approximately 0.14% of the expenditure of depending on the figure of 130 to 140 billion rand, is actually being dispersed for complementary medicines. Now, as much as we talk, and I hate to sound controversial, that we talk about the healthcare inquiry, but most of what we're doing is a disease inquiry, because most of the spend is on treating diseases. Once they've occurred, we haven't had a huge expenditure towards prevention, whether in the public sector or the private sector. Most of it is a reaction model. We treat the heart attack when it happens. We're not looking at a greater level of preventing it. And that's what's eating up most of our costs. We have a situation with medical aid payment restrictions, as you see with the 0.14%. There's either a lack of understanding or plain prejudice, if I dare say, that results in poor or no payment from medical aids. Also, to add to that, there is no provision in any medical aid that I'm aware of, or even in the bodies like CMS or the BHF, where there is a representation for CAM professions. So people outside of our profession make decisions for our professions without having the necessary and requisite knowledge of our professions. There's a general, as I say, sense of ignorance or prejudice, because most medical aids, if you look at their board and constitution, and decision makers are medical practitioners who make decisions for professions that are not theirs. So if we can't be employed by them, at least look to us for some level of consultation and provide us that knowledge that they're looking for. And we can provide our experience and our expertise. So if we look at comparisons to one of our BRIC partners, for example, in India there's a Minister of Health for, if you want to call it Western medicine or allopathic medicine, and there's the Minister of Health for what is called Ayush, Ayurveda, Yoga, Unani Tibb, Siddha and Homeopathy. In that country, they have practitioners who provide these systems of medicine care within the public healthcare sector. So in the case of homeopathy, approximately 200 million people get treated with homeopathy, and the professionals are employed by the state. So, as we say, the AHPSA is constituted and it registered diagnostic professionals. In terms of law, they effectively para passi to medical practitioners. They have given the same responsibility of diagnosing and treating. We just use different modes of treatment. So we still conduct Western clinical diagnoses, as well as providing therapies that are different from what Western medical practitioners would use. We also do not enjoy any representation, either at the national or provincial Department of Health. We battle with having adequate engagement with the Department of Health. Many of our letters go unanswered. We have graduates who come out and have the potential to be part of an internship program. They have basic and extensive diagnostic skills that can be utilized by the state. We often hear the figures being bandied that there's 6,000 or 8,000 shortage of doctors, yet our students are not used in an internship program by the state. So if we look at healthcare expenditure, and this is the figure I come to across where we talk about professions, often, unfortunately, loosely gets used allied health professionals. Allied health professionals, often when used outside of the Allied Health Professions Council of South Africa, often refers to physiotherapists, dietitians, and the like, and actually doesn't represent us. And the figure that gets quoted there in terms of expenditure is not for allied health professionals as we define it in terms of our Act. So just to make the comparative, so this is, I don't see the acknowledgement, but this is again from the report, taken from the report of the Council of Medical Schemes. If we look at this kind of figure, of the 130 to 140 billion utilized approximately by 17% of the population who are on medical aids, you look that there's a figure for GP consults is about 8.2 billion. Hospitals about 46 billion. Other services that, whether it's pathology and the like, 3.5 billion. Supplementary and allied health services, that's the physios, nutritionists, speech therapists and the like, is the 9.4 billion. Chiropractic 119 million, homeopathy 42, acupuncture 197, osteopathy 340,000, and phytotherapy 86, and it goes to 62 and 13. You'd see it comes to 0.13 point something recurring, so we've rounded to 0.14. You'd see this is an absolutely small amount, and yet we find medical aids on a consistent basis reducing those fees of complementary practitioners, and we don't find it other than it makes purely no sense from an economic point of view to reduce those fees. It is not what is impacting them on healthcare costs. So I can only assume that there's a level of ignorance or prejudice that they continue to do that. To use an example, and I can forward the information because it's something in the last 48 hours, MediHelp as a medical aid will refuse to pay for the pathology service of a homeopath. And the excuse is that we'll only pay a medical practitioner. But the law requires me to diagnose and treat. Part of diagnosis is making requests for pathology services. You are restricting me the right to practice my profession. Section 22 of the Constitution speaks of the right to practice a profession. But if you're going to have medical aids doing certain things to restrict me, you basically restrict my right to trade, and more importantly, the right to a patient to get the right kind of service. I find, using another example, as Discovery Health, in the last many years, 5 years I think it's already now, who unilaterally decided you have a member saving account, a self-payment gap, and then above threshold payment. And before it used to be an open pool for all practitioners, they summarily decided that they'll only leave that to general practitioners and did a pool risk of homeopaths, chiropractors, psychologists, occupational therapists, biokinetics, into one pool of 20,000. They do not engage with the practitioners, they do not engage with the professions, but make unilateral decisions that affect our members and our patient base. And to go to my earlier point, we're speaking a lot about healthcare, but we're not really dealing with the important things of where we sit with burden of diseases, communicable disease, non-communicable, maternal and mother and infant mortality ratios, and the Millennium Development Goals will change to the SDGs now. We're not looking at lifestyle. We are basically running a reactive model that only looks at treating end-stage disease. Or when you notice the person's cholesterol up, then provide them a treatment, as opposed to focusing how do we prevent our society that's faced with communicable diseases and non-communicable diseases. There's, as I say, the attitude of medical professionals and medical insurers has to change where they look at accommodating people. from other professions and not basically monopolizing the healthcare market. If I may make a few more comments over and above this slide. Is that how do we create a model that promotes healthcare and prevention whilst recognizing the need to deal with disease that already occurred? We all have a responsibility as professionals to address the well-being of all people that live in South Africa. And we find that the inequitous nature of how private healthcare is running does not provide the citizen, in terms of Section 27 of the Act, the access to health services. It doesn't speak of one health service, but health services. And the way medical aids operate in the private healthcare sector, they basically force patients to use a certain level of care, because if they don't have the money, they can't go to complementary practitioners because the medical aid won't pay for it. Okay. I hope that was brief enough, knowing that we have less time.
No, but that was not intended, certainly, to curtail your right, to fully present your case. Okay.
Dr. Pillai, so also looking at the time, thank you for your presentation, very clear. So if you were to hold my pen, what is the main recommendation that you write down in my book here?
I think the recommendation for me is very simple. Medical aids have their actuarial scientists. They figure what they can spend on a member. They should leave members the right and the constitutional right to access the service they want. Because what we find, I'll give you an example, one medical aid will decide they will allow only 1,000 Rand for homeopathic service, but the same patient can access 9,000 Rand for GP service.
Yes, I understand. So your recommendation would be addressed at the schemes?
Yes.
To allow their members the right to consult you?
Yes, and I think, that's from a private healthcare sector, but also the idea would be if you had any force and effect within the Department of Health, to engage with them and wonder why they don't use the services of professionals that they pay for their training.
Yes, all right, thank you very much.
Thank you.
But your approach, as I understand it, goes further than that, though, doesn't it? You are concerned about precisely what are we to understand by the right of access to healthcare services. Because what you see and what you infer from the conduct of the medical scheme is that, having regard to the amount that they set aside for your profession, it doesn't reflect a recognition of your service as being part of the healthcare service. That's really the primary concern. Isn't that?
That is correct, Chair.
Yeah.
No, thank you very much. I have no questions.
Okay, thanks. I just wanted to ask one question regarding the challenge that you keep referring to. Where do you think is the avenue, which avenue do you think would help you get in terms of proper access? Is it at getting your fellow professionals from other disciplines to understand more what you do? Is it really a push regarding funders, or is it about getting your members to actually push on your behalf in terms of getting their benefits funded properly?
Well, part of how we've been funded is because of the push of members, us educating our members. Our avenues, for example, the MediHelp would refuse to pay for pathology. We have to get the membership because it's their medical aid and make the request, and secondarily, to ask CMS to intervene. That's the one aspect. But I think most importantly for me is to having the right of access to the medical aids themselves, the way they need to engage with us, that we can explain how we practice and how we practice differently from an allopathic medical model. So everything is gauged at one model. For example, if a person came with a reflux, and they came with a bowel problem, and they came with a headache, in a Western medical model, they will be approached at 3 different levels and 3 different managements, where the way we'll do it far more holistically and looking at that. So long term, there is a cost benefit to the healthcare model. So a lot of what we're seeing is that more and more of treatments go towards chronic medicines. We're not solving people's problems. We're just keeping them on chronic medicines. When you look at a complementary medicine point of view, we often enough change the patient's state where they don't need medicines in perpetuity. So it's a different thing, but we need medical aids to open their doors to sit with us and consult with us. It is this very long arm thing is that we'll just amuse you with a little few rands, and we're not quite interested in what you do. And yet we look at these systems of medicines in big parts of the world, they're providing value. Traditional Chinese medicine acupuncture is a big part of healthcare in China. And Ayurveda and homeopathy in India. If you look at the WHO system, homeopathy is the second largest system of medicine. And yet we don't have the recognition or an avenue of access to discussion with the medical aids.
But is it, in your view, entirely, about prejudice or not understanding, or is it really about the benefit structure that we've spoken about? You may have heard that optometrists are complaining about the same thing in terms of limits. Even we've referred a number of times to mental health problems being limited to 15 days out, or 15 or 21 days, and a progressively declining general practitioner share of the rent. Dentists as well are complaining about the same. The point is, are you sure that this is just not an issue of benefit structure of the medical scheme not really being in tune with needs of patients out there, or you've got other reasons to make you believe that it's targeted specifically at your profession?
Well, if you look at the stats, 0.14% is spent on complementary medicine in total of 2,600 practitioners. And you're looking to curtail those amounts. We're not asking for special treatment. We're asking for equal treatment. We, in terms of law in this country, are classified as primary contact physicians or practitioners, that we provide the same level and have the same responsibility to diagnose and treat. We just use a different mode. Why is it that you can provide, in terms of discovery, above threshold, you give an unlimited resource to a GP, but you remit to a homeopath as a pool risk with other professions to 20,000? Why is it that you provide in other schemes where you allow 1,000 rand to a homeopath and 9,000 to a GP? Let the patient get to choose. It's the right of the patient. What they should do is say, what can we afford to spend on a primary care practitioner, and let the public choose who they want to go to. Let market forces dictate. What we're doing is a long-term problem. By paying for one system of medicine, you're entrenching that model. You're entrenching that system. That provider of service, that pharmaceutical company is getting reimbursed at a longer scale. If you look, the spend on medicines was about 30 billion rand. And you're fostering that, and you are denying the right of other systems of medicine to grow. To me, this is anti-competitive behavior. The fact that a patient will go to a GP, not necessarily because they want to, because they're getting reimbursed there. The patients from MediHelp won't come to a homeopath because now they perceive a lesser level of training or quality because their medical aid won't pay for the pathology. And the medical aid goes as far as to say, send them to a GP to request the test. So this is utterly discriminatory. I can't see it any other way.
As you would have gathered from what Dr. Beng put to you, there are other disciplines who are also concerned about what is allocated to their disciplines, such as the general practitioners and the dentist.
Yes, Chair.
You understand that, yeah.
Chair, I understand that because we've got this kind of limited resource with almost unlimited requirements.
Yeah.
My point is that the complementary medicine never had a fair access to the market. Yeah. We are talking about like other professions like optometry, we've had an excess. That excess is now being diminished by rands and cents. We've never had the right to access to the service.
Yeah. In particular, those who provide what has been described here as primary health care services do believe that they are not being looked after fairly by the process. And you also operate in that field of primary health care, is that right?
Yes.
Okay. So what your concern, therefore, is that you are being discriminated against unfairly as a discipline?
I think it's not necessarily a discipline, but I think as disciplines, because complementary medicine contains many disciplines. I think for me it's not just that. I think part of what happens there is an extension to the fact that the public don't have an access to health services and only to a particular type of health service. Mm-hmm. So the Section 27 says access to healthcare services. Yeah. And we provide a healthcare service, and the way they manage the process denies even citizens the right to access.
Yes. And then, do you have any statistics which indicate the number of people who use these services so as to assess?
Yes, we do it. Again, a lot of it will come from the utilization services from the CMS. Yeah. But we have approximately 1 million out of the 55 million who access this care in this country.
Yes. And you're saying that based on that figure, what's allocated is just unfair?
It's ludicrous, to say the least.
Yeah. Okay, understand. Now, is there anything else that you'd like to edge on us?
I think it's for me that's the most important thing, and I'm aware, as you've discussed earlier, being a statutory council, that we'd have other opportunities of input at a later stage.
Okay, very well. Well, thank you for your presentation, and also for drawing attention to this, to your discipline in particular, and some of the challenges that you are facing. And thank you so much for being patient.
Thank you kindly for the opportunity.
Thank you. Right. Is it, Professor, I wonder whether it would be a convenient time just to take a 10-minute break at this stage? Yeah? Okay. And then we'll then start with you when you come back after 10 minutes. Thank you. Yes, are we ready to start?
We are ready.
Yes. I wonder, would you place yourself on record? Yes.
Good afternoon, ladies and gentlemen, and especially the ladies. This presentation is dedicated to you as it concerns breast health, but is also an important principal issue at stake here in the framework of competition. I'm Professor Apfelstedt. I head the unit for breast health at the University of Stellenbosch and also have a private breast health practice.
You're a professor of what?
I'm a professor of surgery, but I haven't practiced general surgery now for almost 20 years. I've specialized in breast health and surgical oncology. As such, I provide a comprehensive breast health service. Shall we rock with the presentation? Okay. Way back in the year 2002, I got frustrated with the quality of imaging provided through conventional channels and set up in the private sector my own breast health center. And the novelty here was that I was going to provide a single practitioner with a group of associates imaging and clinical services under one roof. And that's where the crux comes and where all the problems arise from. So what is actually necessary if you want to do this in the current system? You need to be educated and qualified to do the stuff that you're doing. Imaging is part and parcel of the education and qualification of the surgeon, and in particular of any specialist. I myself have been examined, and as a professor of surgery, I also examine on images in the specialist examinations to obtain the specialization in surgery. You need a license to own X-ray equipment and imaging equipment, and we'll come back to that later because that is one of the major problems, and you need to have funding for your services in the private sector. And there we have problems with the medical aids, the administrators, and one of the prior presentations, the Council for Medical Schemes. Let's look back at the qualification and education. Specialty imaging is part and parcel of the education of the specialist. You're being examined of that. And to put a regulatory framework on it, the HPCSA, the Health Professions Council of South Africa, actually in a workshop that was accepted, the results of which were accepted on December 5 in 2014, regulated the ownership. Anybody may own any form of imaging equipment. Operation of X-ray equipment is restricted to specially educated people, but any imaging equipment that does not emit ionizing radiation, such as, for example, ultrasound machine, can be operated by anybody else. And the interpretation of the results is that any individual currently registered with the Health Professions Council of South Africa and who is adequately educated, trained, and sufficiently experienced to interpret and record the findings. So this is pretty much the hard stuff. So we as clinicians, as opposed to radiologists, which are the imagers, are entitled to provide imaging services to our patients. We may own our own X-ray equipment, and there should theoretically be no barrier. What is the reality? There's a vast gap between the legal and regulatory framework, which is in practice, as I've quoted above, but there is not a single specialist, except for myself, that I know of in South Africa that has run successfully a practice, including X-ray, CT scanners, or MRIs. The reason here is in the monopolistic hold that the Radiological Society of South Africa has on imaging equipment and the reimbursement thereof that is currently active. So, what does that mean in my own private practice? But I would wish to draw your attention to the fact that this can be due in any other specialist practice, like, for example, in an orthopedic practice, like, for example, in a gynecologic practice. The patient comes in, gets a consultation, which is provided by a clinical person, but then she also has, if indicated, imaging of her breasts and is consulted again about the results. Other providers in competition are the radiologists who only provide a mammography and ultrasound only if it's indicated. We have extensive quality controls. I pay a medical practitioner 2 hours per week to control the quality of our results and see that we actually compete and benchmark ourselves against the best breast imaging services worldwide. We publish our results regularly, whereas in our competition the quality is at best unknown. And I recently ran again a search on the most important medical results or scientific results site, PubMed, under mammography and Africa. And the only publications that are coming out of there are my own and one rare one from the Republic of Congo and another one from Tunisia. So, how does that look like in economic terms? SAMA is providing, the South African Medical Association provided the clinical codes to services rendered, and before the split in 2004, which I think you must be familiar with, where the Radiological Society separated from the South African Medical Association, the clinicians can do imaging services, but the reimbursement was frozen at 2004 levels. This has the following effect. Currently, a clinician can do an imaging procedure. In our case, it's mammography and ultrasound. We combine the two, and we are being reimbursed at 2004 levels at 540 rands, whereas per practice cost study, it costs us about 1,445 rands to produce the image. Whereas in the radiologist practice, the imaging is billed at virtually the same level and fully reimbursed. Why should it actually be a bit more expensive? I think the difference is trivial, but we include ultrasound in there, and we have extensive quality control procedures, but essentially the pricing level is similar. However, as you can see here, we are excluded due to the fact that we are actually clinicians and cannot bill under the same codes as the Radiological Society of South Africa. There's a difference, there's a further difference. Some medical aids collude together, collude with the Radiological Society and tell their members that they will pay only for the service which is demonstrably of high quality. On our side,
so can I just take you back to the previous slide?
Yes.
Yeah. No, I'm sorry. This one here. The code. These codes, are they linked to a discipline or are they linked to the procedure?
Yes, both ways. If you're doing breast imaging, the clinical code is 3605. And in the electronic submission systems of many of the healthcare funders, like for example Discovery, it must be linked to a radiologist's practice number. So if this link in between the code procedure and the practice number throws up anything that is unusual, it will throw out the claim. So there are actually, we've queried this, and our patients have queried this, and there are medical aids that actually allow for mammography to be done by oncologists and by gynecologists, which none ever does. And if it's done with a surgical practice number, like for example in my own, and in this country as information for the Dutch member of the panel, it is actually so that surgeons treat breast disease. So I cannot do that. All right. However, this is only part and parcel. The imaging is only part of the procedure, because if you add in the other components of that service process, then you will see, as in this slide, for the 3 most common service items in breast health, the annual screening, the diagnosis of a mass, and the follow-up of breast cancer, if you're going to a super specialist center like ours, you will actually come out at a much cheaper price. Why is that so? Because the service process that is enforced by the exclusionary reimbursement practices in this country is so that the patient must first go to a general practitioner or gynecologist to obtain a referral for the imaging. Obviously, this necessitates a consultation, then she gets the imaging, the results are being sent back to the practitioner, and who then has to explain in another consultation to the patient the results of it. And this leads to the annual screening process being actually much more expensive than it could be, and notably as it is in our own center. However, there's a hidden cost component which I have tried to elucidate together with funders, and unfortunately the data programs are not that good that they actually can go and search this up. We have, due to strict quality controls, there are no downstream costs. Further imaging and secondary imagings and more expensive imagings that are required, or even biopsies. We keep this to a minimum and keep ourselves demonstrably within international benchmarks. So likely cost savings are actually on a systemic level much higher than indicated here. Same holds true for diagnosis of a mass. The diagnosis of a mass in our place is relatively cheap and simple. We utilize simple biopsy guns that are cheap. The procedure here costs about 2,500 Rand. If you add in the pathology, you end up at a maximum cost of about 9,900 Rand. Whereas it is common in competing practices in the radiology environment to go for vacuum-assisted biopsies, which are about 4 to 5 times as expensive, and in many cases still to go to interventional operative biopsies, which require a hospital stay. Once again, we keep ourselves in this framework to international quality parameters that in more than 90% of cases, the diagnosis must be established before the patient enters the hospital. Follow-up of breast cancer, again, cost savings due to the fact that we operate according to clinical protocols. So, what is the problem? The new compensation codes and reimbursement models are limited to the Radiological Society, which actually makes it impossible and cost ineffective for any clinician to compete with radiologists on imaging level. The patient co-payment is unjustifiable, and it forces the patient into an inefficient and costly 3-step process. It is also so that the patient experience is negatively affected by this. Because if you've ever been to a general practitioner or gynecologist, then have to leave the practice, go somewhere else, get your imaging, go back to be told about the results, that is not really that inspiring. Whereas if you come to our place, you leave within an hour and you have your diagnosis and the treatment, most likely planned. There are also higher systemic costs. I've alluded to that in the avoidance of secondary downstream costs, and there's a general lack of competition between the Radiological Society and other specialists. It is quite amusing, actually, to read in an American journal called Radiology, where a radiologist called Berlin, in a review of cost comparisons, actually wrote, heaven forbid, that clinicians were allowed to do imaging, a price war might break out. Isn't that what we actually want to have? We would like to have a little bit of competition. Right. There is... I've mentioned that before. This is not the only problem. We're also having the problem that the Radiation Control Board, which issues the licenses for imaging equipment, has been thoroughly captured by the RSSA. And despite the Health Professions Council guidelines that specialists may do their own imaging, can own imaging equipment, will not issue licenses to non-radiologists. Monopoly support there. I actually have a dream, and I think this could hold true for all specialists that can or that are intensely dependent on imaging. Like I mentioned, orthopods, ENT persons that need to image the nasal sinuses and the frontal sinuses, neurosurgeons who need to see tumors and anatomical abnormalities, in that clinicians could actually own shared equipment, employ radiographers to produce the images, and due to the fact that we cannot charge for interpretation of images, that is part of the consultation process, we report this as part of the consultation process, and it would mean a much better service and a much better service experience, leading to greater patient satisfaction and actually better results in healthcare. I think I've said everything I wanted to say, and I'm eager to hear questions.
Thanks, Prof. You are a general surgeon by training.
I'm a general surgeon by training, yes.
You want to be paid as a radiologist?
I do not want to be paid as a radiologist. I want to be paid as per practice cost studies. And these are the same as whether you are a radiologist or a surgeon or whatever.
Yeah, now, but I suppose every practitioner wants to do that, but we are at a stage where that still is yet to be done. But why I'm asking this is because your slides compare what you are getting paid with what radiologists get paid for the same type of service.
Yes.
In other words, if you were paid what radiologists are paid, would you be complaining, irrespective of cost studies?
The answer to that is actually that's not the reality. And I would not be complaining. I would complain about the reimbursement models and the legal and regulatory failure to actually achieve that.
No, Prof. If you wouldn't be complaining if you're paid as a radiologist, it seems to me that you're now complaining because the issue of cost studies seems to be not so much an issue, because even without cost studies, if you were paid as a radiologist, you wouldn't be complaining. I think that's my point.
In essence, you are onto something, yeah.
Do you provide the radiology services to other practitioners, or it's only for your own use?
I provide this only for my own patients.
Yeah. Now, when they pay you the 540, do they indicate what component of that is for the use of the equipment and what component is for your clinical analysis?
No.
How does your remittance advice, what does it look like?
I've put up a slide here that actually shows the entire service process. It is this slide here that shows you the annual screening, for example, that includes the consultation for the patient and treatment of complaints.
Now, there are very good general practitioners who are quite proficient at cesarean sections. Should they be paid as gynecologists? Obstetricians?
I am neither a gynecologist nor a general practitioner, so this question is a little bit difficult, but I would think that in the reimbursement models, the same service should actually attract the same remuneration.
That's something new now, but because that's what I'm battling with now. But it means you have to support that a general practitioner who can do a cesarean section must be paid exactly as an obstetrician, which takes us to my next question. What is your understanding of scope of practice? Is it relevant?
Scope of practice is in certain terms relevant, yes, but you will find an awful lot of overlap, and practice changes over time. You know, for example, if we're looking at the practice of gastroenterology and surgical gastroenterology and internistic gastroenterology, both are doing gastroscopies, colonoscopies, it's the same thing.
Yeah.
And frankly, I don't know whether there's any difference between internists and in between surgeons who are doing a gastroscopy. It's a service that is rendered competently on both sides.
Yes.
You know, let me ask you, conversely, do you think then that it would be appropriate that a vascular surgeon who needs to operate on a occluded vessel and who can interpret an angiogram much better than any form of radiologist, unless it's a vascular radiologist with a super specialist training, which there are few, and I don't know whether there are any in this country,
why
is being discriminated against in terms of remuneration? I don't think that this is fair.
Why your example doesn't work about the gastroenterology is because you're taking two specialist disciplines that are quite close to each other. And if you were to look at the procedures, you will find gastroscopy being done by a general surgeon, by a gastroenterologist as well, which means it's still within the scope of practice of either one.
Yes.
But you are now moving from general surgery to radiology, which are completely different, and actually there is equipment that's there. The point I'm saying, my concern is your focus seems to be purely on what it costs, and it's about fees, but ignoring the issue of a scope of practice, because as a general surgeon, I do not believe there's anything there that empowers you to do radiology.
I've never aspired to the practice of radiology. However, I think anybody around this table here would take a severe issue with this statement if, for example, a orthopedic surgeon has to actually correct a fracture blindfolded according to the report of the radiologist. That is nonsensical. It means, what I'm trying to say here, that for my specialty and for my chosen field of interest, I must be able to interpret the imaging. I must be able to look at the images and say, okay, the breast tumor lies in that and that quadrant, it has this and this size, and it requires this and this form of surgical intervention. And I don't think that this is, as you put it to me, is the practice of radiology. I think this is intensely the practice of appropriate and safe breast surgery.
Yeah. But Prof, especially in emergencies, you will find that as you are working, whether as a general practitioner or an orthopedic surgeon, the interpretation of radiology you will apply as you are doing the procedure, because you can't wait for the radiologist to come and confirm a fracture.
Exactly.
But it doesn't mean then that the general surgeon or the orthopedic surgeon will claim as a radiologist for that. And I think that's the point. But we're going round in circles. In my view, I'm not getting the issue. But this is not at all to suggest that I do not believe. I have no reason to doubt your skills in interpretation of radiological images. But as good as you are, should we make rules for exceptions? If we were to say we allow that, what's to stop me, qualified as a general practitioner, from coming back and also wanting to do the exact same thing?
It was actually very clear at the workshop which I attended with the Health Professions Council that specialists within their field of specialty can interpret and perform imaging procedures. I don't know whether you would actually like your wife or your daughter for a neonatal assessment to go to a radiologist purely because he's a radiologist? Or would you trust the gynecologist who is doing the ultrasound to diagnose the practice and diagnose malformations in the embryo much better than any form of radiologist?
Yeah.
It's the practice of imaging.
Yeah.
And what I want here is that other specialists, be they orthopedic surgeons, be they general surgeons, be they vascular surgeons, when they have a special field of interest, which is at times even a certifiable subspecialty, can actually engage in imaging appropriate to their specialty. And I don't take your example of the general practitioner that seriously. I don't think a general practitioner has anything to do in, for example, doing mastectomies or doing general anesthetics or anything like that.
I used the general practitioner. It was a very deliberate example. That's why I didn't extend it to a mastectomy. But Prof, my questions, I heard you. Thanks.
Yeah. And I think it would actually be much more effective if we had specialists combining to control shared imaging equipment, and we would get much better quality imaging also. That's what I think, because only the orthopod knows what he needs to see on the image of a fracture. I know as a breast specialist what I see on an image of a mammography, and I think the vascular surgeon also knows much better what he needs to see on the images of a vascular tree before he operates.
From the point of view of the terms of reference of the healthcare inquiry, one of the questions that we are tasked with is not about turf wars between specialists, but the cost of private healthcare and the incentives that exist within the system to provide comprehensive care that is most cost effective. So in that regard, what I'm interested in is if you have a better quality product that is at equal or lower cost, what is it that is preventing that being attractive to healthcare funders? For me, that's the issue that we have to, and this is a good potential example of that. So that's the question. What are the structural barriers that get in the way of funders, either me as an individual if I'm paying out of pocket, or a member of a healthcare, someone who runs a medical scheme? What is stopping them, from your experience, from choosing providers who offer quality, comprehensive care at a lower cost?
There are an awful lot of soft issues in here. And it is the paradigm that has been successfully challenged elsewhere. Like, for example, in Western Europe, like, for example, in the United States, like, for example, in Australia, where this the professional group that is most effective and most cost-effective above all is being supported. In this country...
So what is different in those systems that doesn't happen here?
Okay, all right. I will come to that. Now, in this country, as I've experienced it, when you want to offer imaging services, and even if you provide published results, the first thing that is going to happen is that the funders are actually asking the Radiological Society whether this and that individual should be reimbursed. And you can imagine what the result of that was. As a matter of fact, the Radiological Society actually has written to each and every funder not to reimburse anything that is being done in my practice. And many of the funders actually react to that. And as a consequence, do not reimburse. And that is one of the major barriers. We have actually, and this is has been to me quite interesting to look at the CMS and their presentation. We have actually asked our patients to complain to the CMS about this. The CMS has not in a single case reacted.
Those are radiologists in the employ of these schemes, or are they independent radiologists?
Come again?
The radiologist
Yes.
who would say that you shouldn't be paid.
That is the president of the Radiological Society of South Africa.
Okay.
In communication to all medical schemes.
Do the schemes consult this organization?
Yes.
And say, can we pay this person?
Yes. And
they say no?
Yes.
So that's your concern?
That is one of my concerns. Right. Another concern is also the issuance of licenses, which is not happening to non-radiologists. Radiation licenses by the Radiation Control Board.
Thank you. My first question on one of your slides, I think it's the one you talk about technical and professional imaging services. You said that you publish your results.
Yes.
And my colleague Profon has asked about the that we are interested in cost effectiveness,
yes.
in cost-effective models or modalities
yes.
of delivering care.
Yes.
So what measures of effectiveness do you actually publish? Because now you've showed the cost savings and how...
All right. Thank you very much for this question. Let me just explain to that. The breast health and especially breast cancer screening is one of the best researched and best documented areas in healthcare. So, for example, if you're going for screening mammography, there's, for each and every age category, there is the question, how many of the mammographic screens result in a recall? That means that the woman has to come back for further imaging. What percentage of the recalls end up as a biopsy? How is the biopsy being performed, interventional or needle biopsy? The cancers that are being detected, what type are they? What size are they? Are they node negative? Those are the quality parameters. We are the only service in between Cape Town and Cairo, which is quite extensive, that actually publishes such data that are in line with international best practice. I would like to come back to Professor Von's question of just now. What is cost effective? And there's something that rankles always, and that is the issue of self-referral. If you're having technical equipment, are you then inclined to utilize this? And I wish to draw to the attention of the panel the fact that self-referral, as it is mentioned in this crude form, should actually be rejected because it is deeply unethical behavior. And it would mean also, conversely, because I'm a surgeon, that every patient that comes to my door gets an operation. No, I don't do that. And my colleagues also don't do that. Conversely, the separation of imaging services and clinical services does not, and I emphasize, does not exclude the issue of self-referral. Because self-referral also exists in the realm of the radiologists. And this may be news to you, but it is there. If you're a clinician, and let me explain that to you, you're actually very well aware of how self-referral in radiological circles works. You do one investigation. Let's, for argument's sake, say, because we're discussing that at the moment, you're doing a mammography. And you say there's an abnormality, and as a radiologist, I actually recommend a further imaging, for example, with the MRI. And so you have increased the value to your service from a mammogram, which is 1,500 Rand, to a breast MRI, which suddenly is 12,000 Rand. I wish to emphasize that by no means I say that our colleagues radiologists are so-called self-referrals. No ways. I think they're all ethical, and they genuinely recommend further imaging only if it's strictly indicated. But likewise, I wish to reject the suggestion that we surgeons self-refer and that everybody gets an operation. It's not true. But it is important to recognize that the potential for self-referral exists on both sides.
My final question is on, have you raised this with the South African Medical Association?
We've raised it numerous times with the South African Medical Association and actually came absolutely nowhere. We've raised the issue of issuance of licenses with the Directorate of Radiation Control, which has given us a runaround. And there's a collection of replies in your supporting documentation. We actually went as a single practitioner. We went to the Minister of Health, and we've had more than 20 communications to actually look into the fact that the Radiation Control Board refuses to issue licenses to non-radiologists, and we have gotten exactly nowhere. The system is deeply gummed up and biased and skewed towards an unhealthy monopoly.
Thank you.
I like unhealthy monopolies because they interest me. Mr. Appelstedt, can we go back one sheet back? I just want to precisely understand what happened here and who's the actor. So you refer to the SAMA ownership of the coding system, I think?
Yes.
Implicitly in here?
Yes, because that is what most medical aids still refer to.
Yeah,
we know that is invalid, and so for then you know the background.
It's the current coding system. It's the only one. And what is the relationship of the Radiological Society to SAMA here in the heading of the sheet?
None, because the Radiological Society split off the South African Medical Association in the year 2004 and issued their own guide to billing. And they approached the medical fund, as the way I understand it, as a monolithic block and negotiate according to those lines with the relevant medical aids.
For the 1397?
1397, yes.
And that was in 2004?
No, it's adjusted each year.
Yes.
As far as I understand, it's currently standing at 1397.
That's right. So that happened in 2004. They split up. They negotiated. It could still 2004. They could still negotiate a level of reimbursement. Yeah. A year later, that was gone, and so that is being adjusted to inflation or whatever, up to. And then also your 540 Rand also refers to 2004 levels. But it's not being adjusted. Is that the situation?
That is correct.
And the adjustment should be done by medical schemes, isn't it, on a yearly basis?
Let me confirm. Is that done by medical schemes, the adjustment?
No, SAMA.
Speak into the mic.
SAMA adjusts the rates approximately 4 to 5%. Every year it's increased, and the medical aids have also their own increase of the normal percentage increase that they apply every year. So the code 3605 is increased only a little bit every year. However, the code 34100, which is the RSSA code, for that code the reimbursement is negotiated by the RSSA with the funders and usually accepted by the funders. So currently for 2016 it stands at 1397. And on SAMA codes, the medical aids reimburse the patient 540 more or less.
Yeah, but still don't. Sorry, ma'am, for the record, would you please state your name for the record, ma'am?
My name is Anna My name is Annemie Apfelstedt. I'm the practice manager of the medical practice of Professor Apfelstedt and Associates.
Thank you.
I still don't really fully understand what you say. So we, as from 2005-06, we have no collective bargaining on tariffs anymore. Before that, we had a tariff, and after that, we have had several reference systems, either operated by CMS or by the Department of Health, and there's varying degrees of reference to that tariff reference system in the contracts of medical schemes. Hopefully not all in a uniform way, because that would be not what they should do according to the competition law. So what I would like to understand, who decides on this 1397, taking it from 2004 up to now, and that is precisely, as you said, is the amount of money that they need, because that is up to costs. So there must be a form of coordination here somewhere between our SSA and the schemes that agree to pay for this amount. So I would like to know more precisely how that happens, how that can be a uniform tariff being paid by schemes for this, for the code that the radiologists can put on their bills. And the same, of course, happens with 540. And I take it that the 1445, Mr. Appelstedt, is your interpretation of your costs for a normal practice. Yeah. Yeah.
Yes, this is so. As far as we understand, the Radiological Society negotiates with the funders,
yes,
and then combinedly sets the prices,
yes,
for the coming year. Whereas due to the fact that SAMA has been, the South African Medical Association has been ineffective in negotiating with the same, let's put it, rigor or conviction, the pricing actually for imaging stayed behind.
That's right. So when you say you understand, you have no personal knowledge of that?
No, because I'm not a member of the Radiological Society for rather obvious reasons, nor am I, I'm a clinician, I treat patients.
So what happens now on the chair's question? He said, is this driven by type of profession, or is this driven by I said the practice code and the type of service code? He said it's a combination.
Yeah.
So on Discovery's forms, you can fill in your code,
yes,
your tariff,
yes, and
also your practice number. And if you have a particular practice number, so you're from a particular practice category, you can't fit in 34,100. You have to fit in
exactly
36. So that's how the system works. Who is the actor here? Who prevents you from claiming, or who prevents Discovery from paying? Is that from paying according to 34,100? Is that SAMA, or is that?
No, it's the Radiological Society of South Africa that claims ownership of these codes and will actually intervene if anybody else but a radiologist charges in those codes.
So the ownership of so all codes are owned by SAMA except for the radiological codes. Is
that is how I understand it, and yeah.
The 5-digit coding system that the Radiology Society currently uses is not proprietary owned. It's not a proprietary system, but it is used only by radiology firms with a radiology practice number on top of your invoice. So the radiology practice number, starting with 38, that's a number that is allocated to every radiology firm. The radiology practice number may be on top of the invoice, and that they can charge for the 5-digit coding as we see here, for example, 34100 would be the 5-digit code for mammography.
Yeah.
Any person who is not a radiologist may not use the 5-digit coding, but must use SAMA coding.
And do you have any idea, is there any role of the HCPSA in this situation?
No direct role. And there's no direct role for the HPCSA in this, as far as I would know. But coming back to earlier questions about scope of practice, the HPCSA has on 2 occasions confirmed that I actually can engage in breast imaging and its interpretation. It's within my scope of practice.
That's right. Do you want to follow up on this one?
I also want to check an issue. How would the Radiology Society know if a because they never see the medical aid claims. Medical aid, you send your claims in. How would the Radiology Society know what the medical aids pay other people?
You're asking me something that I don't know. I simply can't answer this
question. Does it seem feasible that before... I'm not arguing with you, I'm trying to understand how the system works. Does it seem feasible that the Radiology Society is so powerful that the schemes are so scared of them that they're worried they're going to come and check all the numbers, and if they find someone being... I'm running a medical scheme, and your code comes in 27 and whatever, and I pay you. How would anyone else know what I've done besides you?
Frankly, I don't know, but it seems to me that the Radiological Society has got a hold on this reimbursement. You will find this in all the scheme's rules that you cannot. Yeah.
It's in the scheme's rules. That's
yes.
what you do.
But how does it come into the scheme's rules is your next question, and I can't answer that either.
May I just, Case, if you don't mind, in terms of the link with the Professions Council, isn't that the starting point? When you qualify as a general surgeon or a radiologist, you take that registration with the HPCSA if you intend to be in private practice. And then the Board of Healthcare Funders, the practice code numbering system, will allocate a practice number.
Yes.
Which, based on the classification of your qualification at the HPCSA, will give you a number that has got a prefix that is relevant to your practice. Meaning, I've forgotten now, the general surgeon, what is the prefix? Is it
15?
15. But a radiologist will have a different prefix. Is that not the case? Now, that 15 and 38, as far as I know, would then be linked at medical scheme level as to what codes you can or cannot claim for.
Exactly.
So that is where the link, where it starts at the HPCSA, yes. Is it not so?
I would like to add that we have a group practice number, 0155052, specifically for this purpose, where the group practice number, this number, has a link of all the practitioners working in the practice, which is Professor Appelstedt with a practice number, individual practice number starting with 42, the second surgeon, and then the other people working in the practice. And all these individual practice numbers are linked to the group practice number. So all that is fine and catered for and accepted.
But the principle remains that it's still a 42 number, which is different from a radiologist number.
In essence, yes.
That's the link.
That's
the link with the Edge Professions Council. Yeah. So this is where my confusion comes.
The practice numbers are actually not set by the Health Professions Council, but by the Board of Healthcare Funders.
Yes, but the Board of Healthcare Funders depends on how the HPCSA classifies you.
Yes.
Yes.
And now, of course, but I can't give the answer, but I think what we're trying to get at is the balancing of whether this is 100% self-protection by the radiologist, just pure economic interest of of the organization and its members, as you implicitly suggest, or maybe also explicitly have put before us, or whether it's a matter of protecting the quality of the service. And I think Natsuka has gone through that with you. I'm not a doctor. I can understand what you said. You are perfectly capable and able to do the imaging. And I can't decide on that, but I do think I understand the balancing that is being done. And of course, this is one of the core issues of the inquiry itself, to see whether we can find incidents of power within the system that shouldn't be there. But I can't make that call today. I think I've further understood your presentation very well. Thank you very much.
Can I speak to this last point?
Yes, please.
It is actually so that in South Africa, and I know this from international experience, it is so that the Radiological Society enjoys a very unhealthy monopoly, which has been broken up in places like, for example, the United States and in Western Europe, where the imaging has migrated towards the subspecialties. And this is a trend. And as you put it correctly, places like my own provide actually an existential threat to radiology, because in my practice we are delivering results superior to best practice in radiology, and there's no radiologist involved. And that must be an existential threat.
Understood. Thank you very much. Yes.
Yes. I mean, help me understand as a layperson, excuse me, please. Help me understand as a layperson precisely what your concern is.
Right.
Now, if I get injured on my ankle, I go and see a doctor, and this doctor says to me, well, you need to see a specialist. And then I go to the specialist, and then this specialist says, you must go and take an X-ray. I go and take an X-ray, and then come back and give this specialist the X-ray. He looks at it, at the report, he says, you find nothing wrong with you. Now, where is your complaint there?
It actually is very simple.
Mm-hmm.
If you were to go, and most likely you're going to do that in real life, if you were to break your leg, you would most likely want to go to an orthopod directly, to an orthopedic surgeon, and you would actually appreciate it if in the very same practice you could have an X-ray of your leg and then be fixed accordingly. And you would actually think that the orthopedic surgeon knows how to fix your fracture by looking at the image and actually know exactly which piece of bone belongs where. Would you rather prefer to go to a radiologist and then be X-rayed, and then go back to the orthopedic surgeon while you're still in pain, and the orthopedic surgeon not look at the X-ray, but merely look at the report and try to fix your leg like that? I don't think so.
Now, what I speaking for myself, what I would prefer initially is that whoever takes the image of the injury is a person who is skilled in doing so and is able to read that accurately. And that would be my concern in the first place, so that there is no mistake about the imaging.
There's another concern here. Let me speak to your first concern. And I want to wish it very, very clearly understood that I have no bone whatsoever who does the image or so further and so forth. But that it's being done properly and that the patient experience is a good one. And the current system with the 3-step procedure doesn't look to me like a very good patient experience. Now, the second point that I want to make is actually that, and I've made it before, I think that a super specialist, and I emphasize here, a super specialist in his own field is most likely, and we've seen many examples of that in the scientific literature, is actually much better in interpreting the results of X-rays than a general radiologist. I emphasize here a general radiologist.
Precisely what is your concern? Do you want, I mean, if you do these images, you want to be paid as a radiologist with the same code that you've given us the code. Is that what it is? Or do you want the freedom to do imaging, and when you do that, to be paid as though...
Appropriately. I want both.
Yes.
And I want to have a system of healthcare where there's real competition in terms of quality, and yes, also of price. And it is actually very important to notice that we are a developing country.
Yes.
And we have limited resources. And to interposition a specialist where actually none is needed in many cases of a different specialty actually drives up prices. And that's what it is. That's what it does.
Now, do radiologists undergo a special training to be able to do their job?
They do, without question. Just to give you an example, and I know what you're driving at.
No, what matters is not so much what I'm driving at. What matters is the answer to this question. Do radiologists receive a special training?
Yes, they do.
Yes. And for which they have to be paid?
Yes.
And the code that's assigned to them is a reflection of that?
This is undoubtedly true.
Yes. You have your own specialty.
Yes.
Which doesn't involve the training that radiologists receive, does it?
It involves, and I take issue with this statement actually.
Yeah.
Just to give an example, I work in a teaching hospital.
Right.
And just to give you an example, the surgical training as well as the radiological training. The radiological training at Tygerberg Hospital has about the viewing in my specific field of interest of 4 months of breast imaging. If you train as a surgeon, you will see breast imaging together with clinical presentations for 6 months, which is 50% more than any radiologist. I can further tell you that at Tygerberg Hospital, if you're a surgical registrar, you're also obliged to attend imaging pathology correlation sessions at 2 hours per week, where you will see actually in the end many more breast imagings than when you train as a radiologist. So it is I could as well contend that if you're training as a surgeon at Tygerberg Hospital and the University of Stellenbosch, you will have a much better foundation in breast imaging than a radiologist trained there.
I understand. Is there anything else that you'd like to...
Judge, can I just one
Yes.
short... Professor Appelstadt, look again at my sheet. Who is keeping, or who could keep Discovery from paying you $14.45 on code 3605?
We've tried it.
Who is able to keep Discovery from paying you $14.45?
Okay, I hear from the side of my practice manager, Jonathan Broomberg.
Right. Because he likes his money.
Obviously, it's very convenient.
But it's not the RSSOA who keeps Mr. Broomberg from paying you $14.45, is it?
Well, I don't know what the influence lines are there.
Thank you very much.
It's obviously a very convenient situation Because this way the patient pays 1,000 rand that actually the patient has bought insurance for.
Yeah. There's this last question. You've given us the code, and what is the code for general surgeons?
3605.
And for radiologists?
34100.
Okay, so that would require a change in the codes.
In coding or in reimbursement level for that code 3605, because there's always a reimbursement attached to a code, and that can also be varied.
Yes, okay. And then in that event, whenever you do the work that you're mentioning, you would have to be reimbursed as if you are a radiologist.
I'm not saying
on their codes.
No, I'm not after that. What I'm after is to be at a realistic reimbursement level.
Yeah. Which is what level on these levels that you've given here?
It has got nothing to do with the radiologists.
Right.
It has got to do with the practice cost. And the practice cost, as reflected here, is 1,445 rand.
Right. And why are you paid that amount?
Pardon?
Why are you paid that amount?
Why am I?
You are paid 540.
Yes.
Instead of that amount.
Yes.
Why?
Because the SAMA hasn't adjusted the reimbursement for their codes, and the medical aids will not pay out according to anything else but this code if they pay at all. And remember, some medical aids don't reimburse at all.
Now, adjusting the code would mean what?
Adjusting the reimbursement that is linked to that code.
Yeah.
Yes. That is for SAMA to decide. And as I've mentioned before, it has not had any form of effect, no matter what type of practice cost studies we submitted. We've done twice this at great cost to ourselves. We employed actuaries to actually show that the costs are that.
Yeah. So,
and that is fair remuneration.
So the code that's presently assigned to you does not truly reflect the kind of work that is involved.
Quite correctly.
And that's all you're looking for.
Yeah.
Are you in any of your relationships in a designated service provider relationship to any medical schemes?
No.
Have you been asked, invited, responded to a call?
No.
Is there any reason for that?
I cannot answer that to you, but we from our side have offered 2 medical aid schemes a comprehensive service package, which actually is much cheaper than what you see here, because in exchange for the volume, we would absorb, for example, pathology costs and so further. They have not agreed to this. The reason being that the membership is too dispersed and the services are not, and they could not actually, their information systems are not as sophisticated as to allow them to drill down to that level that actually we could demonstrate we are cheaper than what they're currently getting. And it still remains my contention that this is so, because we're keeping the downstream costs minimal.
If your real concern is that the code presently assigned to you doesn't truly reflect the kind of services that are involved in your work, and all that's required is simply to ask those who are responsible for assigning code or indicating what's involved to upgrade the code. Is that right?
That is part and parcel of the problem, but I've also got another problem, and that's the principal problem. That is there must be an allowance for competition and between clinicians and radiologists for imaging services. Okay. As long as the system remains as gummed up as it is for the moment, with differential remuneration at each and every level and each and every imaging service, we will not see healthy competition emerge between clinicians and radiologists as to what concerns provision of imaging services.
Well, probably I don't understand. I thought that perhaps you should say this in your own words. What precisely are your concerns? The first concern, what is it?
First concern is purely for my own benefit. And that is, or benefit or for my own existence,
yes,
that one should be fairly remunerated for good quality work. Full stop. This is not happening for reasons outlined. Then on the systemic level, and here it becomes interesting for the panel actually as a whole, is we have no competition to the Radiological Society in South Africa as to what concerns imaging provision. And this is something lacking. This is something that is happening elsewhere, where, for example, a neurosurgeon would order a CT scan from a shared facility with other people and then interpret the results himself before he does the operation of the brain tumor. And I think we must free up the system to allow more competition into it, and then prices might come down.
Insofar as the first one is concerned, what is required is to upgrade the code so as to reflect truly what's involved and then determine what's a fair remuneration, as you use the word fair remuneration, right?
Yes.
And that insofar as the second concern is you have in this concern, you would like other specialists to also do, to compete with a radiologist.
Yes.
To do everything that the radiologists do.
Pertaining to their specialty.
Yes.
For example, a urologist, when he does an ultrasound of the kidneys, or gets a CT scan as prepared by a radiographer in a shared facility, he can interpret it because he knows how to operate it. And that would be fair income.
Yeah. When they come back from the radiologist, don't they come to you and then you look at them?
Yes.
Okay. Is there anything else that you'd like to add to what you've told us?
No.
Thank you. Thank you for coming to share with us your concerns.
Thank you very much for listening to me.
Thank you.
And affording me the opportunity.
Yeah, thank you. Gentlemen, this is the National Hospital Network, is that right? Yes. Who's the leader of the panel?
Judge for my sins, Kurt Worrell-Clare. I'm the Chief Executive of the National Hospital Network. To my right is the Chairman of the Board, Mr. Emil Defchant, and on either side of us are our legal advisors, Mr. Tlamini and Mr. Bauer.
Yes. So I think as and when they attend to make any presentation or to comment on what you're saying, if they could just place their names on record.
Certainly.
Yes, very well. So you're going to start?
I will.
Sure.
thank you to the panel for this opportunity, and apologies for the late hour. I hope we can get to the gist of our presentation. I'm tempted to say, may we take our heads as read, certain of the documentation, so that we can really just get to some of the nub of the issues as opposed to repeating ourselves. Just a brief introduction to who the National Hospital Network is. What you'll see in terms of our submission as first presented to you is some data in terms of where we are as an industry, who we represent. We have updated it a little bit, and I'll give you some of those updated figures now. But in essence, the National Hospital Network is a representative body established first in 1996 and having enjoyed 3 exemptions since that date. The first having been awarded to us really early in 2006, and we currently have an exemption which ends 31st of December 2017. And these have been granted to us from the Competition Commission itself. The purpose of our exemption is really to protect the interests of smaller independent hospitals or standalone facilities, as we refer to them, who are not part of any group such as Netcare, Life, or Mediclinic. And the reason for that is one of the conditions set down by the competition authorities in granting us an exemption was that there could be no share value in any one of our particular members relating to any of the groups. That within itself is posing some interesting scenarios which we'll speak to in terms of this particular panel, because we are noticing going forward that while some of the groups are not necessarily purchasing independent members, although that is happening as well, that there is a new interesting development where some of the existing groups are entering into venture or joint ventures with some of the independent hospitals, which is posing some interesting challenges for us under our exemption. So where we are at the moment in terms of the NHN is we're currently representing approximately 8,600 beds within the sector, and that's made up of a variety, just to get to my notes here, it's made up of a variety of different types of health categories or health establishments. We've heard from some of the other stakeholders that we very often refer to as the 4th group. We would like to correct that. We don't think we are a 4th group because of the very nature of who we are in terms of the subcategories that we represent. We have acute hospitals, subacutes, rehab, day clinics, and psychiatric hospitals, all of which are within our broad parameter. That makes us quite attractive to some of the medical schemes in terms of the services that we provide. And as we sit here today, we've gone from 2006 representing 70 or so health establishments to current date where we represent approximately 177. As I said, around about 8,600 beds. At the same time, we've seen consistent growth over the years, and it's with great thanks to the competition authorities for having granted us that exemption, because it certainly enabled us to establish ourselves within the market as an alternative to the groups that exist within the particular environment now and who constitute approximately 80% of the market. Our geographic spread is throughout the country, as we've evidenced in some of the slides for you, and we've shown you some of the growth there in terms of where we stand as the National Hospital Network. That's the NHN's bed growth per year, and those are the figures which we've tried to break down for the competition authorities, where we've played open books and we regularly update them in terms of annual information as to our membership, as well as a host of other information which they require from us. That's our geographic spread. The difficulty with these slides, and if I can just maybe emphasize it for the purposes of the panel, is that much like what happens with the provincial licensing authorities, we tend to look at beds as opposed to types of beds, which I think is very important for the purposes of understanding the restrictions that are imposed on our members in terms of their relative scopes of practice. For example, a mental health facility, although qualifying as a private bed, can only treat mental health patients, and within that there are subdivisions as well. Mental health facilities, for example, can be divided into 3 types of beds. You can have a voluntary patient or voluntary mental health patient, an assisted mental health patient, and an involuntary mental health patient. And then even within that, there are even subcategories where you have beds that are allocated to adult patients and then beds that are allocated to minor patients. So it's somewhat of an amorphic tool that's very often used by the provincial authorities, and that's something we'll speak to when we're looking at some of the regulatory impediments which we'd like to speak to. We're currently under a four-year exemption, as I said. We believe that the 4-year exemption was granted to us as opposed to a 5-year, largely because of the inquiry that's happening as we sit here today. And it's likely that we'll reapply once all of the information has been discussed. So we have 3 government notices which you can reference and which is available to the competition authorities, many of which have set down conditions under which we enjoy the exemption. The current condition is that we supply on an annual basis information relating to our membership and our growth. And we can say without any doubt that the exemption has been extremely beneficial in protecting our members, in particular the smaller hospitals, from acquisitions, mergers with the large groups, and vulnerabilities that are in the market, as at the same time representing hospitals that have been in the market owned by previously disadvantaged population groups who have struggled even under the apartheid regime and certainly have established themselves as credible and quality-driven facilities to this day. In addition to which, we believe that we provide a viable tool for new market entry, which we believe is critical in order to ensure that competition happens at the extent that it should within this country. At the same time that the NHN has grown, we've noticed that the medical scheme population, or certainly the medical scheme administrator base, has grown as well. And we've noticed a consolidation in that market from certainly the 2006 first exemption, when we were only representing 70 or so facilities, to where we are today. From the Council for Medical Schemes, we make reference to basically 3 medical scheme administrators. The 2014 data that we are seeing is that MedScheme Holdings in 2014 represented about 27.2% of medical scheme population, Discovery Health at 27.2%, and Metropolitan Health Corporate at 25.3%. We've added a little bit of additional detail to that because some things have happened in the interim, and I mentioned in particular the fact that BankMed Medical Scheme has switched from Metropolitan to Discovery Health Administrator. Providence has also been incorporated within Metropolitan, and PolMed has switched from Metropolitan to MedScheme. So we estimate the consolidation in the market to be approximately 31.9% for MedScheme Holdings, Discovery Health at almost 29.1%, and Metropolitan Health Corporate at 19.3%. Why we mention the consolidation of the market in this regards is because the NHN faces 2 scenarios in our negotiations. Either we negotiate with a single administrator who is negotiating on behalf of all of its medical schemes, or we'll negotiate with a single administrator who will then facilitate negotiation with every one of its respective medical schemes in a separate process of engagement. So you won't have 2 medical schemes sitting in the same room discussing a negotiation package with us. We will meet with them on an individual basis, and that will be accommodated by the administrator, who will then provide a supporting role. From a preference point of view, from the NHN, we find that the latter example is more beneficial for us on the basis that we're able to engage directly with the medical scheme and its needs, and have been able to design together with those medical schemes packages which are beneficial for the medical scheme and its membership base. Here I want to put a caveat, if I may, and say that we're very cautious not to discuss the nature of those agreements, understanding that our competitors are sitting in the room and watching what is happening and what's over live streaming. But we can say to you that we have adapted to specific needs within the medical scheme environment based on their membership profile and some of their very particular needs. When we are negotiating with a single administrator that's representing on behalf of all of its medical schemes, it poses some significant challenges to us. And those challenges include the fact that very often the administrator will have a single set of rules which will incorporate all of its medical schemes. So you won't have any variances between the medical schemes. And we want to just flag for the attention of the panel that it's good for you to probably look not only at the consolidation of the administrator, but also the impact that rules imposed by administrators may have on restricting access to medical scheme members, and we'll give you some examples as we proceed. Whether or not the medical scheme administrators are playing within the areas of Section 4 or Section 5 of the Competition Act, we don't believe it's something we should answer, so we're going to defer that to the panel to have a look at. But what we do want to say at this stage is that as the NHN, we felt it necessary to apply for an exemption under the Competition Act, and it seems somewhat inconsistent that parties who are doing much the same thing would not have done the same. Having said that, and again referencing some of the rules that are imposed by a single approach amongst numerous medical schemes, you might have a situation where the administrator imposes a rule which then impacts across all of those medical schemes, which is not necessarily in the interest of competition. If we may move on, because we don't want this to be a blame game, but I think rather if we can speak to the purposes of what these hearings are and the terms of reference as given, what we'd like to do is highlight some of what we believe are some of the areas of concern around competition and some of the regulatory matters which we've addressed in some detail in our submission to you. And we've sat here in many of the hearings, and I don't want to rehash them, so please, if you feel you've heard it enough, please be free to just say we hear that point and maybe move on. But when it comes to the licensing of facilities, we believe that there are some real impediments to competition, and if we may reference some of those concerns that we have, and forgive me for being quite legal in this particular presentation, but I think it's important for us to address some of the legal concerns with a reference to the regulatory framework itself. Where we currently stand today in terms of licensing is that it was initially a national competence as provided for in Section 44 of the Health Act of 1977. As a consequence of the interim constitution, that process was by promulgation, or proclamation more accurately, devolved to the provincial authorities, which posed some interesting difficulties, because if we read the provisions of Section 44 of the Health Act of 1977, you'll see it makes reference to particular officers such as the Director General, which doesn't fit nicely within the provincial dynamic. We don't have Director Generals within the provincial competencies. So there is some confusion as to which parties or which authorities are responsible for the processes. During that time, two provinces in particular took the opportunity to enact their own provincial legislation, which became almost effect the enabling law to allow them to promulgate their own licensing criteria. And we've heard representations, for example, from the Western Cape, which has promulgated its own regulations under 187. But some of the problems that we currently face within the provinces that adhere to Regulation 158 are as follows, and I'll list them briefly for you. Significant inconsistency interpretation. You might, for example, have one province that will allow certain aspects only to be denied the very same things in another province because of the different interpretations and the different approaches. Inconsistency in responsible authorities with specific reference to appeals lodged in terms of Regulation 55. Some provinces, for example, have advisory committees which advise through the process. Others have different processes with different timeframes. Rejections of applications of either new licenses or variances existing licenses issued with no or little reasons provided, thereby raising administrative fairness concerns. And whilst we always have the right to challenge this on an administrative basis in law, this is a costly process which very often results in lengthy delays and huge costs to both parties, including the Departments of Health that are defending those decisions. Then what happened very briefly was the National Health Act, in particular Chapter 6, as it refers to sections 35 through to 40, was promulgated erroneously in the absence of regulations, and for a period of time, technically all health establishments were illegal on the basis that in terms of those provisions, we had to reapply using the Certificate of Need process. Yet there were no complementary regulations to allow us to do so. As a consequence of that, the Hospital Association, of which we are also a member, together with the Minister of Health, made a joint application to the Constitutional Court, together with the State President, to have that promulgation overturned as premature. As we stand here today, provinces that have not enacted their own provincial legislation still adhere to Regulation 158. Regulation 158 was first drafted in 1980. It's 30 years or so out of date. And some of the practical problems that we have in that regard is that it's a one-size-fits-all approach, which is not necessarily in line with what's in the best interest of cost affordability. And I'll give you an example. Regulation 158 is primarily for an acute-based hospital. So it'll talk about things like a 2-meter wide corridor. And the reason for that is you've got gurneys and you want to push your gurneys through that. But Regulation 158 also applies to psychiatric hospitals, which don't have gurneys and don't have theatres, and yet you have to build a 2-meter wide corridor. It doesn't make sense. So what we've always argued for as the National Hospital Network is for carve-outs within the licensing framework that are adapted to specific healthcare needs. So you have criteria for subacutes, you have criteria for day clinics, and you have criteria for psychiatric hospitals without instituting the acute-based requirements from a construction point of view, which impacts significantly on cost at the end of the day. That to date hasn't happened. Although in the Western Cape, as you heard in their presentation, they have started to make that distinction between the different types of facilities. But there's no real law in terms of how those things are actually built. In some provinces, we have concerns, and this is not something which we're not discussing here for the first time, because we've actually met with the MSC and the HOD in these particular provinces, where we've seen a gradual introduction of new criteria which is not published, not accessible to the public. Very often, the first we'll hear of it is when we apply for those licenses. And the concern that we have in this regard is, from a legal point, we feel that if you are going to impose criteria as an administrative entity, then there should be a legal process allowing you to do so. To add arbitrarily criteria is ultra vires in our opinion, but we don't want to be in a process where we're constantly litigating against the regulator, because the perception is that we become a litigious entity, and that's really not what we want to do. We would rather work together with the departments of health in terms of understanding basic needs around licensing. So one of the recommendations that we would put to the panel is for a comprehensive unpacking of Regulation 158 within the context certainly of the Certificate of Need as envisaged within the National Health Act, but more importantly that we start looking at distinctions between types of facilities, so that when we're looking at license applications, we don't have the blunt tool of there are enough beds in the province, therefore it's a barrier to entry for new market players. And if I may, just by virtue of an example, the total number of beds in KwaZulu-Natal versus the total number of beds in Gauteng, if we start unpacking it by referencing bed types, we'll see that there are disciplines such as mental health that are underrepresented and could do with more representation within those particular provinces. And then if we even unpack it a little bit further, you'll notice that when it comes to aspects of mental health, for example, that are designed around the needs of adolescents or minors, there are even less beds that are allocated for them. So if we can unpack the entire component of Regulation 158, recommend some carve-outs in terms of how those facilities should be licensed, have new criteria in terms of it. And here I want to emphasize the fact that as the National Hospital Network, we would certainly not oppose being regulated in that regards. Regulation is helpful, it protects the members of the public, and certainly something that we would support.
But does the National Health Act, though, not contemplate regulations?
Yes.
So that you don't, Regulation 158, those regulations were promulgated under the 1977 Act.
Correct.
What the new Act does, it contemplates that there will be a regulatory framework which is consistent with the new Act.
Sure.
Yeah.
But if I may just perhaps maybe give an example of how a perfect opportunity presented itself for us to correct some of those inconsistencies in the past is when we look at mental health legislation, for example. Rather than take the opportunity, and mental health law was enacted in 2002, much later than Regulation 158. Rather than use the opportunity to say, let's design mental health facilities which are beneficial for patients without the need for 2-meter wide corridors, because there's no gurneys, there's no theatres. What it did was re-emphasize in Regulation 42 the need to comply with Regulation 158. So the point that we're really putting to the panels, if a sincere recommendation can be made for the categorization of health establishments so that the licensing is health establishment specific as opposed to having a one-size-fits-all approach, which is not necessarily in the interests of the applicant who's applying, and at the same time the building requirements that could have a ripple cost effect in the industry. And the reason why we highlight this is because the more expensive the building or the more expensive the capital investment, the more impact that's going to have on the patient in terms of recovering that capital amount. And if I may preface at this point, one of the concerns that we have with the National Health Act is that it doesn't make the distinction between consulting rooms for doctors and hospitals, and it talks about the allocation of a license under the Certificate of Need for a period of no more than 20 years. The initial submission, or the initial draft of the National Health Act talked about a 10-year license, and we raised some concerns as the hospital sector that if you have a 10-year period of which to recover your capital investment, that's going to impact negatively on cost for patients. The longer the duration of the license, the better it is to recover that and make it more affordable. We're still not convinced that 20 years as a potential maximum is enough with no guarantee that the license would be renewed. And again, we must make a distinction between the license to run a facility and then the operational licenses, which happen every year to ensure that you comply with certain quality standards and regulations. That happens on an annual basis anyway with all of our facilities.
So what period would you like?
We would be happy to work with the Department of Health in order to come up with a credible period.
No, but on 2 occasions, they've come up with 10 years and later with 20 years. You're not happy with any of them.
Well, we're saying that maybe if we had some language that was more consistent with, if it was to remain 20 years, then there would be some language for renewal of another 20 years. What we wouldn't like is just an arbitrary application of 10 or 20 years, but there be some empirical evidence behind how we come up with a number. And it also might depend on what type of facility it is. A day clinic might be treated differently to an acute-based hospital. So there could be some variance there from the national authorities. So when it comes to the National Health Act, we think it important, and here there's some absence or some areas which have not been provided for within the current national legislation. And we understand that under Regulation 90, the Minister has powers to enact regulation. And maybe this is something which can be a recommendation coming out of the competition authorities as a means of promoting competition, more enhanced competition within the sector, is to allow for different categories. If we look in the current definitions of the National Health Act, you won't see a definition of an acute-based hospital or a subacute or a psychiatric hospital. Other legislation might, but it might be important to utilize the opportunity so that the licensing can be specific to those facilities. What we would also say to the provinces is that when it comes to allowing new entrants into the market, that it's possibly incorrect to have an approach which merely references the number of beds per population dynamic. We should be making distinctions between bed types. As I've mentioned just a few of them, we've got acute hospital beds, we've got mental health beds, and those facilities are actually restricted by their particular scopes of practice. So you cannot have a situation where a mental health facility will treat a surgical patient. So it's very often a blunt tool that's used by the provinces to restrict access into the market for particularly new entrants. And we think that that's an incorrect approach to have. So one of the recommendations that we would make to certainly the provinces is to rather interrogate the type of beds that are in the geographic regions. And from a competition point, we would also say if there are specific concentrations within a particular area where one of the groups are dominant, that maybe it would be in the best interest of that geographic location to have a competitor which is not a group, as a means of providing competition to the sector. If I may then move on to the Medical Schemes Act, and we're very glad to see that we were not the only ones complaining about designated service provider arrangements and the PMBs. I'm not going to re-emphasize a lot of the concerns because I'm sure that you've heard them, but to say the concern for the NHN is that designated service provider arrangements are a critical component of the Medical Schemes Act, yet it remains one of the most unregulated. There's no provisions within the Medical Schemes Act which talk to the principles of the designated service provider arrangement, the manner in which these are contracted, transparency as to how they are appointed. And certainly what we're experiencing from the NHN is despite the fact that we believe we can offer a cost-effective alternative, and the medical schemes that we engage with would indicate that in many instances we are able to provide cheaper interventions at the same level. We are not seeing ourselves appointed onto DSPs because of either existing contractual agreements, and here I want to reference a question that Professor Von mentioned to another stakeholder, where where you said that your impression was that we negotiate contracts on an annual basis. We are aware of the fact that some of the contracts are 3-year periods, where they've engaged with a group, for example, for an extended period of time. And largely because of those contracts, we've not been able to access the designated service provider market. We are encouraged to hear from the Council for Medical Schemes that they're aware of the fact that in some instances, these designated service provider agreements are sometimes more expensive, and it begs the question, if we're looking at affordability within the market, why would cheaper alternatives not be on designated service provider arrangements? The concern that we have in this regard is that as we sit in our negotiations with medical schemes, the criteria applicable to the appointment on DSPs is very often not known to us. Some medical schemes have indicated that their approach going forward will be as follows, that they will have criteria applicable to quality, price, etc. And if your hospital meets that criteria, there's no reason why you should not be appointed on the DSP. We would certainly support that approach. What we're concerned about is anecdotal evidence, and here I must preface the fact that it's anecdotal. We've not been able to test it, and for that reason we would make the recommendation to the panel to perhaps request copies of these designated service provider agreements so that you can interrogate it. But we've heard, for example, that some medical schemes will refuse our members access to a DSP on the basis that they have to ask permission from the anchor network whether or not they can allow a competitor onto the DSP. For us, that begs the question, and not only in terms of contract law, but certainly in terms of competition law, that we would have to get permission from our competitor in order to be appointed onto a DSP. Obviously, our competitor would not allow that. And on that basis, we would really ask the panel to interrogate those agreements in a little bit more detail. We also are concerned that the manner of designated service provider agreements being transparent not only for ourselves as providers, but for our patients as well. In some instances, for example, where we approach a hospital or a funder for an authorization, we are told that we are not the designated service provider, and yet the patient is in the community which is service-based by that particular hospital, our member. And even if our member then says, we're prepared to meet the costs of your designated service provider in order to assist our patient, nonetheless, the authorization is denied. So even though we're prepared to meet from a cost perspective exactly the same terms and conditions set down by the designated service provider and its anchor network, we are prohibited from treating that particular patient. It then becomes extremely difficult for us to explain that to the patient who, as we've heard in many of the testimonies today, are very often not in a position to engage in this level of discussion with their medical schemes. We also believe that those, not necessarily the intellectual property behind those contracts, but certainly the impact that these contracts have on their patients should be public and should be available to their patients for them to understand. Other scenarios that we've faced is a designated service provider is appointed almost 100 kilometers away from the hospital where the patient is resident, which references us to the Code of Good Conduct, which we've often heard of in these presentations. Our experience with the Code of Conduct is that it's a nice to have. There is no legislative force behind it. There's no law which empowers it, and if the hospital, or I'm sorry, if the funder doesn't adhere to the provisions therein, it's not as if they can be sanctioned, which we don't necessarily believe is in the best interest of patients. So we would like, for example, the Council for Medical Schemes to address that, as well as the designated service provider contracting environment in which these are currently done within the sector. Now, we have discussed this with the Council for Medical Schemes. So again, it's not something which we're discussing here for the first time. We have approached the Council for Medical Schemes. The response that we got is something that we're going to have to take up with them again, because we don't believe that the reasons they've given us not to address our concerns are entirely within the ambit of legislation, but we've not had the opportunity to engage with them, so we intend to be doing so relatively soon. So in short, in a nutshell, as we sit here today, what criteria is applicable to the appointment of providers to DSPs? Currently, there are no provisions within Medical Schemes Act pertaining to the principles, criteria, and the manner in which these contracts are concluded. And very often, they're subject to confidentiality clauses. So even if you ask for access, you're denied on the basis of confidentiality. And the question that we would pose to the panel is whether or not these contractual terms have exclusivity clauses which are in the interests of competition. We've also heard from many of the patients here and as some of the administrators that have given evidence that if they're unhappy with their medical scheme, they can walk and vote with their feet. We submit that that's not entirely true. If we look at Section 29A of the Medical Schemes Act, as was evidenced by some of the previous submissions, medical schemes reserve the right, for example, to impose waiting periods, in some cases up to 12 months for pre-existing conditions. And it seems somewhat arbitrary if you look at Section 29 that if I voluntarily want to move from one medical scheme to another, that I could possibly face the likelihood of a waiting period for 3 months, with the exception of PMBs. Yet, if my broker, as part of an employment relationship with an employer, makes a move as an employer, those waiting periods don't apply. Now, very often the reason for such is that they want to prevent churning within the medical scheme environment. Arguably, I would say that an unintended consequence is that patients cannot vote with their feet. They are very often tied into these medical schemes, which are not necessarily meeting their benefits or their particular needs. And perhaps that's Section 29 can be re-looked at, particularly in the light of the fact that there's an inconsistency between if my employer says I may move, no restrictions apply, but if I do so as an individual, those restrictions do apply. We've heard much about the reserves currently within the legislation, in particular 29.2, sitting at 25%. The National Hospital Network feels that this might be too high if we look at international comparisons at reserve levels. A significant amount of money is now sitting in reserve banks, which have very particular rules applied to how it may be used, and we think that some of that can be freed up for member benefits. At 25%, certainly when it was imposed, we believe that the net effect was we saw a radical decrease in benefits as medical schemes were working in a defined area to try and recover that money in order to pay and meet their legal requirements, and that very often was at the expense of benefits to their members. If we look at the Health Professions Act, if I may move on to that, we've heard some stakeholders have called for the right, for example, to employ health professionals. And that's referencing Section 8.1 of the ethical rules, which would prohibit corporates, for example, from employing health professionals. What the National Hospital Network is saying in this regard is it's not as simple as saying, yes, you may employ in order to be more cost effective. You have to take into account the dynamics of the market as it exists today. We believe that as the market exists today, one of the consequences of allowing corporates to employ health professionals would be that the large hospital groups would be able to meet better salary demands and be able to pay for these practitioners at a level that the smaller independent would not necessarily be able to meet. An unintended consequence, and something that we would have to consider from a competition point of view, is that if we look at the employed individual, an unintended consequence is a professional who's able to render his services currently to anyone who approaches him the result of him being employed would be that he's no longer allowed to receive patients from anywhere. Those patients would naturally be diverted to his employer and thereby take his skills out of the market to a general population and limit him to an employment relationship where those skills would have to be accessed within the corporate entity that employed him. And in some areas, this might impact extremely negatively when you have, for example, low representation of specialists, rural areas in particular, where you take that person out of the general population accessibility and you place him in a single environment who, again, might or might not be a designated service provider. A worst case scenario, they're not a designated service provider, and then you have all of those consequences attached to that employment relationship as well. So as we sit here today as the National Hospital Network, we don't believe it's as simple as, yes, let's employ doctors in order to be more cost effective. We believe you must take into context the dynamic that we're sitting here today from a market perspective and the fact that the 3 hospital groups constitute 80% of the market and are probably in a position to offer far better packages than a small standalone facility at the end of the day. This also seems, and I want to reference, for example, to other legislation, because very often people look at Regulation 8 in isolation and they don't look, for example, at the Mental Health Care Act and certainly the ethical rules which are set down by the Board for Mental Health Practitioners. In particular, in its annexure, it refers to multiple relationships, and it actively encourages its members not to engage in multiple relationships where there can be potential conflicts of interest. So for that, it seems that certainly some of the professional boards have gone a little bit further than just Regulation 8, and they've actually interrogated it from a perspective of multiple relationships and whether or not that is in the interest of patients at the end of the day. And that's basically where we are as the NHN. We purposely didn't want to come here in order to finger point, but rather provide some practical examples for the Commission in terms of where we should be looking. And I think from our perspective, we've mentioned some of the blunt tools which we don't believe are necessarily in the interest of competition. We've tried to reference some of the questions that have been posed. What I would like to add is that one of the calls, certainly from the patients that have given their testimony here today, and it's been extremely helpful for us as well to understand, the difficulties that they face. But one of the requests were that doctors would be responsible for explaining PMBs to their patients. We don't believe that that's something that a doctor should have to do. If you look at the National Health Act, in particular Section 6, 7, and 8, as it refers to informed consent, the doctors already have an onerous obligation to explain to patients their benefit options, the risks associated with those benefit options, and it very specifically refers to costs as are experienced by the practitioner himself. In other words, the cost that the practitioner would be charging the patient. So in other words, to be responsible for explaining his own costs. I don't believe the intention of the legislation was to allow doctors now to become responsible for the very thing that administrators are paid for, and they're paid well for the job that they do. And my concern is that we don't create an environment whereby administrators are abrogating their functions to health professionals, which is not within the broad parameters of legislation as it exists today. Section 7, 8, and 9 of the National Health Act are more than in the interest of patients. Doctors, including health establishments, are obliged to explain their costs to patients, and we do that on a daily basis. And it would be improper for you now to impose an additional burden on health professionals to explain the likes of PMBs as are interpreted by numerous medical schemes, of which there are many and very different plans within that. It would be an impossible scenario for them to do so. The contract between a patient and their medical scheme is just that, a contract between them and their medical scheme. And on that basis, it should be imperative that the medical scheme meet that responsibility and duty.
So the doctor will explain his or her fees without reference to a PMB.
What provisions 6, 7, and 8 of the National Health Act say is that the doctor must explain to his or her patient the benefits of any particular treatment option, as well as the risk associated with that, and then the costs attributed from his perspective or her perspective as a practitioner to the patient. And on that basis, the patient is then informed from a cost perspective what he or she is facing in terms of costs from the actual provider of the service, in the same way the hospital.
But isn't that wide enough to require a doctor to explain the PMBs where they are applicable?
It depends, Judge, on what we are asking the doctor to explain.
It can't depend. It's either when it is involved, he has to explain that, or he doesn't have to explain that at all, whether it is involved or it isn't involved. So all I'm asking is, how do you explain what your costs are for this particular condition if they happen to be, if it happens to be a PMB condition without reference to it?
We see, for example...
There's a difference between who bears the primary responsibility for doing that, as opposed to how do you obtain an informed consent without reference to explaining what a PMB is, if it is an issue?
If it is an issue, it's not always an issue. Our concern primarily is that we're placing onerous obligations on doctors to go way beyond what the legislation requires from them.
What really is the problem in a doctor having to explain that, really? What is the problem? He has to explain his fees in order to get the informed consent. A step further, what's so onerous about that?
There are approximately 86 medical schemes as we sit here today. As we've heard, there are numerous different plans, different levels. The concern that we have is that doctors are now having to enter into the domain and making representations on behalf of medical schemes, where they are actually not the contracting party. They happen to be involved indirectly, but the primarily contractual relationship exists between the medical scheme and its member. And on that basis, from a legal point of view, are we expecting the doctor to enter into a domain which he's not party to in terms of a contract?
It is incidental to his function, is it not?
In some cases, yes.
Yeah.
The question I think I would pose to the panel is, what exactly are we expecting from doctors to explain from a PMB perspective? The fact that it might be a PMB condition, or are you asking them to go into what a medical scheme may be prepared to reimburse or not? I think that is a different level.
But the other question is, what is so onerous for a doctor just to tell the patient that this is governed by, it's a PMB condition, and what are the charges for this?
I don't think that would be onerous for him to say that this is a PMB, but what we're expecting the doctor then to do beyond that is now talk about how the medical scheme would reimburse. And I think that's going way beyond what the doctor can be expected in law to do.
No, I understand.
I don't believe I think our document is rather substantive, and if you have any questions, we're here to answer them.
Thank you very much. A couple of brief questions. You told us about the negotiation model that you encounter when you encounter an administrator. It's either the administrator negotiates on behalf of its schemes, or it facilitates your negotiation with the schemes that it has counts as its clients. Is this is a choice on you of the model?
No, the choice is not ours. Very often the administrator will say that they are negotiating on behalf of the following medical schemes, and we will only engage with the administrator.
And very often means always. It's either or.
Either or. One of the larger medical schemes does this. Another large medical scheme doesn't. It allows us to engage directly with the individual medical schemes it represents.
And which medical scheme negotiates on behalf of the schemes?
Discovery Health.
And the others?
Med scheme allows us to engage with the individual medical schemes.
And MMI?
We negotiate on behalf with the administrator.
With the administrator centrally on behalf of the
medical
schemes
schemes they represent, yes.
And you explained to us that you prefer to do that individually with schemes. Obviously, that allows you to have a better negotiation position.
Sure. If for example, if I maybe explain the purposes of the exemption for which we applied, we believe that it gives us countervailing power in terms to engage with the medical scheme, and it certainly has assisted us in that regard.
Yes.
As we've gone through 3 exemptions, we've gone from 70 facilities to numerous facilities that we're representing today, and new members joining us. The experiences that the members that have joined us indicate is that as standalone facilities, they just don't have the ability to engage with the likes of a single administrator representing 32% of the market. The other concern that I have is that if you have one set of rules that applies to all of those medical schemes, what is lost within our experience is, for example, we had alternative reimbursement models and fixed fee arrangements with some of those medical schemes. As they then become absorbed into a single administrator, that falls aside, and we now become bound to a single set of rules.
It's quite clear to me. Thank you. And then you said you were not here to finger point, but you will want to draw it to our attention. We already picked it up ourselves. And you would be hesitant to lodge a complaint with the Commission because the other day you have to sit around the table again with that's the position, isn't it?
Correct. The other concern that we have is that, the ability of these large medical schemes to park claims, if we don't come up with an agreement, is an ever-present concern for us. And what I mean by parking claims is we have a period of negotiation with these medical schemes, usually from September in the year going through to December. If it comes to 31st December that we've not got an agreement, there's an ever-present threat that on the 1st of January they'll park claims and we won't receive payment because there's no agreement. This impacts on cash flow, and we've managed to, in this particular year, negotiate an interim agreement to stop that from happening. But it is a present threat for us, and it's something which we're particularly concerned, particularly within the broad parameters of consolidation within the market.
Is that a form of retaliation?
We're told that it's not, but the reality is if there is no agreement, the medical scheme would park claims come 1 January, and we would have a situation whereby patients would be accessing our facilities for services, and we would bill and not be reimbursed in the absence of an agreement. It's the practical reality that we face.
Thank you. Another issue, it's on the DSPs and your problems to get to be included in DSPs that you would like to be included in. And first of all, yes, we are requiring the contracts between administrative medical schemes and facilities on DSPs, and we'll have a look at it. But I would be surprised to find very much exclusionary clauses in these contracts. Maybe we'll find them and we'll have a look. But nevertheless, you said the practice is that you are shut out, and you even alluded to the fact that it might be the case, or that in your everyday practice, you see that you are applying or you're being approached for a DSP, and then the the scheme, the owner of the DSP, of the operator DSP, has to consult either by clause or because of the economic circumstances, the context in which it operates, to consult the core hospital group. Do you have any concrete evidence on this for the panel?
Unfortunately not. As we said, it's anecdotal evidence, which we're hearing from some of our hospital managers who have attempted to access DSP agreements. The concern that we have is much broader than this. If we ask today what the criteria, what the principles, and how these DSPs are actually contracted, no one can tell you. It's just not available. It's not as if it's tendered, where we put out to tender who can then apply for these designated service provider arrangements. And on that basis, in the absence of information, what happens is, on a practical basis, you might find a single patient who presented a facility. And again, this mustn't be seen in isolation. We've got to look at the regulatory framework in which these DSP arrangements operate, where the regulations make, for example, a distinction between a voluntary use of a non-DSP and an involuntary use of a DSP. If the patient wishes to exercise their choice and access the facility, and even if the facility is prepared to meet the same cost parameters of the agreement, they prevent it from doing so. It doesn't make sense.
Your neighbor wants you to read something on the...
No.
All right.
That's all right. It just reminded me that it's not as if, for example, any one of the medical scheme administrators on an annual basis calls the market to tender for DSP arrangements. These are very often ad hoc, done at contractual level, and it's perhaps within the best interest of patients that the DSP arrangements would be on a centralized basis, whereby people are presented with criteria which they can ordinarily compete with in order to access that, as opposed to long-term agreements with a single anchor group, which is not necessarily in the interests of competition.
That point was quite clear. Thank you very much. So we would be very interested in not only anecdotal evidence but concrete evidence on this consultation of the dominant party. So if you could take that with you, if that is possible, and I'll leave further questions to my colleagues.
This information comes from your hospital managers, right?
Yes.
Based on their experience in dealing with medical aids?
Yes.
Is there any reason why they shouldn't come here and tell us that?
I don't believe they would have any objection to doing so.
Thank you for your presentation. I have two questions. One has been asked, but I just want to ask it again just in case there is an addition. You talked about your preference to negotiate with individual schemes instead of one administrator on behalf. And you mentioned that there are rules that might not be in the interest of competition. One issue that you feel negatively impacts on you is that you've had other innovations like alternative reimbursement models. So what I'd like to know is, what are the other factors?
All right, I'll give you two examples. Our engagements with a particular medical scheme, very often the medical scheme will say, well, this is our demographic profile, this is our age reality, these are the conditions which we face high cost concerns with, and then would we be prepared to enter into ARMs or fixed fee arrangements with them to meet those particular needs? And we've certainly done that with individual medical schemes. That becomes a little bit more difficult when you're dealing with a single administrator which has one set of rules for all of its medical schemes. Then we also have a scenario, for example, where an administrator might establish a criteria for access. And I'll give you an example. One of our hospitals is particularly efficient in hematology, would like to be reimbursed for hematology, has met all of its licensing requirements. Its doctors have met all of the scopes of professional practice requirements, registered with the right authorities, but the administrator requires JIPA accreditation before they will reimburse the facility. Now, JIPA accreditation is an international accreditation which requires you to get an international accreditation process. You have to have a period of time in which you submit documentation and research and evidence-based. I think the period is over a 4-year period before you would even be considered for that accreditation. And the question that we pose is, in the absence of the fact that that's not a South African legal requirement, on what basis is it a rule of an administrator which acts as a barrier to entry for that particular hospital to be able to compete in providing those particular services? So hence we highlight the fact that it's not only about negotiating with an administrator from a tariff point of view, but it might be important for you to unpack the rules of those particular administrators to see if the rules themselves are impacting on access to not only providers, but certainly patients as well. You heard, for example, from the Council for Medical Schemes, a recent case which was, it's not yet reported, Judge, but it is available. It's a Supreme Court decision involving Genesis Medical Scheme and the Council for Medical Schemes, where the rules of the medical scheme were challenged, and whether or not an opportunity was provided in the Act to mitigate concerns around Regulation 8 and payment in full were being adhered to or followed or utilized by the particular medical scheme. It's a very interesting judgment, and I think one that will provide some benefit for you to look at, in particular from paragraphs 42 to 45.
My second question is that you mentioned that some medical schemes are considering a criteria that includes both quality and price for their awarding contracts for DSPs. So I'd like to know, in your experience, when the members of NHN apply for DSPs, what, in the absence of criteria, what do they usually put in?
It's usually hit and miss. Sometimes it could be as arbitrary as, okay, you're on the DSP, and sometimes you're not on the DSP. If we, for example, understood the basis upon which we were either accepted or rejected, that would assist us in actually creating interventions or ARMs or fixed fees that would benefit the medical schemes for the purposes of DSPs, in particular around their concerns around prescribed minimum benefits. That would be a much easier process for us to engage. But at the moment, only a few medical schemes actually provide us with their criteria. And it seems that in some instances there are different approaches. Some are merely price-based. Others are interested in a whole commodity of issues based from quality, pricing, benefit to its patient or its member, and a whole lot of other criteria. If, for example, that criteria was available to every single provider to access, to make representations on and compete with, it would certainly be in the interest of the medical scheme to have as many providers on its designated service provider arrangement as possible. What I suspect is happening is that preferential pricing is granted in favor of volume. And in a way of securing volume, it's possibly restricting access to other providers as a means of calculating the amount of people that are being churned or soft churned to that particular provider who manages to get on, which I don't necessarily see from a competition point of view as being too much of a concern. I mean, obviously you would exchange volume for price, but we must also look at the unintended consequences that might have for individual patients, many of whom have presented today about their own individual experiences, and having a situation whereby it's a lot more accessible to a lot more providers.
Our job at the end of the day is to do the best for consumers. So if they do get a better price because of what you've just described, it's hard for us to not take that into account. So, I mean, it is a tough market, but we are here interested in consumers. So I want to also go back to your preference for direct negotiation with the scheme on the basis of what objectively could be described as guaranteed quality. JIPO. JIPO doesn't sound like a good acronym for quality, but anyway, we'll leave it at that, whatever it is. So if it's a marker of quality, again, that isn't a convincing reason for me. I agree with you on transparency. Transparency is always good in all markets. We don't have a problem with that. But I don't see that as a good reason if it's about a quality issue. So if you could give me a better reason, that would be good. And then I want to ask you some questions about quality and your network.
Look, referencing the JIPO accreditation, many of the hospitals go beyond Regulation 158, which is the license that's prescribed by government. Some of the hospitals will go into ICO accreditation, they'll go to international accrediting agents, and have to meet very stringent quality requirements in order to do so. And this is because they not only compete for South African patients, but sometimes compete for international patients as well. And very often the question that's asked of us by the international patient is, on what basis can we guarantee around questions of quality? The JIPO accreditation, and I don't want to decry the JIPO accreditation, because personally I think it works in the country where it does. The concern that I have is that if a hospital meets its licensing requirements, it meets its statutory requirements, and its professionals meet their scopes of professional practice requirements, and they want to provide those services as they are allowed in law to do so, how can an administrator impose a condition which is neither required in law nor in terms of professional clinical standards, and say we will not reimburse you unless you get this? Now, the amorphic argument would be we're concerned about quality, but I'm going to take that a step backwards and say if they've complied with regulation, scopes of professional practice, then that quality question has been addressed at the South African component where the service is actually delivered. So if I can explain it maybe that way for you, and I'm not decrying a medical scheme's insistence on quality. In fact, in many of the engagements with the medical schemes directly, they say to us, we account to a board of trustees, and we want to be able to guarantee to the trustees that we are actually contracting with someone who's going to provide quality. To that effect, many of our hospitals participate voluntarily in the Best Care Always initiatives, which monitors quality right down to infection control, IV infection control, and they participate at that level, and they have that information. And we engage with many medical schemes in sharing that data as well. Certainly some of the medical schemes require that as part of the contractual engagement with ourselves. And we also, as the NHN, taking the initiative of enhancing that further by doing our own quality surveys with our members, so that if there are areas which they can improve, then they really should be improving. We believe we owe that at least to our patients.
So that's what I'm interested in. What do you do, and how do you do it, and how do patients know?
Best Care Always, an initiative that's across the country. It's a voluntary process where many of the acute-based hospitals participate. It's in line with international standards around how we measure quality and how we address quality and we record quality. And that happens within the hospital itself. Where we believe as the NHN that the Best Care Always should be enhanced is that it's not only an acute-based facility within our parameter. We've got psychiatric hospitals who don't necessarily have to do the same level of infection control in theatres because they don't have theatres. So design a quality initiative which best suits those particular patients. Compliant with the provisions of the National Health Act, every one of the facilities has a complaints-based process which we inform our patients of. And we're not afraid of our patients complaining. We believe it's a pivotal part of the process. Very often it's an indicator of where something's not working within the hospital. And our medical schemes raise it with us. If the medical scheme's unhappy about readmissions, then they will raise it with us, and we will engage directly with the hospital concerned in order to address quality concerns. There are a couple of things that we have in process. We're busy at the moment, for example, of engaging CareGauge, which is a known consultant in the market, in order to address some additional quality initiatives, which we're going to be rolling out with our medical schemes going forward.
And if I'm a patient and I've got a choice of a few hospitals, and one of them is yours, how do I find out if it's got a good quality rating?
There's no uniform publication of quality indicators in South Africa, and I think that's something we would support. Some medical schemes have started to try and do that from a patient satisfaction perspective, and we've certainly participated in those medical schemes that have done so. Interestingly enough, if we look at those medical schemes that are measuring patient satisfaction, NHN hospitals score very well, proportionately so when compared to the other hospital groups. So we're particularly confident that we render an extremely good service to our patients, but we're not infallible, and there's always room for improvement. And certainly what we try and engender amongst our hospitals is that if there are complaints, listen to them, engage with your patient, even if it means the hospital manager particularly meeting directly with the patients who are complaining in order to address issues. We would encourage that too.
So, just for the record, you're in favor of having some public transparency declaration of a hospital quality, say there was a score that everyone agreed to or something, you have no problem with that?
I don't believe we would have a problem with a measurement of that nature. What we would, however, preface is that the manner in which it's calculated be methodologically sound. And we've had some initiatives in the past where there were significant methodological concerns as to how, for example, we determine basic things like patient days and readmissions, which don't necessarily result in an accurate score for those hospitals, with distinctions, for example, between hospitals that are speciality-based and usually have comorbid patients. They very often have a higher level of readmissions because of the nature of the patient. So if the scoring tool makes those distinctions and is accurate and supported with empirical evidence and sound methodology, we would have no concern with that.
And you're a coalition of the willing. Are there any conditions under which you would expel a member from your network?
As part of our exemption process, we engage with the competition authorities in terms of our membership criteria. And the membership criteria are in essence as follows, and I'm just going to paraphrase them. We're a voluntary body. If you don't want to opt into the NHN negotiating on your behalf, you're more than free to not. That doesn't mean we're going to expel you as a member, because there are other benefits that the NHN provides. But if you opt into the process, then that's the representation that we make to the medical schemes, that these are the hospitals that have opted into that process. Other criteria that we've put in place in order to create efficiencies which are in line with our exemption are, for example, we require that our members all belong to a single switching agent, which is MediCredit, and there is reason for this. MediCredit is able, for example, to populate the database with the fixed fee arrangements and the ARMs and assist our hospitals to feed that in so that it goes correctly to the medical scheme and is invoiced at that level. It also assists us in gathering the information so that when we can go to medical schemes and say, is the NHN exemption working from an exemption point of view, we can actually track utilization. So we can see where the medical schemes have started to utilize NHN facilities because of the arrangements that we have in place. So we can actually measure utilization. And on that basis, we can access that information on a national basis, which we feed into actuaries in order to assist us. In that way, we can make the distinction between utilization, which is just as a result of new members joining, and actual increases in utilization, which are as a consequence of the deals that we've negotiated with the medical schemes. And some of the medical schemes have now started sharing that information with us, where they say over a period of time, we've seen a move from some of the hospital groups into the NHN network from 8% to 16% over a 1-year period. In some cases, we've seen actual procedures where we have significant representation in terms of the procedures which are being rendered. So we're able to track that and able to engage with the medical schemes on a much more intellectually sound basis because of that.
We've had some reports of the big hospitals have an economy of scale that must benefit them, whilst they wouldn't be so big. And so, I mean, there are two pieces of information. On the one hand, they could just price you out the market. How come they can't price you out the market, in your opinion, if their economies of scale work so well? So everything's cheaper for them because they're buying, I don't know, catheters or drips or whatever it is. And then on the contrary, we've also been presented with data where your theatre costs might be less than theirs, and then one wonders why. And so do you have any comments on that?
Look, price comparisons are difficult because we don't have access to that information. This is where the medical scheme is in a much more powerful position than we are. They would have access to the comparative information. It does beg the question, however, that if the end product to the medical scheme is cheaper as provided by the NHN, why they wouldn't be represented on things like designated service providers or enhanced packages of engagement. What we are seeing, however, is that some of the medical schemes are prepared to share that information with us without obviously violating competition information from, but basically to say to us, these are the areas that we would like to address with the NHN. So we're able to then, for example, design fixed fees around those particular areas, which would be a better way of managing cost to the medical scheme, understanding that we don't have the same economies of scale. Every single one of the hospitals operates as an individual. Our exemption only speaks to price. We can't, for example, procure on a central basis. That would require an additional exemption in our mind, and certainly what our legal advisors are telling us.
Okay. Thank you. May I just ask, just to follow on a statement you made almost in passing, but specifically, how has exemption protected your members from acquisition by bigger players?
The experience that our members are reporting to us is that outside of the NHN, as standalone facilities, they're not in a position to negotiate tariffs anywhere near what we've managed to negotiate for them. And very often it's at a much lower rate because they're invariably price takers. They don't have the capacity in order to negotiate with the likes of a single administrator. Understanding that if you look at our membership, it could be a single psychiatric facility of 8 beds that's sitting in a province in Western Cape. But as a collective, we are able to go into those negotiations and say we represent the interests of 8,600 beds. It's a national network which is attractive to the medical schemes. They're more willing to engage with us on that basis. Which brings me to another area which we very often are finding with medical schemes when we challenge them on the basis that why are we not being appointed to designated service provider read. One of the excuses in the past was that we didn't have the geographic network that we currently do today. We are able to challenge them now on a like-for-like basis and say, show us your DSP network, those providers that are on the table, and we'll see if we've got a hospital in the facility which can compete geographically. And now with the fact that we have a broad network of members represented throughout the country At 8,600 beds, that's an attractive tool for a medical scheme to engage with us. Members that are outside of that are very much on their own, and the experiences that we've had with some members, for example, having left the NHN, have experienced significant cost impacts in terms of the fact that they're then treated at a private reimbursement rate, which is very often the medical schemes rate, as opposed to the negotiated tariff that we have in place as the NHN.
Okay. Yeah, your very last paragraph in your submission here, you refer to the fact that healthcare professionals have grouped together with a view to negotiating with funders. In our view, this contravenes the prohibitions contained in Section 4(1)b of the Act. How does this differ from what NHN does on behalf of its members regarding negotiations, tariff negotiations?
The simple difference is we have an exemption. And it seems inconsistent that other role players would be allowed to do so outside of an exemption. I believe if those role players were to apply to the competition authorities for an exemption, they would more than likely be granted it in the same way that we would. But it does seem inconsistent that we've got one approach with certain role players and another approach with others.
Okay.
And I think that for us is a concern.
Okay, I think it's a. I hear you when you say that's the difference, because I was battling to see how you could be critical of that, but find that it's okay on your side. Now, let's just go to the multi-scheme, what I'm calling now multi-scheme negotiations, when administrator represents a number of schemes. What is it specifically that you have a problem with regarding that?
The problems are wide in terms of the fact that if, for example, we don't manage to come to an agreement with a single medical scheme, we still have the opportunity to engage with numerous other medical schemes and come to an agreement. So the impact would not be as profound as we don't have an agreement with you, and that agreement, non-agreement, extends to 15 medical schemes, which constitute X amount of people. And then we break it down into the realities where we see a single facility that's 8 beds sitting in Western Cape, where, for example, the 60% of its members come from one of those medical schemes. So the impact can be quite dramatic in terms of a non-agreement. Whereas with the other medical schemes where we're able to negotiate on an individual basis, not only are we able to design scheme-specific alternative reimbursement models and engagements with them, but we are certainly able to mitigate the impact of a non-agreement by at least having a much bigger or much wider approach to that. So the practical impact of this, if you look at the nature of the NHN, is that you could have a scenario where one of our hospitals in one particular area has 70% of its patient profile coming from a single medical scheme, which is then represented by a single administrator where there's a non-agreement, and that could have a catastrophic effect on them.
Yeah, but what it means, what I'm hearing you say is that where you are allowed to negotiate one-on-one across schemes that have the same administrator, are you suggesting that administrators in that scenario have got absolutely no influence? Is that your experience? They have no influence purely on the basis that you're sitting in a meeting where it's one-on-one?
I can give you an example without mentioning, obviously, medical schemes, but the medical scheme says to us, this is an agreement between the NHN, the medical scheme, and our members. The administrator is here to facilitate the administration of our scheme, and whilst they might assist us with the process of gathering information in order to understand costing and utilization, the negotiation is important between us and the medical scheme. That's one approach that some of our medical scheme partners have taken. Other approaches, the medical scheme is certainly influential in that process, certainly from capturing the information on a universal basis and feeding that information into the schemes. And rightly so. It only makes for robust negotiation. And on that basis, we don't have a concern with that. What we do have a concern with is where a decision is ultimately made by an administrator, which impacts on behalf of several medical schemes, which could, as stated, have a catastrophic impact on a single facility.
But is this the same where you're talking about large schemes that negotiate for themselves, or even smaller ones that you sit and negotiate even the smaller schemes on a one-on-one basis?
We certainly negotiate with smaller schemes on a one-on-one basis.
Is there a difference in terms of percentage adjustments based on whether it's group negotiation or it's one-on-one?
What we'll find with the medical schemes where we negotiate separately, there are very often price differences. There are distinctions because, as we said, we try and adapt our agreements to the specific needs of those medical schemes. So you will find a scenario where a single administrator is assisting in the administration of numerous schemes, but will have individual agreements which will vary in many ways, and it's not only on price. Sometimes some medical schemes say what's of interest to us is a fixed fee around the 5 top cost items for us. Other medical schemes say they're not particularly interested in fixed fee arrangements, but they're looking at something else, another alternative reimbursement model. So we find a lot of engagement at that level from the schemes, which does result in differences. Where we have a single administrator representing all of its medical schemes, we don't see that distinction.
Okay, even on price. But from your submission earlier and today's presentations, the presentation, there seem to be quite a few shifts in terms of how you view the world now. Especially, let me just move on to the ARMs, where you certainly, on page 44, paragraph 137, you refer to the fact that NHN has got a limited capacity to deviate from fee-for-service, and traditionally NHN members are unable to carry risk and do not have the ability or indeed the capability to always effectively address same. You further made reference to the fact that it's one of the services I think you're rendering your members regarding the ARMs now. Has your view changed? Are you more capable of getting into alternative reimbursement models?
On the alternative reimbursement models, the difficulty we're trying to explain there is because we represent individual hospitals who don't, for example, have a single procurement model. You might find that there are significant differences in terms of how certain procedures are done, and it's difficult for us to have cross-subsidization within that, unlike the groups which would have that advantage within their economies of scale and being a single company.
But the point is you are now capable of entering into alternative
within a limited capacity, yes, and we engage directly with the medical schemes. What we try and do is those particular procedures where they're particularly relatively easy to predict, we will engage with the medical schemes in that respect. And as we sit here today with one particular medical scheme, as much as 20% of our business is under a fixed fee or ARM arrangement, and we've been asked to extend it, and we're busy looking at that at the moment.
Okay. The other area would be DSPs, but just to be clear, are you now of the view that there is space for DSPs in this sector? You may be unhappy in some parts, but you are not saying there is no place for DSPs, is that?
I think let me put it to you this way. I believe that designated service provider agreements, as envisaged within the Medical Schemes Act, are a critical component that the medical scheme can utilize in terms of those regulations to mitigate its exposure, in particular to Regulation 8 and payment in full. If they utilize that effectively, it's certainly something which is beneficial to the medical scheme and certainly beneficial to its members.
No, but extending it beyond just the PMB environment, just normal provider networks, as you can broadly refer to.
Agreed. It doesn't have to be restricted to merely the PMBs, although arguably the legislation might be a little restrictive in that regard. But certainly expanding it upon into other areas, and certainly what our engagements with the medical schemes have been pragmatic enough to do that. And with the numbers that we are able to bring to the table now, we're finding medical schemes are more attractive. This year in particular, we've seen medical schemes which haven't appointed us to DSPs now finally doing that. And in some instances, those negotiations are ongoing.
Yeah. When you say you would like to see a situation where if you match a DSP tariff, even though you're not a DSP, you want to be able to do that, right? Now, someone might say this is where you want to, your bread buttered on both sides. Why should I compete to reduce my price to get into a DSP when I can get through the back door? Because the issue is, the price is just one component of getting into DSPs, isn't it? Now, if that is allowed, don't you think that maybe what will be missed are the other administrative advantages of getting into DSPs? Whether will you still be obliged to provide quality data? Will you still be obliged to provide, or rather to be subjected to profiling? What?
I think if we look at it rather from this perspective, the instances where we've attempted to facilitate access to DSPs is very often patient-based, where the patient presents at our facility for a whole lot of reasons. Convenience, they're resident in that community, it's the closest hospital to them, their family members have difficulties in transport, and we try and facilitate that. It's not so much that we want our bread buttered both sides, but merely attempting to facilitate patient need in this particular case. As standalone facilities, we're very often embedded within the communities in which we work. It's of profound interest that we remain connected to our communities which we service. No one's saying that we would then be subject to any different criteria around quality, accountability, and a whole lot of other things that are obviously commensurate with those agreements. But if we're really concerned about affordability as its patient concern, then we don't see why those type of scenarios should be prevented. Particularly where, and we've had instances, for example, where a patient has been asked to travel 100 kilometers to a designated service provider when their hospital is 2 kilometers away. These things don't make practical sense to us, and I believe that if we had a more open system of engagement, much along the lines of the tender process, where these are the criteria, this is the quality, and this is what's important for us, everyone would have the right then to participate. And if we lose to a competitor, so be it, but at least we've had an opportunity to participate at the same time.
I think that's an important rider where you're saying as long as everybody gets a chance to bid. Okay, now regarding new entrants, as I see it, is that there is a difficulty here in the sense that, as you also referred to it as well, that the big established players, there is concentration there. Almost all submissions say that. Meaning that to try and dilute their power is important. Now, new entrants, though, when they go to look for funding, they can't get funding unless they come up with a big player. And we had that in some ways, then the license ultimately ends up with a big player anyway, which seems to defeat the purpose. Now, I would have expected, yesterday KZN said there are 76 approved licenses that are not developed yet. I would have expected that NHN fits in perfectly in supporting those new entrants. For the reason it makes sense. I mean, anyone who comes is the first hospital, so they are not big player. They are, to me, they seem to be your typical member. And of course, just you growing. But are you involved in this? Is this something that you are interested in broadening, or you also see these new entrants as potential competition?
Don't hear us incorrectly. We would encourage competition. I think that's ultimately in the interests of the public. And certainly we would not see that as something that should be restricted. We, as the NHN, obviously don't get involved in the individual licensing matters of our members. or non-members, people who wish to join us at a later stage. What we are seeing, for example, is the scenario which you allude to, where rather than acquiring or merging with existing facilities or independent facilities, some of the groups are entering into joint ventures with new entrants into the market. That does pose a challenge for us because whilst there's no share value per se, but by virtue of a joint venture, a group is concerned, and that person would obviously be precluded by virtue of our membership criteria from accessing the NHN. But if it's good, honest fashion competition, we wouldn't necessarily oppose that.
Okay. Now, is there, you made reference to the fact that profitability is not an appropriate tool to analyze competition. Do you still stand by that? Is that?
The concern that we have, and this is something which we've observed through the process of this engagement, is that very often anecdotal evidence such as super profiteering is made against hospitals, but we believe that the panel is more than capable of making those determinations. Profitability, a component of consideration, but certainly not the only. We would have to look at a wide range of factors, okay. And then not to mix us in with the likes of the groups and see the individual hospitals for the entities that they are.
Okay. Lastly, I mean, in your submission, you spent quite a bit of time explaining why you're different from the big three, almost in a sense that you are disadvantaged. Today, it seems like you're coming round to what I always thought was the issue, where you say, maybe this offers a competitive advantage. I don't know if I'm hearing you right, but why would you see that as entirely negative, that you're different? You say you're cheaper, you've got the kind of facilities that they don't have really in big numbers, your psychiatry clinics, your day clinics, you've got an exemption behind you. Why should the panel see you as the orphan here?
I don't believe we are the orphan. We certainly stand tall on our shoulders, and we believe that where we are today is as a consequence of having successfully applied for an exemption from the competition authorities. It wasn't always this way. The very first exemption that we had, we only represented a small number of facilities with a much limited demographic profile, much limited demographic profile. As we've worked towards engaging more constructively with our medical schemes, we've seen our membership grow. We've seen our members be able to compete along the lines of the groups, offer alternatives to the medical schemes, to the point where we believe that we are a viable alternative to the established groups, and we would like to see that maintained. And we believe it's because of the parity afforded to us through the competition exemption that's been afforded to us. If it hadn't been for that, we would not be in the position that we are today. And I think the individual hospitals would be in a much worse position than they are now.
Okay. But then you still feel that within the hospital association, your interests are still aligned with those of the big three?
Hospital association, you mean HASA?
HASA, yeah.
Look, within HASA, we obviously align ourselves to the principles of that organisation in terms of its larger engagement on things such as regulation. And on that basis, we certainly participate at that level, but under no circumstances do we discuss price. That's something which we only happens within the NHN.
Okay. Thank you very much. Thanks.
Thank you.
I think for the record, you must understand that our task is just not limited to furthering the objectives or coming to the assistance of the consumer, but it's much broader than that. To understand that. It is to consider, among other things, whether there are any factors that tend to undermine competition within the private healthcare sector, which is where you're involved. Do you understand?
Yes, Judge, we do.
Do you have practitioners who practice from facilities of your members?
You mean health professionals?
Yeah. Specialists?
Certainly.
Yeah. Most specialists? Do you have a number of those?
Depending on the facility type,
Yeah.
As we said, we've got day clinics, we've got subacute facilities. Very often within a subacute facility, it's a multidisciplinary approach. Acute-based hospitals, we have specialist acute-based hospitals, so a wide variety within our broad membership.
We were told that there are, the few specialists and there's intense competition for them. Is that right?
They are a scarce commodity, so I'm sure that there would be intense competition amongst the specialists, yes.
Yes. Now, do you know how your members attract specialists to your facilities?
No, Judge. From the NHN's perspective, that's not something which we involve ourselves in from the operational perspectives of our members. But we would expect our members to be compliant with the ethical rules of the Health Professions Council.
No, I understand those aspects, but all I wanted to know is whether, do you know how they attract specialists?
That's not something that the NHN involves itself in.
Do you know whether they offer them any incentives?
Not as the NHN, no.
Yeah. When consumers go to your, well, I suppose you don't know this either because it's an operational matter. Well, let me ask the question anyway. Do you know whether consumers who go to facilities of your members are told what the tariffs are?
I'm not too sure I understand the question. In terms of the cost, yes, we would certainly explain that to the patients. So it's not something that they're unaware of. Certainly, from a contractual perspective, our members would inform them of those costs.
So what would a consumer be told, for example?
Again, really going into the operational side of
So you wouldn't know what
members,
they're told?
We wouldn't know. We would know from a legislative point of view that they are obliged to inform.
But you don't have any personal knowledge of that?
Certainly not.
Whether they may well not be told, for all you know.
I'd be surprised if that was the case.
Yes. And did you say that you assess the quality of the services that your members provide?
Not as the NHN, we don't act as a quality assessor, but what we are interested in doing together with our medical scheme partners is together with them address issues of quality. And we have certainly been doing that with some of our medical schemes. And individual hospitals...
Do you have any interest in ensuring that your members offer quality services, quality health services?
Certainly, as a board, we've discussed this, and we believe that it's imperative that quality be a consideration.
What steps have you taken or do you take to ensure that they provide quality healthcare services?
Certainly, there's a variety of initiatives that we've undertaken. Certainly, engaging with our medical schemes around best practice. Medical schemes have the freedom to engage with us around their own quality concerns, and we address that directly with them.
I mean, from a patient standpoint.
What we're doing at the moment, and this is in early stages, Judge, but we are initiating on a survey amongst our members through CareGauge, where we've put together a comprehensive survey on quality, which we're rolling out to our members in order to address issues such as that. What medical schemes have indicated to us, and this is somewhere where we've probably been lacking in the past as the NHN, and largely because we've not had the information available to us, is we know for many years, as part of the negotiations, that the groups for example, share that information with medical schemes on a regular basis. The difficulty for us, being the separate entities, is we've not been able to collate that information in a way that we can share that. But we are initiating processes where we can do so in order to engage on that level.
And when did you start that?
We've certainly started it with our single switching agent in terms of gathering that information, and the care gauge survey is rolling out as we speak.
When did you start that process?
Beginning of this year.
I see. So prior to
that, individual hospitals would voluntarily engage in the best care always process, and we've been quite participatory in that process together with a whole lot of other role players.
And do you know whether your members publish that information?
Also, for interest's sake, Judge, some of our hospitals train nurses, so quality is a critical component of the services that we render.
Yes, I understand that. But I think what I'm trying to find out is the quality of healthcare services, whether is it in your interest to make sure that your members perform the services to a standard that's acceptable. And
simply yes.
Yes, and you only started that this year.
Certainly, in terms of the survey, we've started this year. Yes.
Yeah. Okay. And the purpose of the survey is to
address
get satisfaction from customers.
More importantly, to identify those of our members which could improve their recording of quality on particular levels. If they need assistance in that regard, then to direct them in the area where we're certainly willing to share, for example, the care gauge survey with yourselves if you would be interested.
But what about with consumers? Would you share that information with consumers and say your member A, for example, has not been performing up to standard?
Look, I don't see why we would have a problem saying that a particular member is not up to standard.
I mean, sharing that information, generally with consumers.
At the end of the day, consumers are our clients, and I think it would be in the best interest to do so. I don't think we'd be afraid to do so, though, as long as it was fair.
I understand. Now, you've made much of Regulation 158 and the 1977 Act. It's not clear to me why you keep on referring to that regulation, and that regulation must be adapted or amended. We've got the National Healthcare Act. Is that right? Is that right?
Correct.
Now, that statute calls for regulations which will deal with with the implementation of the provisions of that act, in particular as they relate to section 30 to 40.
Correct.
Yeah. Shouldn't the focus then be, when those regulations are being formulated, the kind of concerns that you have should address those?
Certainly, Judge, and I mean, from the NHN's perspective, when it ever comes to the publication of regulations and commentary where we have a direct interest in, we certainly participate in that process. The difficulty that we have, and I'm sorry, I didn't want to interrupt.
Sure.
The difficulty that we have is that some provinces are now attempting to promulgate their own licensing criteria, and the concern that we have is that we're now going to have a duplication of those services when it's certainly evident to us that the National Health Act is looking to promulgate that law and pass regulation. Not that we're opposed to licensing and regulation, but we're concerned that we're creating inefficiencies within the system.
I think those who have done so have told us that they're doing so because in the interim there are no regulations, which is precisely why the bringing into operation of those provisions of the Act was set aside. So until such time that there is a regulatory framework in place, something needs to be done. And to the extent that this regulation remains in force, that's what they're doing. Others take the view that they don't have the power to amend the regulations. So you have that. I can understand your frustration because some provinces take the view that they have the power to amend those regulations. Others take the view that they don't have the power to do so.
I think, Judge, and I say this from a legal perspective, the concern is obviously you can't have a lacuna where there is nothing. In the absence of nothing, then the old law certainly applies. The difficulty that we have, as we've evidenced in our presentation, is that we have significant differences of opinion, or more accurately interpretation, on how Regulation 158 is enforced. I'll give you a practical example. In Gauteng, if you want to establish a mental health facility, you comply with Regulation 158 and there is no concern, provided you go through that process. In KwaZulu-Natal, one of the criteria that have now been established is that you can only have a single-story facility. Now, that criteria doesn't exist within Regulation 158. The counter that we have is that they're interested in protecting patients from committing suicide and not throwing themselves, obviously, off buildings. But those concerns have already been addressed in Regulation 158, and why would you restrict, for example, a building to a single floor where it poses additional flow concerns in terms of where you control access and that to patients? So the concern is that there are added criteria which don't necessarily exist in law, and that is our concern.
I'm aware of those difficulties, but I thought that what your recommendation would be is that the process of framing the regulations under the new Act would be expedited, rather than to complain about going into the future, because that's all that's required. Those regulations are outdated. And secondly, they were framed under a statute which doesn't take into consideration the fundamental values that now underline our constitutional democracy.
Judge, we're happy to support you in that.
So those are all the reasons why the process of the new regulations should be expedited. I can understand that. But what I don't understand is the recommendation that says we have to amend the Regulation 158.
Judge, we certainly support you, and we would echo your call for an expedient process in that regards. But at the same time, we would ask for certainty in the regulatory environment. Where we stand at the moment, depending on the provinces, we have no certainty as to how to approach the current law, and I think that's not within the interests of the sector.
Yes, I understand. Is there anything else that you would like?
Just to thank you for listening to us, and hope you have a pleasant evening. It's late.
Thank you anyway for your patience and for your willingness to stay until this late.
Thank you very much, Judge.
And also thank you for coming to share with us some of your concern, in particular as they relate to the regulatory framework.
Thank you very much.
Yes, thank you. Okay. I understand that tomorrow we will start at 8:30, and the proceedings will take place in Auditorium 2. Thank you.